Hello and welcome to Trial TV Live. I am the Squeegee of Justice. Thank you so much for joining us today as we are continuing our pre-trial prep of the upcoming murder trial of Charles Jones, also known as Julio Foolio. Appreciate you guys joining us. Let me just do a quick mic check, make sure my audio is sounding okay. Hello and welcome to Trial TV Live. Sounds good there. So get settled in, get comfortable. We are on day 2 of our pre-trial prep. We did some history deep diving of KTA and ATK. We looked at Charles Jones's history more in depth yesterday, and we started with some pretrial hearings. So today we're going to continue with that. So again, get comfortable, get settled in, and let's get started.
We the best, no contest. My clique is the best. We the best. There ain't no one like cause of you dumb or you crazy. There's no way, G. Me and my clique, we handling biz while you and your clique just act fugazi. You couldn't persuade me to give a damn, it just don't faze me. I got my Xbox, she can't play me. Money in a text box, I get paid. We the best. We the best, no contest. My clique is the best. We the best. We the best, no contest. My clique is the best. We the best. We the best. There ain't no rest. For the wicked I'm bad and I'm blessed. Put it to the test. For the rest there ain't no contest. So what's next? Got me leveling up, I'm obsessed. I bring the fire like I'm possessed. My personnel and my clique is the best. There ain't no contest. There ain't no one like cause of you dumb or you crazy. There's no way, G. Me and my clique, we handling biz while you and your clique just act fugazi. You couldn't persuade me to give a damn, it just don't faze me. I got my Xbox, she can't play me. Money in a text box, I get paid. We the best. We the best, best. We the best, no contest. My clique is the best. We the best. We the best, best. We the best, no contest. My clique is the best. We the best. We the best, best. We the best, no contest. My clique is the best. We the best. We the best, best. We the best, no contest. My clique is the best. We the best.
All right, welcome in everybody. Hope everybody's having a good day today. It is April 17th, 2026. We are in day 2 of our pretrial hearings as we get prepared for the shooting murder trial of Charles Jones. We have Charles Jones, also known as Julio Foolio. He is the victim. He was 26 years old when he was shot June 23rd of 2024, just a few days after his birthday. He was in Tampa celebrating his birthday. The defendants are Davion Murphy and his cousin Rashad Murphy. Then we have Isaiah Chance, who is the boyfriend of Alicia Andrews. And then we have Sean Gaithright. Alicia Andrews was convicted Halloween night. Jury came back and found her guilty of last year, 2025. Her defense team is contesting it with the judge. They actually got Judge Sisko taken off of the sentencing. So there's a new judge that will be doing her sentencing. But May 12th, she will actually find out if she will get a new trial. So she's been convicted, but she may get a new trial. So hold on to your seats for that. That may change everything. So let me welcome in everybody before we get started. Camilla, 10 months. Thank you for all the hard work. Space Streams Rock. Thank you, Camilla. Great to see you. Allison and Jane, thank you for joining us today. Debbie, good to see you. Shirley and Lori, hello, hello. Hey, Anthony, how are you? Good to see you. It's going to be 90 in North Georgia. Ooh, yeah, I think we're supposed to hit 90 as well. Allison, good morning. And Kimbers, good to see you. See who else is with us. I know a lot of folks are coming in, so let me just snap. There you are. Good morning to you. Happy Friday to everybody. Joy, good to see you. Richard in the kitchen. It's going to be a high of 50 for you on Saturday. That's a big drop off, right? Wow. Going from 90 to 50 or 80 to 50. Green-eyed cat, good morning, good morning. Welcome in. All right, let's see. I know a lot of you came in later, so let me scroll through that. Debbie saying good morning. Good morning to you. Courtney Scott, hello, good morning to you. Thank you for joining us. Hey, Mel, happy Friday to you. Good to see you, Jackie. Good morning, Stella. Thank you for joining us. Miss Bree, good to see you. All right, let's see. I think I've gotten everybody. Coops, good to see you. Going to be lurking and working. Sounds good. Joanne Jedi Platypus, happy Friday to you. Sherry, good morning. You're going to be in and out. Sounds good. Have a good day, Sherry. I hope all is well with you and your family. Iowa Backyard, we are dog foster parents. Huck is a smaller shepherd mix, beautiful and energetic. Awesome. Can't wait to see that. Are you going to post that? Are you going to share that on your channel? If so, we'll definitely go check that out. All right, you guys. Be sure to hit the like button as you're coming in. We appreciate that. Show YouTube that you are not a robot, that you are a human being. And show us that you are a human as well. If you can hear my voice, please take a minute to hit the like button. And let's go through. Okay, so the charges are first degree premeditated, which is capital. So the four guys are on up for the DP. Alicia Andrews was not. We are waiting her sentencing, which is supposed to be in December, but she may get a new trial. We'll find that out in May, on May 18th. But the guys are all up. Now we're focusing in on Yungeen Murphy because we have people representing him: Florida PI Sam, Nick Sonardi, and Scott Sonardi. So we will hopefully be talking to them. I don't know if we'll be able to talk to them throughout the trial, but if you're not familiar with Florida PI Sam, she has done great work on her channel. So definitely go give her a sub and check out her work. She actually did a really cool video involving new technology, and it was a while ago, and I watched it, but I'm teasing it right now, so I'll rewatch it and I'll let you guys know more on Monday. So this is a DP case, which is why they have multiple lawyers, because you have to have a DP qualified lawyer as well as just a regular lawyer. So count one is first degree premeditated. Then you've got count two, which is conspiracy to commit first degree. And remember, there were people that were shot in the cars that were wounded, but were not. They were just wounded and injured. I don't have my notes. Oh wait, I do have my notes in front of me. All right, because there's a lot of players involved. So Xavier Edwards, he was the driver in Charles's car. We have Gino Norris. He was also in Charles's car. And Alicia Andrews was convicted of manslaughter. So that's what she's contesting, and might possibly get a new trial based on the judge and how Judge Sisko was acting to the defense. So then we have counts 3 through 5, which was attempted first degree. We have Judge Michelle Sisko, who tried Alicia's, was on the bench for Alicia's trial, and that's the one where the defense said she was a little prejudiced. And that's also where they said that they went to like Law and Crime or Court TV, and they were looking at their chat, and their chat was saying, yeah, she's really biased. She's really biased. So then we have the state. We have Michelle Doherty and Anna Ismer. You guys may recognize her from the Sunny Bell trial. We covered Sunny Bell, and that was also out of Tampa. So we saw Anna there. And then we have the defense. So we have Nick Sonardi and Scotty Sonardi for Davion. Now, Nick, you'll remember Nick was also, he was representing defendants in Sunny Bell. Rashad Murphy is represented by Daniel Hernandez and Brian Gonzalez. Both of them were representing defendants in Sunny Bell. So you might remember, or you might recognize those guys from there. We have Sean Gaithright. He is being represented by Jason Wise and Jenna Finkelstein. Then we have Isaiah Chance, who again is the boyfriend of Alicia Andrews. He's represented by Richard Watts, Christopher Bolt, Ida Nemotin, and Thomas Paleo. So June 23rd, 2024, Jacksonville rapper Charles Jones, a.k.a. Julio Foolio, was fatally shot in an ambush outside a hotel near the University of South Florida in Tampa while celebrating his 26th birthday. Tampa police and the FBI allege that the defendants traveled from Jacksonville to Tampa specifically to track and target Jones. Surveillance footage and cell tower data reportedly placed the defendants at multiple locations where Jones was spotted throughout the night, culminating in the shooting at approximately 4:40. And again, excuse me, if you want to watch more of that, go back and check out our history. We did a backstory of Charles yesterday, leading up to the shooting. He posted on his Instagram. They got kicked out of a Airbnb, and that's why he went to go find a hotel, because otherwise he would have been at his Airbnb. Now, investigators state that the three shooters opened fire on two vehicles in the hotel parking lot. Jones was struck and pronounced dead at the scene. 3 other individuals were wounded but survived. That would be Xavier Edwards, Gino Norris, and who was the third one that got shot? I guess it would be Tiafa McCrae, even though that says she's a witness. Oh, no. Okay. Oh, Robert Howard. Did he get shot too? I know Xavier and Gino got shot. I have to confirm all of this. All right, I know I've got 2 of them. All right, I'll find out for sure. All the defendants face the DP if found guilty. The prosecutor contends the attack was part of an ongoing and violent feud between rival Jacksonville gangs. That would be ATK, or Ace's Top Killers, and KTA, or Kill Them All, which is Charles Jones's group. All right, hey, Hell Rider, how are you? Good to see you. Pretty chick. Good to see you. Welcome in. I think I got all the newbies coming in. Allison, good to see you. Holly, good to see you. Thank you for joining us. Bama Green Eyes, good to see you. All right. All right, let's get started. This is going to be a long day. This is going to be about a nine-hour stream because we have a lot to show. So let's get to it. So we're going to start off today. Again, we have quite a lot to show you guys. So we're going to start off today. This is from August 8th of 2024. Now let me just post this here. Let's see, where did that go? Okay. So this is a hearing. All right, so this is a hearing from August 26th, 2024. So this is an arraignment. So this starts with Alicia, who's seated there. Then we have Isaiah and Sean. And again, Isaiah is her boyfriend.
Remain seated. Come to order. Court is now in session.
All right, good morning, everyone. Have a seat. All right, are we anticipating anyone appearing via Zoom? Okay, all right, very good. All right, all right, and if everyone could identify themselves for the record, starting with the state.
Good morning, Your Honor. Anna Ismer for the state.
Scott Warren for the state.
Okay, and then is Alicia Andrews present?
Good morning, Maria Junker on behalf of Ms. Andrews. She is present and to my right.
Okay, very good. Isaiah Chance.
Good morning, Your Honor. Justin Treatise on behalf of Mr. Chance, who is present.
And I'm sorry, tell me your last name.
Treatise.
Treatise?
Treatise, yes, Your Honor. Sorry.
How do you spell that?
Petredis.
Okay, thank you. All right, and Mr. Chance is where? Okay, good morning. And then Sean Gathright.
Good morning, Your Honor. Attorney Michelle Rayner on behalf of Mr. Gathright. He's present, and then Bob Shaw.
Okay, and are you Mr. Gathright? Okay, good morning. All right, so we're here for arraignment, and have you all entered written notices already?
Yes, Your Honor.
Okay, very good. So I guess the question is, at this point, do you know if you're waiving speedy trial or not? you can remain seated. You're fine. You don't have to keep popping up and down.
Yes, Your Honor. Once again, for the record, Attorney Michelle Ringer, on behalf of Mr. Gathray, I, at this point, will be waiving speedy trial on behalf of my client.
Okay. And
On behalf of Ms. Andrews, I'll stand just because the podium's in my way. We yet have not made a decision. We would like to review discovery and discuss that with Ms. Andrews prior to making that decision.
okay. And Mr. Petraeus?
Yes, Your Honor, we will waive speedy trial on behalf of Mr. Chance.
Okay. And then there is a fourth co-defendant that is currently incarcerated up in Duval County. Is that correct?
That's correct, Your Honor.
And what's the status with that defendant?
The defendant, Mr. Murphy, had pending charges in Duval County. Those charges have since resolved, and he should be transported to Hillsborough shortly.
Okay. Do we know when?
We do not have an anticipated date of transportation.
Okay, and so has he been arrested on the outstanding, I'm assuming there was an outstanding warrant from Hillsborough?
The most recent outstanding case when the indictment was filed was executed.
Okay, so Speedy's running for him?
Yes, Your Honor.
Okay, all right, so have you all, so you don't know yet exactly when he's being transported back?
We do not, Your Honor.
Okay, do you know what his next court date is in Duval County?
As of Friday, the pending charges he had in Duval County had been no filed, so we anticipate that it will be shortly within the next few weeks.
Okay. So, when does Speedy run for those that have not yet waived?
For Ms. Andrews, February 7th, Your Honor.
Okay.
And for Rashad Murphy, it would be, it should be in February as well. We would have to check the date.
But we're looking at
exactly,
February
but we're also looking at February.
Okay. So, Ms. Dunker, I'll give you a couple weeks to get whatever discovery you can get, but then I need to know whether or not you're waiving Speedy.
I understand.
Okay. So, I'm going to set a status for the 3 co-defendants that are here. Are you available September the 5th? You all available?
Yeah, Your Honor, what time?
Whatever time works. You tell me.
The only issue is that, I can probably do like a 9 a.m. because I'm going to be coming from Pinellas County.
Sure.
That works for me, Mr. Petraeus.
I have a 9 o'clock Zoom hearing, unfortunately. Yeah, on the 5th.
How long, what type of hearing is it?
It's just a status check and an injunction case from Judge Baroni, so I don't anticipate it long, but it should start right at 9. I think we're the only.
Can we do 9:30 here? 9:30 here?
That's fine.
Okay, so we're going to set the co-defendants that are present here today for status at 9:30, and we will set the arraignment for Mr. Murphy on September the 5th at 9:30, and assume he's going to be here. If there's, Stan, I need you to follow up on that to make sure he's being transported. If you need a writ or anything from me, you need to let me know, but he needs to be here by that date.
Yes, Your Honor.
Okay? All right. Anything further from anybody? Yes.
Yes, Your Honor. I just wanted to let the court, make the court aware, and also the state as well. As the court may know, I am an elected state representative, and so I know that there's going to be chunks in time where I'm constitutionally unavailable.
Sure.
So I'm going to, we don't have some of those dates. We have the session dates, of course, but committee weeks, we don't really have those nailed down. As soon as I get those, I will send a notice of unavailability pursuant to the statute, but I just wanted to kind of make the court aware of that, so and also the parties, so that we know.
Sure, and I appreciate that. And really, the main driver of this is going to be whether or not the 2 outstanding co-defendants that have not yet waived Speedy, whether or not they're going to waive Speedy. So that will be the driving force. But we'll know how things are looking by the time I see you guys back here on September the 5th. And hopefully, Ms. Rayner, your schedule is fleshed out a little bit more so you can give me some guidance as far as your availability for trial, should we have to set it before Speedy files.
Thank you.
All right, very good. Anybody else need anything? Okay, very good. See you all then. Thank you.
Thank you, Your Honor.
Court's adjourned.
right, so that was their arraignment. That was from August 26th of 2024. So this was just a few months after the shooting. So now we're going to go to. Remember, they were talking about the fifth member, right? Let's see. No, there's two. I'm sorry. There's three here. It's the fourth one. The fourth one they were talking about. They were mentioning Rashad. So we'll go over to Rashad's. Just kind of hang in here for a second. All right, so now we're going to go over to Rashad's, this is probably his arraignment. Let's see what this is about.
Si decide hablar, se requiere que
All right, now this is Rashad's, probably his arraignment. I'm guessing this is his arraignment as well. So this is Rashad Murphy's arraignment. And this is from all right, this is going to be from August 29th of 2024.
responda tanto mis preguntas como las de la Fiscalía, el abogado de oficio y cualquier otro abogado que represente a las partes.
Thank you. The first case that I have is page 108, Rashad Murphy.
Present, FRJ.
Good afternoon. For the defense, please.
Donna Perry on behalf of the Public Defender's Office.
Thank you, Ms. Perry. All right, Mr. Murphy, you are charged with one count of premeditated murder in the first degree with the discharge of a firearm, one count of murder in the first degree premeditated, and 3 counts of attempted murder in the first degree. Ms. Masseri.
Yes, Your Honor. First, I would like to note that according to the indictment, count 2 is a murder in the first degree under a conspiracy theory.
Okay.
So that just lowers it from a capital offense to a life felony.
Okay.
And now, as to each count, the state has filed a motion for pretrial detention. I ask for that motion to be set on Tuesday. Yes, on Tuesday morning.
Ms. Perry.
That's fine.
All right. Mr. Murphy, the state has filed a motion for pretrial detention against you on all 5 of the charges in the indictment. That motion is going to be heard on Tuesday, September the 3rd. September the 3rd at 10 a.m. in front of Judge Michelle Cisco. That will be Trial Division 1 in Courtroom 10. At that time, we will dispose of the motion. If any part or all the motion is denied, we'll set bail and any conditions of release on the charges against you. Ms. Perry, anything on scheduling or anything else that you need to let me know about?
No, thank you, Your Honor.
Appreciate your time.
Thank you.
Page 93, Rasul Hakim.
Present, FRJ.
Mr. Hakim, you are charged with, I'm sorry, for the defense, please.
Your Honor, Jennifer Strofe on behalf of Mr. Hakim.
Thank you, Ms. Strofe. Sir, you're charged with 1 count of attempted murder in the second degree with a firearm causing great bodily harm, another count of attempted murder in the second degree with a firearm discharge, and 1 count of shooting at, within, or into a vehicle. Ms. Masseri.
Yes, Your Honor. The state has filed a motion for pretrial detention as to counts 1.
All right, I totally missed all of that. I blinked and it was over. All right, what's this now? Okay, so we saw that already. All right. I thought that was going to last longer. That lasted like all of 2 seconds. All right. All right, let's go to September now.
Defendants are present.
All right, so this is from September 18th. Okay, let's check this out.
Defendants are present as well as their counsel and the state. So I believe everyone has waived speedy trial. Is that correct?
The exception of Miss Andrews. I think that is the only one who yet to get a waiver from.
Okay. All right, Ms. Hurdle.
Yes, Your Honor. At this time, we will not be waiving speedy waiver, right, or speedy trial.
Okay, so that's definitely going to speed things up, everybody.
Oh. Calculated, I think, June 18th of 2025 is what I'm looking for.
Okay. So at this point, and I did look because I know Miss Rayner, and I do apologize. I believe you're in the Florida legislature, correct?
I am, Your Honor, and I'm actually constitutionally, I'm not even available pursuant to the Florida statute 11.11. And so that just maybe puts me in a position where I may have to move to sever because I'm constitutionally unavailable.
Well, let's see. The legislature is in session for 2025, March 4th through May 2nd.
But I'm in committee weeks, though, as well. And so the statute contemplates also committee weeks as well.
And so it looks like, and I don't know, because I looked this up, I don't know, I'm sorry, in the House or Senate?
In the House, Your Honor.
Okay, and one has January 13th through the 17th, and the other has January 21 through 24. So which one is yours?
So those runs, so we will be in committee meeting together at the same time. So the January, and I just wrote these dates down, so. Apologize.
Okay.
I'm pulling the lights. So the week of January 13th, the week of January 21st, the week of February 3rd, and the week of February 17th, I will be in committee those weeks. Also, the week of December 2nd, I will be in committee. Legislative session starts March 4th. Once again, I will be unavailable. I think based on the representation by Ms. Hurdle and our client, she is certainly well within her right now to waive that. I just will have to have a hearing on.
Okay.
It's feasible to separate.
So, then we'd have to get this to trial before January 13th, right?
Yes.
Okay. So, week of January 6th.
Your Honor, may I be heard?
Yes.
Your Honor, Ryan Gonzalez on behalf of Rashad Murphy. Judge, not speaking for any other counsel, certainly for myself on behalf of Mr. Murphy. As the court knows, he's charged with first-degree murder. We have not received a notice yet, but we potentially contemplate that there may be a notice filed by the state seeking death. As the court is aware, this is a 5-defendant first-degree murder that encompasses dual jurisdictions, both Jacksonville and Tampa. Although I haven't looked at the state's discovery notice, because I just received it a day or two ago, inclusive of the in excess of 300-page police report, as well as what I anticipate to be dozens of listed witnesses, I anticipate, as it relates to first phase, having to engage multiple experts inclusive of cell phone and social media.
Well, listen, and I don't mean to cut you off, but if that's accurate, that the state is considering the death penalty against your client, is that accurate, first of all?
Judge, it is accurate. A final decision has not been made. It is going to be reviewed within the next 2 weeks, Judge.
Okay. So that
not just his client, but there are others as well.
Inclusive of my client as well, Your Honor. I would also adopt most Mr. Gonzalez's argument, but I would defer to him.
And you guys can remain seated when you're talking to me, unless you need to stand up to see me. That's the only reason why. Okay. Okay. So, and then, Mr. Pretrial, what is your position on being ready to go to trial by January 6th?
I agree, Judge. I don't know how possible on the case of this 92 if you're ready to go January with
Well-
these witnesses.
Here's the other thing. This is the deal. Now, I'm not going to give you all, if one defendant decides they don't want to waive speedy trial, that's fine. It's absolutely right. However, we're not going to have witnesses being deposed and redeposed and brought back on anyone else's schedule. So, discovery will have to be expedited, and you guys are just going to have to be ready to go. So that's just the way it is. Okay. And then if something occurs and you've already deposed a witness and a new issue has arisen and you want to go back and talk to the witness about something different that wasn't already covered, then great, we can talk about it. Maybe the state would stipulate. But that is going to put a time crunch on discovery. Okay, Ms. Hurdle?
Yes, Your Honor. Also, I will be probably speaking with the other defense counsel on this as pertains to our position with wanting to move forward with the severance. So that may be coming.
Judge, there's not a thing that Ms. Hurdle would tell me in any type of conversation that would put me in a position to acquiesce to a speedy trial. In fact, having done this for an extremely long period of time, I would not risk Mr. Murphy's life on trying this case in a speedy trial capacity. I would withdraw for that.
No. And Mr. Gonzalez, listen, if the state seeks death, that's a whole different ballgame. Okay? So I'm not at all would try to force you into trial under those circumstances. So this is the first time I've heard that the death penalty was even being considered for any of these defendants.
And Your Honor, with all due respect, all of our clients have different positions in this case. As we know, there's several different co-defendants.
Sure.
All of us are speaking on behalf of our own clients' interests and based on their position in the case.
What I'm trying to stress to you all is because one of the defendants, Miss Andrews, because she's not waiving speedy trial, that means if there's going to be discovery, it's got to get going immediately. And what I'm trying to stress is that all of the other co-defendants' attorneys are going to be noticed when these depositions are occurring, and I'm not going to allow several bites at the apple for these witnesses. So,
and Your Honor, and understanding that, but I haven't even received the discovery. I know the state, I emailed out the first portion, which is a police report, yesterday of 300 pages. We just received that yesterday. I went to my old law firm. So I understand the court's position of us being ready, but we haven't even had the opportunity to review what the state has initially given us. Obviously, there's going to be copious discovery. And I do echo Mr. Gonzalez's point, whether, the state is seeking death or whether it is life, my client's life is on the line. And I would literally be doing him a disservice. I mean, to try this by January 13th.
Wait, guys, I guess I'm not making myself clear here. Okay. I'm not going to make the other three co-defendants go to trial in January. What I am saying is that I'm assuming, Miss Hurdle, are you going to participate in discovery?
Absolutely, Your Honor.
Okay, so I'm assuming there will be discovery depositions that you're going to schedule?
Absolutely, Your Honor.
Okay, and so then those dates need to be coordinated with the other three co-counsel. That's what I'm saying to you, apparently not clearly enough. What I'm saying is you guys are going to have the other three, Ms. Rayner, Mr. Petratus, Mr. Gonzalez, you all are going to have to be ready to go on starting to participate in discovery immediately. That's what I'm saying. Okay?
Judge, one more thing for the record.
Sure.
If you don't mind. I tried the State versus Gillespie in front of Judge Heiser starting October 28th or 29th, whatever that Monday is, for a week and a half. I'm going to be in preparation for that trial over the next 3 or 4 weeks. So I want, obviously, the court to know that my availability for depositions, and certainly I can try my best to be available when I can. I don't even know that I can be prepared to take a deposition without having read a police report. So to the extent that I can make myself available, I will. But I can certainly suggest to the court that I'm not willing to have other counsel depose critical witnesses in this case without my availability. and then have to rely on that questioning without the opportunity to do it myself. So again, for the record, I just want to be clear that if it comes to the point where participation in discovery for me over the next 60 days, so 45 days, is not capable, I probably will be asking the court to allow me to withdraw because I am not going to take that ultimate responsibility as it relates to Mr. Murphy.
So, you all can start taking depositions in November and December, correct? Can you not be ready in November and December to at least start taking depositions?
Potentially in the middle of November, Judge, I would think, to the best of my ability. Again, I'd have to advise the court if I didn't think I was really ready to begin those episodes.
Of course. But you guys know who, for example, the lead detective, there are certain witnesses that you know are going to have really the bulk of the discoverable evidence. And I would encourage the state to begin coordinating dates in November or December for these depositions to start occurring. So, and what I'm going to ask when we're concluded here today is that you all stay behind, you start looking at your calendars, and you start setting aside dates in November and December. Just close them out for discovery depositions, all right? And of course, if anything arises, if there's any issue, if the state does intend to seek the death penalty, I would never, ever, for the integrity of the fairness to the defendants, the state, I would never, ever put an attorney in a position to where they couldn't be prepared or effective. I would never do that. But we do have a situation where we've got one defendant who's not waiving speedy trial. The other three have. And as I've indicated, to the extent we can, I want to avoid duplicate discovery depositions occurring. So it seems like November and December, there should be wiggle room for you all to be able just to start setting dates aside for depositions. By then, you should have all of the reports. If you don't have all of the reports by November 1st, then I need to hear about that before then. And I'll take action to make sure that you do. So, yes.
Your Honor, if I may, yes, when I think the conversation with the state yesterday, they did advise me that they pretty much think that we'll have everything for the next week or two.
Is that correct?
Judge, not everything, because there are reports from outside agencies, but I've talked to the main case detective. There is a lot of evidence that is going to be digitally downloaded that he is downloading now that may take a day or two to download all of it. Which will be brought over to me, and I can make sure and ensure that once I get it downloaded, that we're going to figure out a way how to get it sent to all defense counsel. I do know that all of the report that I have thus far has already gone to them, with the exception of Ms. Rayner, because I believe I had the wrong email address, and my secretary will certainly get that to her today. When I was going through the police report, I noticed that there are still supplements that are outstanding. So I'm definitely reaching out to the detectives to try to get all of that in. But I also know that there are outside agencies, including Jacksonville, Georgia, law enforcement authorities, that I have to get police reports for that as well. So whether or not that will be within the next 2 weeks, I'm certainly going to work my hardest to do that. But I have to wait for some of these reports to be completed.
Okay. So completed or provided to you?
Completed and provided to me.
Okay. So I want whatever agency has outstanding reports, I need you to contact them and tell them they've got 10 days to get them submitted to you. So that would be all outstanding reports have to be submitted by, actually, you've got close of business September 27th. Okay? And if you're having any trouble with any other agency or any other jurisdiction, you just need to tell me. And then
yes, Judge,
I'll address it myself. Okay? So all outstanding reports, other than the exclusion would be if FDLE is still conducting testing of any evidence. It's just, you just need to let the defense counsel know that I don't have this FDLE report or whatever it may be, because they're still testing. But all outstanding reports need to be, you need to have them by the 27th, and then they need to be produced to the defense by October 1st. Okay? Okay, So let's deal with Miss Andrews then. So state and Miss Hurdle, January 6th for trial. Okay?
Yes, Your Honor.
And we will set a pretrial conference, which will be a status for everybody, but it will be a pretrial conference. December the 19th at 10 a.m.
Your Honor.
Yep.
If I may, I just want to notate or remind the court because we see I'm new here from first appearance. My client actually is pregnant, so that's another reason why there's certain decisions.
When is she due?
She's due February 15th, 16th.
Okay.
So just for the record. Thank you.
Noted. Okay. So then let's look at our calendars for a trial date for the remaining defendants. All right. Because the biggest issue in a case like this with 4 separate defense attorneys are the schedules of the defense attorneys and the state. So, Ms. Rayner's out of pocket most of the spring, correct?
Correct.
For her legislative commitments. So we're looking at late 25, early 26.
Judge, and I would prefer October of 2025 if the defense counsel could be ready by then.
Judge Brian is also on behalf of Mr. Murphy. Judge, I have State versus Zavante Sampson, which is a 2021 case, and it is just going to trial division now from Division I, and the court just got all of our respective dates. It's a 5-defendant case, and it appears that September of 2025 is when that case is going to be set. Although there may be severances, there'll be at least 3, if not 4 of those defendants that will be tried together. I also have State versus Josue Claval, which is a death penalty case. It is also a 2022 case, and I anticipate that being tried in mid to late 2025.
Well, has that judge set a trial date yet?
That's not set. That's not set. That's what the calendar lawyers have provided to the court.
I understand.
I would request early 2026.
Well, because then I don't want it, because then this is the problem that we're going to run into. We're going to run into the same legislative conflict for Ms. Rayner. So it's got to be 2025 in the fall, October, November, December.
Your Honor, if we were going to try this in 2025, it would be preferable for me either in November or December. I will be in committee weeks, and I know that legislative session for 2026 goes from January to about March, in the very beginning of March. So if we were to go into 2026, I could do mid-March or April 2026. I don't have the committee dates for 2025.
But we can assume it's going to be it's similar this year, correct?
So the committee dates in 2025, and
it precedes the legislative session, correct? So
the committee dates usually in 2025 are October. There's one in October, a sprinkling in November, and the rest in December, and then we go into legislative session probably that second week of January, and then we are done the first week of March 2026 because it's an off-cycle election year. I don't have those dates, but those are kind of what it historically has been.
Right. So hence my comment that the spring is normally no good for Ms. Rayner. So I guess I have a question for you. Just if the state seeks the death penalty against one or more defendants, would everyone remaining be tried together, or would the death penalty defendants have to be severed out?
Judge, I'm not sure about the answer to that question. I'd have to research that. If the death penalty wasn't on the table, I knew that our strategy was to try them all together. We didn't believe that there was any motion to sever. I have not looked at it. I'll have to talk to Mr. Foreman to discuss whether or not that position will change if we file notice on some of the defendants.
Okay, so here's what we're going to do. We're going to pick a trial date, late 2025, for any defendants who've waived speedy trial where the state is not seeking the death penalty. Because honestly, my gut instinct is you can't try them together. That's my gut. I could be wrong, but that's my gut instinct. So we're going to pick a date, and we're also going to pick a date 26 for any defendants where the state is seeking the death penalty. Okay, so I'm going to preliminarily set aside 2 weeks. December. You guys want to start the December 1st, the Monday after Thanksgiving?
On your 2025.
Yes.
Yes, that's fine.
Not 2026. We're not going to go that far into 2026. It'll be in the same soup. Okay. So, and I would anticipate December 1st, 2025. And assuming we have 3 co-defendants where the state is not seeking death, we should be able to get this case tried in 2 weeks, including jury selection, right?
Yes.
Yes. Okay. So that's our prospective trial date. Please block out your calendars with any other judges for those dates. Then, looking at 2026, any defendants who are facing the death penalty. The legislative session is normally done by May, early May.
So that year, Your Honor, it will be done by March because that's the earlier.
I see. Okay.
That's the earlier.
So we're looking at April 2026.
Yes, Your Honor.
Let me look up. Someone look up on your phone real quick. See when Easter is. 2026.
April 5th.
April 5th. Okay. Thank you. So then we would start April 6th, 2026. 3 weeks I will block off. So that would be through April the 24th.
Judge, can we actually start the 13th?
Fine with me.
That way we have like a week to, we don't have to prepare during Easter.
Sure.
No objection, Your Honor.
All right. Any defendants where the state is seeking the death penalty, trial will begin April the 13th, 2026 through May the 1st, 2026. All right. So let's set another status, see where we are. And I will have a proposed scheduling order for you guys. The state, you said you should make up your determination regarding the death penalty in 2 weeks?
Judge, yes.
Okay. So then depending on what the state decides, then I'm going to do a scheduling order as far as the filing of motions, the disclosure of any witnesses, just to keep us organized. Okay. But that way we'll know which way the wind is blowing and when people are actually going to go to trial. All right. Okay. So, let's set another status.
Judge, it may be 3 weeks because we may be meeting on the 10th. So I just wanted to
of October?
Yes.
Okay. All right. So, yep.
Excuse me. Yes. I have already done the pre-motions back on the 27th of August, so I'm not sure whether you were seeking to, at the same time as the status hearing, to hear those, or if you would like me to.
What type of motions are they?
A motion for statement of the particulars and also to reduce the charges.
Okay. Are they don't sound evidentiary in nature?
No.
Okay.
At the moment, but I was just trying to see if it would, you want all the motions heard at the same time as the status hearings, or all separate ones.
Have you seen the motions yet?
Judge, I have not seen them, so I'll check with my legal assistant to see. I'm sure. When were they sent?
August 27th.
Okay, Judge, we did get them.
Okay.
Look at them.
Okay. Very good. Okay. So I'm going to set another status for October the 17th at 9 a.m. Is everyone available?
I'm absolutely.
I'm sorry, Your Honor, I was distracted. October
October 17th. Just a status. See where we are.
Judge, were the states available?
Okay.
Attorney Michelle is available.
Yes, Your Honor.
Okay, very good. So we'll know better who's going to trial when. And then Ms. Hurdle, when we come back on that date, any and all, I'll set a motion hearing date for you separately for your client if there's any outstanding motions. So, but just so you know, because you're not waiving speedy trial, any outstanding motions must be filed by Defendant Andrews no later than October 31st, 2024. Okay? That's your deadline to get your motions filed.
October 31st?
Yep.
Yes, Your Honor.
Okay. Okay. Very good. All right. Anything else?
No, Your Honor.
Okay. Oh, you guys need to stay. Your clients will be excused. You all need to stay and start blocking out deposition time in November and December. Okay? Just start blocking it out. All right? See what you can get done. Okay? Okay. After you talk to your clients, then you guys need to confer. And when we come back, when I see you for the next status, I want to hear what your dates are that you've agreed to begin your depositions. Okay?
Are you on luggage? What time on this one? 9?
9 a.m.
So Mr. Gonzalez there, who's talking to Rashad at the forefront here, he represented Zavante Sampson in the Sonny Bell trial. So if you guys watched that with us or you heard that name, he was prominent in the Sonny Bell trial. And then Daniel Hernandez, who represented Jalen Bedward, he was in the Sonny Bell trial. He's going to be representing Rashad as well. So there goes Alicia. She's pregnant, so she gave birth in February. Allison, yep. Yeah, she was due in February 15th or 16th. I'm not sure when exactly she gave birth, but her trial was in October, so. Kimbers, you were, I don't know if you were with us at that point in time. Let's see. It was back in September. And they were sentenced in October. So they were sentenced right as Alicia's trial was going on. All right, I think I can just kind of fast forward through. It doesn't look like anything else is going to happen. Let me see. Do they come back at all? All right, seems like that's about it. All right, so that's it for that. All right, so next up, we're going to we're just going to keep going in time. So this is Alicia's her delay. So her trial got delayed. So let's check this out. Let's see, why was it delayed? Why was Alicia's trial delayed? Let's find out.
I did get an email.
Let's find out why her trial was delayed. All right, so this is from January 5th of 2025. So this is Alicia hearing. All right, so this is some kind of delay. Let's see what this is about.
I did get an email saying that she's stuck in traffic. I think Connie might have, Jay might have been copied to it, not yourself.
Okay.
But saying that she's stuck in traffic and all the way.
All right. I'll let Mr. McClymont know. He's appearing via Zoom, so. Cool.
Say Ruby.
Yeah, I know this. Check down, check in this. It's one slide. Yeah.
Go. I'm gonna hold on 1 second. I was having trouble finding the icon.
So she's 23 now. She just turned 23 in February, so she was
Mr. McClymont,
22?
we're just waiting on Miss Hurdle. I think she is stuck in traffic on her way here.
Yeah, so last year she was not quite. She was 21 actually in January.
Okay, so as soon as she's here, I'll be back.
Okay.
All right, so this took place in.
Okay.
This took place in January. Her birthday's in February, so that she was 21, and then presumably about 22 when she gave birth, and now she's 23. So, yeah, she's young. All right, so I can clearly fast forward. They're just gonna sit here and watch Alicia. She's a pretty girl. So that's one of her lawyers there. I forget his name, but that was one of her lawyers. She had lawyers from Miami. I think she had like 7 lawyers or something like that. She came with a big big group of lawyers.
Miss Hurdle.
All right.
All right, everyone have a seat. Miss Hurdle is present. Miss Andrews is present. Mr. McClymont is on Zoom. Who's going to be arguing this motion for the defense?
I am, Your Honor.
Okay, you may proceed, Miss Hurdle.
Yes, at this time, I don't touch the bench. Okay, let's take it.
Yeah, right. I'm just trying to think. There's no way for Mr. McClymont to participate in this discussion. So does he need to be?
Probably not. It's okay.
Okay, Mr. McClymont, Miss Hurdle has asked that, to approach the bench. So I'm going to let her, but there's no way for me to allow you to participate to keep it confidential since you're on Zoom. So
That's fine, Judge.
okay, very good. Alignment. Okay, so I'm back, Mr. McClyment. So this was Ms. Hurdle's motion to continue. And Mr. McClyment, had you filed a motion to withdraw?
I didn't file one to withdraw, Judge. I'm withdrawing the motion to withdraw.
Okay, so you're going to remain as counsel.
Yes.
And are you adopting the emergency motion to continue trial?
Yeah, I did file on a waiver of speedy trial. I will be adopting.
Okay, so I will,
Just on designation.
okay. So I will grant the motion with the waiver of speedy trial. And Ms. Hurdle, do you have a motion at this time?
Yes, Your Honor, at this time, I am making a motion to withdraw.
Okay.
As counsel.
And Ms. Andrews, you understand what's happening here? Okay, so Mr. McClyment is going to stay on as your counsel. Ms. Hurdle is going to withdraw as your counsel. And due to that fact, there's no way they could be ready, Mr. McClyment could be ready for trial on Monday, as this case is currently scheduled. Okay, so then he has entered a waiver of speedy trial on your behalf. So I do want to get a new trial date on the calendar because I know the attorneys for the state are very busy. This court's busy. So Mr. McClyment, do you have your calendar handy?
Yes, Judge, that is.
Okay. So I can tell you all, I don't have any availability currently until August. So let's start with the state, and it would probably be August 18th, August 25th, somewhere around there. Let's say the 18th.
Judge, I'd be fine if we started on the 18th because I have another homicide trial on September 8th.
Okay.
So as long as, yes, if we started on the 18th and had 2 weeks, I think that would be fine.
That's also fine with Mrs. Her and myself. Right?
Okay. And Mr. McClyment, how are you looking then?
That day works for me.
Okay. And actually, because we're going to need, how many jurors did we say we're going to need?
70.
70. Oh, we're fine. Then we can keep it on the 18th. All right. So then we will go ahead and reset this case for trial beginning Monday, August 18th at 9 a.m. And I'll set aside 2 weeks. It's not going to take a full 2 weeks, but in abundance of caution, I'll set it aside. But I'm thinking it'll be more like a week and a day or a week and a 2 days max. So we have a status with the other defendants, I think, let me look here, March 31st at 10 a.m. So we will set Ms. Andrews for status as well. And for that hearing, Mr. McClyment, if you would like to appear via Zoom, you can. You just know the drill. You got to let me know ahead of time.
Understood.
And then if for some reason that status, if an evidentiary matter has to be heard on that date and time, then obviously you'd have to make the trip up from Miami if it involved your client. But if not, if you're just appearing just for a status to check in, then you can appear via Zoom. Okay. Is there anything else that we need to discuss?
Confirm, we've been working on witness and exhibit lists. Can we strike that they be done by today?
Yes. Okay. was going to enter an order and the order will have in it the dates that I ordered at the motion hearing. But obviously you guys will know, since the case is being continued, that the court's instruction that you all have your witness and exhibit list done by 5 p.m. today, that is now stricken. Okay? All right. Anything further from the state?
No, Your Honor.
Anything further, Mr. McLyman?
No, Judge.
Okay. All right, Ms. Hurdle, anything further?
Yeah.
Okay. All right, very good. We're concluded. Thank you.
And court's adjourned.
Yes, Debbie, Isaiah Chance, he's Alicia's boyfriend. I don't know if they still are. I would guess they still are, and that's why I'm assuming that he's the father, because she got pregnant before all this happened. So she was actually pregnant while this was going on, right? Because that was in August. They were talking about her giving birth in February. So she got pregnant like in, what's that? May, February, March, April, May. Yeah, she got pregnant like in May, maybe early June, and then the shooting happened in June. Think about that. So, right? Yeah, she was pregnant when the shooting happened. Just think about that for a second. So I'm going to go out on a limb and say Isaiah is the father. But are you saying that too? Oh yeah. Yep. I didn't even really think about that, but yeah, she was pregnant when the shooting happened in June. Because if she gave birth in February of 2025, 9 months from that is like May, June-ish, right? Wow. That's kind of weird. But yes, I'm thinking it's Isaiah, unless she was messing around with somebody else. I don't know. I have no idea. But yeah, so those are the defendants. The 4 guys are up for DP. Alicia is up for manslaughter. She was convicted, but she's trying to get that overturned because she now has a new judge for sentencing. So we'll see. May 12th, I believe, is when she will know when she has a new trial or not. All right, let's get back to this. All right, so now we're going to shift gears and we're going to go to Rashad. So that was January 5th. Now we're going to go to February 5th of 2025, and we're going to check in on a pretrial hearing for Rashad. All right, so this is Rashad from February. Let me post this up here. All right, so this is Rashad Murphy from February 5th of 2025.
Catch her everything at the same time.
IT. I need my IT person.
Any questions?
What's my number? My monitor. No, my monitor ain't working. Because I was saying this one on too. I don't know why. I was saying like the last chapter that it was like it was on. Like the button won't turn on. Right there in the corner. Yeah. The first one's not very nice. Not that one. Yeah, that one. I don't know what happened like last week. It was like, look, Reg, what is going? What is that going? You know?
They're going to have to lay it down. Okay, lay it down.
Cause I was like, so it's one of these somewhere? Cause where this thing came from? Oh, that's why I ain't got it here. You got it? You got it to my mom. Yeah, I know that's right. That's what I'm saying. And I was like, oh, what happened?
The only thing I can think of is if Johnny King come over here and be wearing something.
They ain't white nothing. You see how dusty it is? I need some white. They ain't white nothing. But some, it was loose and then all of a sudden it just went out. So that was it.
There you go. $9.95. $9.95. Send it to my bill person.
Quick second.
Quick second.
Hey, you know that.
Yeah, because I'm like, okay, that thing got no, because like from here, they'll light up sometime with the
Okay, so I know we are set today for me to conduct a Ferretta colloquy with Mr. Murphy, and I will do that. I would note at the last hearing, I find that Mr. Murphy's request to represent himself was not unequivocal. At one point he said he wanted to represent himself, then he said he wanted time to hire new counsel, and I candidly am still unsure as to really what Mr. Murphy truly wants. I suspect that Mr. Murphy, understandably so, is very frustrated by the restrictions he's been placed on in Hillsborough County Jail. So what I would like to do, Mr. Murphy, before we get into the issue of whether or not you're actually going to waive a very important right, constitutional right to be represented by counsel, I've asked the representative from the jail, Ms. Hamill-Harris, to be here, and I'm going to delve a little further into what the restrictions are and see if I can get a better grasp on what's going on there. So with your permission, I'd like to set off the Ferretta for now, let Mr. Gonzalez go ahead and represent you for this portion, and then after we kind of work through those issues, then we can go on to the Ferretta colloquy, assuming you still want to go forward with your intention to represent yourself. Does that sound good to you?
Yes, ma'am.
Okay. For you to give up your right to be represented by counsel is, in my opinion, such a fundamental mistake on your part. But the Constitution, the United States Constitution, allows people to make horrible mistakes and choose to represent themselves when they should not. But I think you may be under the incorrect impression that if you choose to represent yourself, then you can file your demand for speedy trial, and then a magic wand will be waved and you'll be home sooner. And I don't think that is a correct assumption at all. And the downside to you is literally the ending of your life via the death penalty. That's the downside for you rolling the dice. So I just need, if you wish to pursue representing yourself, we'll have the Ferretta colloquy, and I will go over everything, every way you're going to be hindered by making that choice. And if I find that you are knowingly and voluntarily waiving your right to be represented by counsel, and then I will grant your request. But I don't want you to think that that means you're going to turn around and file a demand for speedy trial and I'm necessarily going to grant it. Because I anticipate the state will file some type of motion to strike it, and then I'll rule on the motion and we'll see where we are. So I guess, Mr. Murphy, do you want to talk to Mr. Gonzalez about this any further? What is your desire?
We talked about it. It's like just sit right there for so long. Like
I know. I understand. And I don't honestly know the answer as far as how much authority I have to tell the jail what to do. I really don't know the answer. I haven't had this ever come up in 23 years. I've never had this come up. But I am willing to look into it, and I'm willing to continue the dialogue, and I'm willing to do repeated statuses to see where we are. And if you would be willing at this point to keep Mr. Gonzalez on as your counsel and allow him to guide you through this process, and then I am going to talk to the detective, have him give me sworn testimony in camera so I get a better feel for what the allegations are, and then we can go from there. I would encourage you to follow that route, to at least allow Mr. Gonzalez and myself the chance to kind of get a better grasp of what's going on. And then at the end of the day, once that has been explored and I know exactly what I can or cannot do and what the facts are or are not, once we reach that step, then at that point you can tell me, okay, Judge, yes, I still want to represent myself, or no, Judge, I want to continue with Mr. Gonzalez. How does that sound to you?
That's okay. Appreciate it.
Okay. So that's what we're going to do. Okay?
So that was fast. So he was thinking about self-representation. I'm glad he didn't. Ultimately, he decides to stick with Brian Gonzalez. Smart move there, Rashad. Do not, because DP requires 2 lawyers. You have to be qualified for DP, and that's very rare. I mean, it's not. There's not a lot of them in Florida, so that's why you see the same lawyers on these DP cases. And then you have to have certain. If you're not, before you get qualified, you have to sit in a DP trial and get hours under your belt. Basically, you could possibly join in and speak, but you don't have to. But you basically just have to be there and get the case, log the hours. So it takes a lot. It takes a lot to become DP qualified. I'm really glad that he decided not to self-represent, because that would just be foolish. All right, now here they are requesting separate trials. So this is now February 26th of, was it last year? Oh no, this is this year. Oh wow, okay, so this is a few weeks ago, a few months ago now, I guess.
Chance.
I will take a moment. What do you guys, Anthony, very smart move. Professional juror, his client would be a fool, 100%. AWOL, May 11th, read the motion later. Yep. Yeah, I just found that out. I literally just found that out yesterday as well. Kimbers, I didn't watch your trial really, but I did see her on the stand, and whoa, yeah. Was he the one tiptoeing by the Tesla? I'm going to go with no, it wasn't. It was somebody else. It was another person. Allegedly, it was another person, based on the pants. That's what they're gonna bring in. The state's gonna bring in based on the pants. And we saw that yesterday. Rashad had that rip in his pants, and they showed that yesterday. And Davion, they're gonna bring that in. It was based on his pants. All right, so this is going to be a 2-parter. This is them asking to sever, to request separate trials. So let's see, defendants ask for separate trials from. All right, so this is from February 26th. So just what are we in April? Yeah, just 2 months ago. All right, so let's see what this is about.
We have motions to sever filed by Isaiah Chance, Sean Gathright, and Rashad Murphy, correct?
Yes, Judge.
And I did not
was there one filed by Davian Murphy, a separate one, or did you all just incorporate all of the other motions?
Judge, we would adopt the motion to sever as well.
Okay.
I did not file a separate motion.
Okay, very good.
That is correct, Your Honor.
Okay. Yes.
Judge, would the court allow us to be heard, or do you think it's prudent for us to be heard just briefly on scheduling?
Sure. Yeah.
Judge, I truly appreciate Ms. Doherty's ability to corral all of these things and provide us with an anticipated schedule. There are just a couple of things that I wanted to bring to the court's attention for your consideration. And that is that there appear to be, in addition to the motions for severance today, some other motions that might have some anticipatory ability to be heard. And as it relates to number 5, which is the state's motion in limine for pretrial ruling regarding admissibility of evidence, it's set forth in Mr. Gathrigh's style, but I think that it dovetails and it has application potentially to other defendants. And when I look at the additional schedule, the court is going to note that, again, pursuant to the schedule, Rashad Murphy, which would have been Friday morning, but now won't be Friday morning, number 10, is a motion in limine and a Daubert challenge, opinion testimony regarding gang war, hearsay-based gang intelligence, and uncharged and unsolved acts of violence. I believe that those two motions should be heard in conjunction with each other. I think it makes a whole lot of sense from a redundancy standpoint and a thoroughness standpoint. So I would be suggesting to the court that if we do get to other motions today, that it not be number 5, and that either, unless the state has a particular objection or wants to be heard on it, that whenever we now get to when the next time frame will be after Friday for motion number 10, that we hear motion number 5 at that time. So that is my first observation or request. The second might be that, as the court is aware, my second phase counsel was not able to be here today, will not be able to be here tomorrow. Tomorrow, if everything goes as the schedule might anticipate, it appears that in the afternoon, there would be all of the state's penalty phase motions in limine, as well as all of the other second phase motions.
Right.
An abundance of them, although we all know that those normally don't take hours and hours and hours worth of argument. But bringing it to the court's attention that Mr. Hernandez will not be here tomorrow, I can tell the court I'm certainly not prepared and not in a position with my other obligations to argue the Rashad Murphy penalty phase motions, and whether or not either Mr. Hernandez can do those separately at a time available to the court.
Well, I think we already set Tuesday.
Okay, and that's, again, presuming the schedule, flows, and obviously we don't have Friday as well. Also, the one thing I would ask the court, if tomorrow we do get to the state's motions in limine, that Mr. Hernandez be able to, although the motions might have already been heard, be able to add or argue as it relates to those motions in limine separately at the time set for Mr. Murphy's second phase motions.
Okay. Right. So I hear you. I think that makes sense as far as scheduling goes. So my plan is today to hear the motions to sever and at least begin to discuss the parameters of the gang evidence and how much of it is coming in, if any. And then what I was going to have you all do on Friday, since we don't have court, was get together and see if what you're in agreement on the penalty phase motion. So my experience with the penalty phase motions, oftentimes there's a fair amount of agreement between the state and the defense, and then that way we can really streamline what penalty phase motions really need to be litigated. Okay?
I'll pass that on to Mr. Hernandez, Judge.
Yes. So that would be as to all the defendants, just to get with the state and see what you all can agree upon, and then whatever cannot be agreed upon, I will hear Tuesday. All right? Okay. So As I indicated, there are the three motions. Do you all have any preference in light of Mr. Sonardi's, even though he doesn't have a motion per se? Apparently, he's adopted yours, Mr. Gonzalez, correct?
That is correct, Your Honor.
Okay, so do you want to go first?
Judge, without objection from co-counsel, it probably would be appropriate for me to go first.
Any objection? Okay.
No, Your Honor.
Okay, very good. You may proceed.
Judge, what I anticipate doing this afternoon with the court's approval is I'm going to argue my motion for severance or in the alternative, and then I would ask the court to allow me to hear the state's response and arguments to the motion, then allowing me rebuttal.
Sure.
And so to that extent, Judge, essentially, we have filed, and certainly I think this motion dovetails with other co-defendants in many respects, a motion for severance. The state has listed as inextricably intertwined evidence that, in my mind, is neither directly or indirectly tied to Mr. Murphy. To the contrary, it seems that this is a documentary of a large amount of pre-act evidence that utilizes a lot of inference in order to be called purported evidentiary connections. Essentially, the state's introducing and linking co-defendants to prior bad acts in support of a group narrative theory. The prejudice that requires severance in this case doesn't really arise from a single evidentiary issue. It's more from a cumulative effect of multiple categories of evidence, which I will bring to the court's attention. And certainly the state's theory of guilt depends on presenting these categories as a collective proof of an ongoing gang war, inviting the jury to infer intent, motive, and participation by association rather than by individualized proof as to each defendant in and of themselves. Specifically, I think the state's going to rely on 5 essentially different types of evidence. Violence linking co-defendants Mr. Gathright and Mr. Chance to a prior attempt on Julio Foolio's life. A large volume of physical evidence that links, again, Mr. Gathright and Mr. Chance, but not to the defendant. Pre-conspiracy and post-offense statements that are linked to Mr. Chance, and also as it relates to the prior attempted murder. Celebratory statements that occur post-murder that are allegedly made by Davion Murphy, and at one time attributed to Mr. Rashad Murphy, and then an extensive amount of gang-affiliated evidence that materially differs in scope and reliability and probative value as it relates to Mr. Chance and Mr. Murphy. I believe that there's a substantial risk that the jury will render a decision in this case and not be able to contextualize these inferences as it relates to that individualized proof. And I want to go over the types of evidence that I anticipate the state attempting to introduce. I'm going to dispense with a factual basis of the case. The court's well aware of the factual basis, although I will suggest to the court that the conspiratory time frame in this case is June 21st of 2024 through June 23rd of 2024.
And that's what's alleged in the indictment, correct?
Yes, Judge. I don't believe that there's any evidentiary link of any type to establish any relationship between Ms. Andrews and Mr. Murphy, or Mr. Murphy and Mr. Chance, except in happenstance type circumstances. We're talking about historically. First of all, Judge, there's evidence, as we talked about, of prior acts. And the motive, obviously, as the court's aware, is an ongoing gang war between two rival gangs, ATK and 1200 as one group per se, and 6 Block. The allegation is that the defendant, Mr. Murphy, is affiliated with 1200. Co-defendant Chance is affiliated with ATK. Co-defendant Davion Murphy is associated with ATK/1200, and that the victim is affiliated with 6 Block. To establish the nature of that gang war, the state intends to introduce a large volume of evidence that relates to a number of prior shootings and prior killings, most of which are unsolved, and none of which relate to the defendant. 2 of those particular prior acts are the October 6, 2023 murder of Antonio Tilley and the attempted murder of Foolio on October 7th. It would be my contention that there's no evidentiary link between Tilley's murder and Foolio's attempted murder, that the state intends to introduce testimony and argument that Foolio was shot in retaliation for Tilley's murder. It's anticipated that the state will utilize multiple detectives who they will suggest to the court, to the jury, are experts regarding that both Mr. Gathright and Mr. Chance are suspects in Foolio's attempted murder of October 7th, 2023. The defendant had no relationship to Tilley or to Foolio for that matter, and there's no evidence that he was connected to either of those crimes or either of those offenses. And they are, in fact, especially Foolio's murder, attempted murder, unsolved to that extent. While Tilley was shot by Jaquan Mills and another unnamed co-conspirator on the 6th of October 2023, he had been flagged as a member of ATK, and Jaquan Mills was not affiliated or documented in a gang. Law enforcement believes, and this is pursuant, everything I tell the court is pursuant to sworn testimony, which I've supplied to the court in the form of depositions at length of every one of these detectives.
I have them.
And to the extent that law enforcement in that sworn testimony believed that Tilley's death was a contract killing. And however, those underlying circumstances regarding those who are responsible are apparently still under investigation and are largely speculative. Again, Foolio's murder, attempted murder, is unsolved. To establish a link and to support the theory regarding the motive, the state intends to introduce evidence related to Chance and Gathright. During the investigation, there are forensic findings that law enforcement became aware of regarding the attempted murder of Foolio in October of 2023. In June of 2024, there was a search of Mr. Gathright's vehicle wherein there were casings recovered from the scene of Foolio's attempted murder, presumptively matched to that firearm. There are communications between Mr. Chance and Ms. Andrews that the court is aware of regarding, or allegedly regarding, this particular murder. And essentially, in general, Chance tells Andrews that he needed to lay low for a while and asks Andrews to stay loyal. That is obviously part of the provided discovery and also Detective Ramos's sworn testimony and deposition. There are additional communications that the state intends to enter with regard to Mr. Chance's alleged involvement in other Jacksonville murders as well. The state also intends to introduce statements purportedly made by Mr. Chance in reference to his involvement in a prior attempted murder on Julio Foolio, and weeks prior to that charged homicide, and 8 months after Foolio was shot in 2023, Mr. Chance appeared in a video conversation over Twitter or X where he makes statements to Foolio that is your foot okay and he has bigger fish to fry. Again, Judge, as I lay this out for the court, I'm not suggesting that one, we can't get beyond, two, we can't get beyond. It's a cumulative effect and how it is compartmentalized as to individual defendants as opposed to degree. I want to say at this juncture too that I'm talking about these things, and I'm going to argue this more after the state argues. This is a motion for severance. This is not a motion for inadmissibility or admissibility of evidence. We have motions for that. Right. The court's going to hear that. Severance is a different ballgame, and severance is determined under different rules and under different law. And so I just make that point as I go through this, because I don't want the court to be bogged down simply because I'm talking about facts. I think contextually I need to give the court a full understanding, not only for the court, because I recognize it's a little different for you because you have been exposed to some of this already in a prior proceeding. But as it relates to the overall posture, you also were not privy to other parts of it that we're going to talk about today. And again, these shootings are unsolved. So in an attempt, again, to establish a connection between Mr. Murphy and Mr. Chance and the October 23rd shooting, which again is almost a year from Foolio's murder, and certainly far beyond the conspiratorial framework, the state also is going to rely on an Instagram message or an Instagram conversation where Mr. Chance says, had to switch it up, coming different in 2024, love you, brother. And it looks like Tilly and a Ghost 187 underscore are tagged. I hope I'm using the right words, because one thing I can tell the court, I am technologically not savvy, and I don't own social media of any kind. So,
well, we speak the same language, Mr. Gonzalez.
Bear with me if I'm not using the right terminology. So, in taking the deposition of Detective Nieder, his interpretation of this statement is Chance got upset with ATK and told them that they didn't get a get back for Tilly's murder, so he's switching up the family, and then he tags what Detective Nieder believes is Rashad Murphy's Instagram account, which that's another, okay? That is Detective Nieder's interpretation of that Instagram communication. So he doesn't say that this is based on any kind of coded language that is known. It's simply his own translation of this particular statement.
So, Mr. Gonzalez, it'll help me as far as just doing the analysis on this, is to ask you this specific question, first of all. Obviously, if there's a Bruton problem.
There's not.
Okay, I just wanted to make sure we had gotten that.
There's no antagonistic defenses,
Okay.
There's no Bruton problem. That's not what, the state spends a lot of time talking about those things in their response. And I'll certainly hear them out. Those are not the issues. This is evidence admissible as to one defendant that is inadmissible to another.
Okay, I just wanted to make sure that there was no allegation of a Bruton issue, so instead it would be the fallback that, so Brutons are obviously, there's a Bruton problem, obviously there should be a severance. So then the next question would be is whether severance should be granted, and this has to be based on a case-by-case basis.
Absolutely.
So you're going under the second prong, basically, of a severance.
Yes,
there is no Bruton, but based upon the totality of all the evidence, there should be a severance granted.
That's correct, Judge. I'm going to talk about that a little bit more in the rebuttal.
Okay.
But you are correct. So next, Judge, category, if you will, is going to be physical evidence that is admissible against particular defendants, but absolutely not admissible against Mr. Murphy. Now, we're going to hear, inextricably intertwined, we're going to hear a motive, okay? But at the end of the day, as it relates to severance, okay, on June 26th, a search was conducted of Mr. Gathwright's vehicle, and in that vehicle were a litany of an arsenal, okay, of firearms, of ammunition, of switches, of rifle magazines, rifle stocks, buttocks, pistol holders, all of those things. The state would like to admit that, and the state would like that not to spill over and trickle down to Mr. Murphy. So they also would like to suggest that a cell phone that was found there was a straight talk throwaway phone that Mr. Gathwright is now using because he got rid of his phone that was used during the course of the murder. So we're developing the arguments that are going to be put forth with regard to this evidence if admitted. And I know there's also motions pending, are going to be motions pending on these issues as it relates specifically to Mr. Gathwright. Now, understanding that the court's ruling on that, obviously, is very important as it relates to all the defendants, and in my particular case, Mr. Murphy. So, in paragraph 15, the state intends to introduce evidence linking Gathwright also to the attempted murder based on shell casings that were found from that vehicle. So, shell casings from the attempted murder of Foolio, okay, found in Gathwright's car, are going to be used to attempt to implicate Mr. Murphy. Because it's inextricably intertwined? No. Because it's motive? No. Because that is evidence against Mr. Gathwright. And in a joint trial, okay, that cannot come in against Mr. Murphy. So, moving on,
so your position is that the physical evidence found in Mr. Gathwright's, either his car or his home, would not be admissible in a trial against your client, even though they are both charged as part of a conspiracy. Is that what you're telling me?
No, Judge. No, Judge. And again...
So that's yes, you agree with me, your argument is... That
is my argument.
Okay. Right.
That is my argument. And first of all, again, the murder's over. The conspiratorial time frame is done. Can't come in under conspiracy theory.
Well, no statements could come in, but you're saying the physical evidence couldn't come in either?
Nope.
Okay. Do you have case law that says that?
Judge, I will...
It's okay, don't do it now, I don't want to interrupt you.
I know, but I want to write it down.
Yeah, just make a note. I'm aware of the case law regarding co-conspirator statements are inadmissible once the conspiracy is finished. Those don't come in post-conspiracy concluding, but the physical evidence not coming in is a different argument.
Judge, additionally, there are also casings found at that time that are tied to another homicide in May that occurred in proximity to the residence frequented by Mr. Chance. Again, this is evidence I expect the state to attempt to introduce. There is no evidentiary connection between those prior incidents, that prior offense, and as it relates to the prior attempted murder of Mr. Foolio that is related to the defendant. None of the evidence that is seized from Gathwright's vehicle is connected to the charged offense. Okay? That's particularly of note for the court. Likewise, none of the evidence is connected to Mr. Murphy in any way, shape, or form. Moving on, again, the court knows that Mr. Gathwright also had his residence, a search warrant done on his residence, and again, a large amount of firearms and ammunitions were found, 2 AR-style rifles, which are equipped with brass catchers and spent 9mm casings. There's no forensic link between the rifles and the charged offense, and there's no connection of those firearms to Mr. Murphy. The 9mm casings matched casings that were found from the homicide scene. Law enforcement originally thought that they were fired from the same firearm, but after further analysis, they determined, or they thought, that the same firearm was used, but at a different time. So they were able to count up the number of casings and determined that although they were a match, that casing was not used in the homicide. It must have been, the casing must have been, become from another usage. Okay? So because they were able to find all of the 9mm that would fill the magazine at the scene, which means anything that they would have found in Mr. Gathrigh's home was not going to be connected to the murder scene. So that's an important fact, but they want to get it in anyway. And I believe, based on Detective Ramos's deposition, that's exactly what he's going to say. At the same time, Judge, there were search warrants done on Mr. Chance's residence, a 9mm Glock with an extended magazine, boxes of firearms, talking about switches in a notebook, and of course a switch meaning something that makes a semi-automatic an automatic weapon, even if it's not built that way. A poster of what's called Bully Down that was that was made by somebody, but in Mr. Chance's room, and essentially would be speculated on by Jacksonville detectives that is a perceived sign of disrespect to Julio Foolio. None of the evidence in Mr. Chance's residence had any evidentiary connection to the charged offense. To the extent that the state argues that the poster supports this underlying motive theory, the poster has no evidentiary involvement or connection to Rashad Murphy. Next category, Judge, of evidence is post-homicide statements. I know, and I won't, unless the state were to get up and say something different, there is a series of interviews and jail phone calls that involve, that the court knows because you've read my motion, but the response might indicate from the state that it's not their intent to attempt to admit that evidence.
They've described it as impermissible hearsay.
I will, bravo. And so to the extent that that doesn't, they don't change their mind or whatever from a tactical decision, decide that they want to try to enter it, I'll dispense with that argument. They do, in their response, and again, I'm not arguing the response, I want to save that for later, but as it relates to celebratory statements by Davion Murphy, what they, and the court has read them, they make specific reference to celebrating. This is after Foolio's murder on June 23rd, which is later in the day, after those early morning hours, and we expect that they are going to enter those statements to celebrate Foolio's death. For the court's knowledge, the phone associated with Mr. Murphy, Rashad Murphy, was not located in Tampa by way of cell site information, by way of geo-tracking, by way of any forensic method. And essentially that phone, which is the fodder of many other motions, is shared by his girlfriend. The way that these things happen, and certainly just as an example of what I've talked about, is that law enforcement originally believed that those messages were sent by Rashad Murphy because why? He didn't have his phone, so he's using somebody else's phone. And certainly later, After corroboration from third-party witnesses, it was determined that that is not the case. And in fact, it was not Rashad Murphy that sent those messages. And I bring that to the court's attention because it is part and parcel about with what happens and what you can think and what you can believe and what you could be drawn to think if you're looking at things from an overview capacity. And I would talk about this in akin to a jury. So the next category of evidence, Judge, is gang affiliation. The central issue is going to be whether the state can establish the nature of the party's gang affiliation. None of the defendants admit to gang membership. There are no witnesses who will testify to personal knowledge of their purported affiliation. And that becomes important when we talk about case law and when we talk about other cases. Extremely important. Neither Andrews or Gathright are alleged to have any gang affiliation. As I stated earlier, defendant Chance was documented, that's another word in quotes, and certainly refers to statutory criteria, which, by the way, the jury needs to make that finding. Okay? The state is going to put some detectives on, and they're going to talk about what they did, and I think, we're going to talk about that in another motion, because I think that bears its own separate and complete argument. I'm digressing from severance, but I think it's important in terms of context. And I don't want the court to feel that these individual segments of evidentiary issues that I'm bringing to the court's attention take away from the fact that severance is different. The burden for severance is different. So, again, Mr. Chance documented as ATK on March 8, 2024, 3 months prior to the alleged and charged offense. And I go through, I won't do it, the court can read it, you already have read it again, that Mr. Chance is documented by law enforcement pursuant to statutory criteria, broadest criteria I think I might have read in any statute that's ever been passed by the legislature, but nonetheless, that's another story for another day. And it goes into those things that law enforcement use to designate or to document Mr. Chance. And those FIRs or those documentations are exhibits in the motion. It also talks about, again, I'd like to talk just briefly about the bully down poster that was found in Mr. Chance's house, constituting a diss or hatred toward Foolio. I anticipate, based on the depositions, based on the police reports, that the state's going to introduce evidence linking Mr. Chance to extensive gang activity. Activity that is associated directly with violent acts. Activity that, and listen, his counsel is going to have kind of the same arguments about how they go about getting that information. I'm just suggesting and telling the court, it's coming in, this is the way it's going to sound. This is the way it's going to sound if it comes in. And essentially, that Mr. Chance receives financial incentives for committing violent acts, that Ramos refers to Mr. Chance as the mastermind that handles the gang's war, that his Instagram handle is, I think it's Rich Off War, and or that may be his Cash App handle. So while the state alleges that Mr. Murphy is a documented 1200 member, the state's evidence as to that association is categorically different than it is as it relates to Mr. Chance. And it should be noted that it was a month after this homicide, for which we were being prosecuted for, that Mr. Murphy was designated as a gang member. I have set forth with particularity those instances under the gang statute that law enforcement used in order to designate Mr. or document Mr. Murphy as a gang member.
in an overall capacity, without getting into it ad nauseum, the court can read it, is these are unsubstantiated field interviews with random people being stopped for things as simple as possession of marijuana that they have no names, no dates, no person, don't do a supplement, don't do anything to memorialize that a stranger given a list of people. Hey, is so-and-so involved in the gang? So-and-so involved in the gang? So-and-so involved in the gang? Yeah, he is. Yeah, he is. Yeah, no, he's not. He is. That is the first part of documentation that is utilized in order to document Mr. Murphy as a gang member. And it goes into detail based on sworn testimony of detectives as to how they got that information. I question the detective about the specifics of what they say is a gang handshake that's seen given by Mr. Murphy, and he talks about a series of movements that come together, something that can be seen but it's difficult to describe, and he goes on and says, I can't redo it. I asked him to do it with me. Can't do that. I don't know how to do that. Shows a video. I can't see anybody giving anybody a handshake. And essentially that is the second criteria by which Mr. Murphy is documented as a gang member. Thirdly, his association with Noah Williams, who is another individual who is documented as a gang member. He is purportedly, and in fact does, author or sing raps along the way as far back as 5 and 6 years ago, 2018, 2020, 2021, that are fodder and part of the state's attempt to admit into evidence in this case, that he is a gang member, but he is also a prominent musician. He is a person that has millions of views, that has signed a record deal with a national record company. So this is not a person who is simply just an alleged gang member, but a person who is an accomplished musician as well. He also happens to be a childhood friend of Rashad Murphy. Known each other since they were small children. There is no physical evidence to link Rashad Murphy with any criminal gang, and no witnesses to testify to it firsthand. Importantly, I don't anticipate, at least I haven't seen any yet, evidence that would suggest that Mr. Murphy had any involvement in a gang war. So those are the categories of evidence which I anticipate that the court will run into, not only as it relates to the overview of this case, but also as the subject of other motions that have been filed, not only by me, but by co-counsel. Severance is required, Judge, under 3.152B1A. I strongly believe that this case illustrates why severance is required when the state's theory depends on inferential group narratives rather than individualized proof. The prejudice that requiring severance doesn't arise, like I talked about earlier, with one singular incident, but the cumulative effect of multiple categories of evidence that are admissible, if at all, against co-defendants. I do not believe that under the rules of severance, that is cured by inextricably intertwined or motive, either or both. It is going to cause the jury to infer motive or intent or participation by association with individuals that evidence admissible against them would be inadmissible against the defendant. Evidence linking Chance and Gathright to prior homicide of Foolio. Specific forensic and physical evidence seized from both of them that are unrelated to this particular charge and have no connection to the defendant. Pre-conspiracy and post-offense statements that are attributed to co-defendants that may imply guilt or that may have to do with prior crimes and prior murders or attempted murders. Celebratory statements made by co-defendants that initially were thought to be Mr. Murphy, but not. And extensive affiliation evidence that differs in scope depending on the defendant. Independently, they establish a substantial risk, Judge, that the jury is going to attribute co-defendant's conduct and motive to Mr. Murphy. Considered all together, they render a fair trial impossible, in my view. The risk that's demonstrated as it relates to 3.152B1A is, this is what it's designed to prevent. It's required when a joint trial threatens a fair determination of guilt or innocence. A fair determination of guilt or innocence. While the court has the discretion to grant severance when a jury could be confused or improperly influenced by evidence which applies to only one of the defendants, the court should grant, not discretionary, but should grant severance if the evidence directed at a co-defendant which is prejudicial to the defendant exists. I cite the court a number of cases that would establish this general principle. I'll get to it later. The state takes issues, especially with the McRae state case that I cited, but it's not for the reasons that they say that I cited it. It's just simply for the standard law. The factual scenarios are different, and I don't say our factual scenarios are aligned. It's the premise and the context of the court's ruling that I want the court to take note of. I go on to provide the court with a federal court case, State versus Zaffro, excuse me, United States versus Zaffro, and Florida courts also have held that severance should be granted when the jury could be confused or influenced by evidence that applies only to one defendant. Again, cite McRae, I cite the Hernandez case, and I cite the Cason case. The state has some aversion to the Hernandez case, and I'm going to talk about that in rebuttal, but essentially I believe the Second District Court of Appeals agreed with me on that issue. And I think they agreed with my preposition as it relates to the context of this case. The danger of spillover in a circumstance like this with the litany of these defendants being tried together is magnified in complex multi-defendant prosecutions involving different degrees of culpability. And the courts are talk about this all the time. The jury's asked to evaluate multiple defendants through a single narrative and a single framework, not inextricably intertwined, not motive. This is severance, and it's a different ballgame. I cite the Crum case, Judge, and essentially courts in Florida talk all the time about when severance turns on prejudice and not convenience. And certainly in this case, boy, that's a really big word. Because we all know, and we have spoke on numerous occasions about what would happen in the circumstance where the court grants this motion. And I don't suggest to the court for 1 second it wouldn't be a nightmare, but I believe it's necessary. The courts reject severance, Judge, if the following factors are present, none of which are present in this case. There's substantial overlapping evidence applicable to all defendants, not here. And that's citing the Forbes case. Joint trial is proper where evidence of conspiracy, phone records, DNA, and eyewitness testimony applied collectively to the defendants. None of that exists here. In those cases, by the way, Judge, those evidentiary issues, by the way, are determined by witnesses, by live witnesses, by people that take the stand and people that testify to those things. Independent evidence establishing each defendant's guilt. I cite the Hunter case, which the state has an issue with, and I'm going to talk about that in rebuttal, that severance is required when defendants' own admissions, not here, physical evidence, not here, and co-conspirator testimony independently establish guilt. And then, of course, other crimes that are that evidence is linked to the defendant. In the Castillo case, no severance required when the predicate racketeering acts, though numerous, were tied to the defendant's leadership role. And then, of course, antagonistic defenses, which I've already suggested to the court, is not our argument here. By contrast, Judge, the court has held that severance is required when the following factors exist. Each, which is present in this case. Evidence admissible against a co-defendant, but inadmissible against the defendant. And that is buttressed by the 2nd District DCA case of Hernandez versus State at 572nd 404. And the DCA there reversed a denial of severance where prior drug transactions, this happened to be a brother who lived with the co-defendant.
And this all cropped up mid-trial in front of Judge Graybill.
Yep, sure did. Lost my place.
What's okay? There were
And
two
applied only
brothers.
to the brother and
There were
not to
two
the
brothers,
co-defendant.
co-defendants. They were both accused of trafficking and conspiracy to traffic cocaine. And then in the middle of the trial, evidence came up as to one brother and other prior drug transactions that the co-defendant brother had nothing to do with. And
Could happen here. Probably will happen here. Could happen here by co-defendant testimony. Could happen here by cross-examination of counsel that might open the door to a number of different things. But at that stage of the game, what the court said is that obviously where those prior drug transactions applied only to the brother, that severance should have been granted. Also, Judge, the second type of case where severance is required is the expansion of admissible evidence through co-defendant's conduct. I cite Dix, where they suggest that severance was required where the co-defendant's statements were used to support the state's theory of guilt, but would have been admissible as to the defendant. Again, a brutal issue. But thirdly, the risk that the jury will infer participation based on association, and that's back to Hernandez again. This is not a routine joint trial involving overlapping of independent proof tying each defendant to this case. As to Mr. Murphy, there's no forensic or ballistic evidence. There's no admissions or inculpatory statements. There's no animus directly toward Foolio. There's no participation in any prior violent offense. I will suggest to you that the state may indicate that, again, I'm talking about facts, I'm talking about admissible or inadmissible evidence, that in 2018, 6 years before this case or this murder occurred, that an individual by the name of Joe Rod Adams was killed, okay? And in fact, Mr. Murphy had a connection to Joe Rod Adams. They would suggest that's his brother. It's not his brother. People call each other brothers. They're not brothers. But I think that's what the state might suggest to you. Number one, it happened 6 years before this. Number two, Mr. Murphy's not involved in any violent act that I'm aware of or that even detectives will testify to in speculation or opinion. And certainly no one will walk in here and tell you or tell the jury that that exists. So to that extent,
Mr. Gonzalez, before Mr. Sonardi needs to leave, I just want to if he's got anything to add. You said 2:30, correct?
Correct, Judge. Our position is very similar to that of Mr. Rashad Murphy as it is to Davion Murphy. It dovetails the same arguments and factual basis. So we would adopt it on behalf of Mr. Davion Murphy.
All right, thank you, Mr. Sinerdi.
May I be excused?
Yes, you may.
Thank you.
Judge, instead, the defense anticipates that the state is going to rely on surveillance-based inferences, primarily, number one, the comparison of the defendant's clothing, all black, back boots, back jeans, back shirt, black hoodie, that he is seen wearing in a Walmart with surveillance video 36 hours before the murder in another jurisdiction, with pictures taken of shooter number one at the scene of the crime, where that individual is dressed in all black. Just for context, I don't know if this is working, Judge. So just for context, there's Mr. Murphy in Walmart, and there is the picture of the shooter at the scene. And this, primarily, as it relates to surveillance-type inferences, is going to be the state's evidence as to the fact that shooter number one is Rashad Murphy. That would also be in addition to Mr. Murphy's presence in Tampa after the murder took place. Hours after the murder took place, Mr. Murphy, there's going to be evidence that he was in Tampa in the company of some of the other co-defendants in this case. Not all of them, some of them. And an inference that the state's going to make that he drove down with them from Jacksonville, which there's no evidence to suggest he did. Number two, that he was in the Airbnb that the court's aware of, although he's not on any surveillance video going in and out of the Airbnb, and speculating that he must have gone in through other means in order to get in. Judge, evidence of the prior attempted homicide of Julio Foolio is admissible.
Why don't we refer to him as Mr. Jones?
I'm sorry, Judge?
Let's refer to him as Mr. Jones.
So much easier, Judge. I forget Jones, but I always remember Foolio.
Yes.
Yes, Judge, I'll do my best. So the attempted homicide of Mr. Jones, the state's most compelling evidence with regard to that attempted murder concerns the actions of other co-defendants' involvement in that attempted murder. And there's no comparable evidence as it relates to the defendant. All of the evidence as it relates to that incident is with reference to other co-defendants, and it precedes the conspiratorial time frame by a year. While the defendant, Mr. Murphy, doesn't concede that any evidence related to that murder is admissible, evidence to establish a shooting that occurred is categorically different to evidence directly linking co-defendants to that act. And that's what happens when we sit at this table, without question, and I think without there being any other way but spillover. Mr. Murphy, has no evidentiary involvement in that case, and others do, not only by statements, but by forensic evidence. This distinction, Judge, is really critical. If the state's permitted to establish that Mr. Jones' attempted murder is itself retaliatory, basically, as it relates to detectives' perceptions and opinion evidence, as it relates to Tilley's homicide, retaliatory in that respect, then the state's no longer offering the incident merely as background or context, which is what it should be meant to do. It's establishing co-defendants' direct involvement in an ongoing cycle of retaliatory gang violence that Mr. Murphy is not subject to. Once that showing is made, the scope of this evidence expands dramatically. It opens the door potentially to testimony and argument concerning those prior acts, whether it be, again, like I said, in cross-examination or testified by jointly tried defendants. Doesn't matter that Mr. Murphy would have a right to confrontation. That's not what I'm saying. What I'm saying is that it is heard, perceived, and taken in by the jury to begin with. Most of the prior acts, I believe in another motion, the court will see that I broke it out in a chart. I think 9 of the 13 acts are unsolved. The gang retaliation is largely, if not entirely, predicated on law enforcement opinion testimony that is drawn from a variety of sources. Lyrics that they are interpreting from songs, social media posts that they are interpreting over years as it relates to this crime in June of 2024 and long outside the conspiratorial time frame. But the state's evidence of co-defendants' direct involvement in certain cycles of this violence bolsters the state's case as it relates to Gathright and Chance. Certainly not as it relates to Mr. Murphy. The expanded narrative might be admissible against Chance and Gathright in the event that the court rules unfavorably on motions that are pending before the court, but it's inadmissible as it relates to Mr. Murphy. I go on to talk again about at length the Hernandez case, which we already touched upon. And the Hernandez case quotes Crum, which is a Florida Supreme Court case. The objective of fairly determining a defendant's innocence or guilt should have priority over other relevant considerations such as expense, efficiency, and convenience. The prejudice of this particular case, Judge, is even more acute. Unlike Hernandez, the collateral evidence that just involves some drug activity that was unrelated to the charged offense, as the court pointed out in the factual basis you're aware of, the evidence at issue here concerns an attempted homicide against our victim a year earlier, offered to establish an underlying motive, in a conspiracy prosecution predicated on group motive and collective animus, presenting evidence that is directly linked to co-defendants to that prior attempt of the same victim creates an inescapable risk that the jury will attribute that participation to anybody else sitting there. I just can't imagine. The court might say, well, every jury's different, and certainly they're asked to compartmentalize, and they're asked to consider the evidence only as to one person and not the other, and that's all great, but it shouldn't be done. I don't believe the case law allows it to be done in this particular case, and I don't believe that limiting instructions, I don't believe that any instruction would keep it from happening. I think association alone will rule the day. Because nothing can distinguish between an individual's retaliation and a group's retaliation or other individuals other than the defendant's retaliation. Severance is required to prevent the jury from conflating evidence of co-defendants' conducts, and that's what's happening here. The next category that we're talking about is co-defendant only physical evidence inadmissible as to Mr. Murphy. We talked about those things, and in general, there's no forensic evidentiary nexus to the defendant that would be inadmissible against him in a separate trial. And so in a separate trial, none of the forensic evidence comes in. None of it. And to that extent, I believe that requires severance. Thirdly, Judge, statements again, that we talked about that are attributable to Chance, to Davion Murphy, to Gathright are also inadmissible as it relates to the defendant. And I cite cases for that proposition. And also as it relates to statements that are made, and court talked about this earlier, statements versus physical evidence under 803.18e, that they were made either prior to or after the alleged conspiracy and wouldn't qualify for admission. Importantly, while the evidence might be admissible against those people, those individuals, respectively, those statements were not made in furtherance of a conspiracy, and they're inadmissible as it relates to Mr. Murphy. Finally, Judge, the gang affiliation evidence and the propensity for association. The evidence offered against Mr. Murphy is speculative in totality. It's derived from undocumented informants or individuals off the street. It's derived as it relates to interpretations and association with known people that are not involved in gang activity at the time. And critically, in contrast to some of the other co-defendants, there's no evidence linking the defendant to ongoing gang activity in the form of crimes, in the form of violent behavior, in the form of prior murders or attempted murders, aggravated assaults, shooting into vehicles. Doesn't exist as it relates to Mr. Murphy. We recognize, Judge, that while evidence of gang membership may be admissible on the issue of motive and intent, specific evidence associated with a co-defendant's gang membership, in this particular case, evidence being entered on a speculative basis by law enforcement officers, not by individual witnesses who have direct knowledge, is not relevant to Mr. Murphy. I'm going to talk about later on Richardson versus State and talk about recognizing the admissibility of evidence of gang membership on issues of motive and intent. The state's theory is not that the individual defendants had a specific motive to kill Foolio, but rather that they acted in conformity with their affiliated groups. And gang rivalries is not a gang rivalry between a defendant, and in this case, Mr. Murphy and Foolio. It's a gang rivalry between gangs. And to that extent, I think that's what sets it apart. And we're going to talk about Richardson because the court may or may not have recognized by now when we talk about the Robinson and the Hayes and the Richardson cases, they are Duval County cases. They are related to this case, at least to the extent that the state would suggest they are inextricably intertwined. And I believe the state's going to cite them as a reason for admission of that evidence. And I think when I make my argument, I think the court's going to recognize that that's not what happened. And those cases are far different than this case. I digress because we're not talking about admissibility of evidence, we're talking about severance. But it's hard when you're laying out an argument like this and you're seeing this boatload of factual evidence dump into this motion for severance that I think is a circular argument. And I think the state's attempt, and I don't mean it in some unethical manner, but their attempt to flood this motion with all these factual statements is not what the court needs to consider when it relates to severance. What I will tell the court, though, is that their reliance on some of these cases, even though ironically they have the same underlying retaliatory historical basis that this case is alleged to have. I think the findings and the rulings of those courts are enlightening as it relates to that. As I said earlier, Judge, and I'm getting to the end, even a seasoned detective, and I don't mean Jacksonville gang detectives, although they are detectives and they've worked their job, you can see in the other motion what their historical training and experience is. I've set that forth with particularity in one of the other motions. We have a homicide detective here in Tampa who handled the investigation. The court's aware of Detective Ramos. Even Detective Ramos, during the course of this investigation, made some investigative errors that he ultimately corrected himself and ultimately said, no, what I thought might have been the situation turned out not to be so. And to his credit, he made those observations both in his reports and under oath. And I bring this to the court's attention because I think that it's inconceivable that jurors are held to a higher standard than law enforcement might be and are capable of disregarding compelling evidence that is attributable to one defendant and not the other. And if this court limited the scope of admissible evidence, there's no feasible manner to ensure that other parties might not open the door to otherwise inadmissible evidence during testimony or during cross-examination. And we have to respect and understand and make our decisions, in my humble opinion, based on those factors as well. Because again, what we are looking at is what allows Mr. Murphy to have a fair determination and not be prejudiced by evidence that would otherwise be inadmissible to him. I have suggested to the court that if you are not convinced that severance is proper, that we need to have separate juries. And although I don't think that's a cure, and I think I might be the only person, and I could be wrong, that tried a case in Hillsborough County with 3 juries. I know there's been many, many times that there have been 2 juries. I tried a case with 3 juries.
Is that Cass Castillo's case?
Yes, Judge. I had one of the co-defendants in that case. Judge Fuente had one as well, and Mr. Castillo prosecuted that case. Nightmare.com. And certainly, very fortunate, I will say, the court's probably going to say, well, it didn't come back on that issue, and it didn't. But it was a miracle, and it probably could have or should have. But in that light, the bottom line is that I can only anticipate amplifying that by another one.
Well, didn't you have Bruton issues in that one?
We did. It wasn't as much the reason for the separate juries that I was referring to. It was more just the logistics and the fact that it occurred, and to the extent that there's not a problem. And I know the court has said, and I have no reason to disbelieve the court. If we had to, and that's what I choose to do, we'll find a way to make it happen. And I'm not suggesting the court can't do that. I'm just suggesting that it brings ripeness to the inevitability that something could go wrong in the very slightest of circumstances, much less something more magnanimous. So that is obviously the fallback position. Finally, Judge, guilt phase instructions don't cure penalty phase prejudice. I point out to the court in the motion that in the guilt phase, 3.12c instructs the jury about how to consider evidence independently with regard to co-defendants. Certainly not a cure-all by any stretch of the imagination, but there is an instruction that references what the law tells the jury to do. No comparable safeguard exists in penalty phase instructions. To the contrary, the instruction directs jurors to engage in a holistic, qualitative weighing process. They've now heard varying amounts of evidence against varying defendants in the guilt phase, so you have to ask them to sanitize themselves and continue to compartmentalize in that particular circumstance, which presumably and hopefully they do in a guilt phase. And then in a penalty phase, the process of weighing aggravating factors and mitigating circumstances is not a mechanical or mathematical process. In other words, you should not merely total the number of aggravating factors and compare the number to the total number of mitigating circumstances. The law contemplates that different factors or circumstances may be given different weight or values by different jurors. Therefore, in your decision-making process, each individual juror must decide what weight is to be given to a particular aggravating factor or mitigating circumstance against A, B, C, D. Some, presumably defendants, in the event that there's an adverse verdict, may have much more mitigation than other defendants. Although the aggravators are similar in nature on paper, they are not similar in nature as to, let's say, what the prior felonies are, what a person's individual prior makeup, prior history, whether it be familiar, whether it be intellectual, whether it be school-wise, whether it be psychological. To ask a jury to deliberate in this fashion as it relates to the lives of these four individual defendants is, in my estimation, too much. I think it is fraught with an inability to continue to compartmentalize not what is evidence as to their guilt, but those factors that would be needed to determine whether someone should be put to death.
But isn't that what happened in the Hunter case? Right? Hunter had multiple co-defendants, right? The state was seeking death as to all three?
Yes,
right?
Judge.
So it's not unheard of?
Not unheard of.
Okay.
Not saying it's never been done. Saying it's fraught with problems, and certainly, now, and of course we have an additional, certainly everything that happens in multipliers changes likelihoods, in my opinion, but the court's correct in that regard. Don't consider that co-defendant's extremely lengthy and historical violent criminal behavior. Don't consider that. Don't think about it. They've just been convicted as a group. They've just been certainly, and again, we're talking about evidentiary issues that are not ripe yet because the court hasn't ruled. Acts that certain people committed during the course of a potential conspiracy that others didn't. Although the law might suggest that if it happens during the conspiratorial time frame, it should be considered against all of them. Let's separate that now when we're talking about whether someone should live or someone should die, and continue to hope that all of now this emotional type evidence that's going to be submitted can be weighed properly. Judge, I'm not going to take any more of the court's time on the perils of the penalty phase deliberations. I have set it forth with a little bit more particularity in the motion, and it stands on its own. There are some cases cited, Judge. Although the court has discretion to order separate juries to avoid severance, doing so will result in significant practical difficulties. Florida courts have emphasized that, I'm going to say it without even looking at you, must take great care to ensure that each jury hears evidence relevant only to its defendant. and that's as it relates certainly to multiple juries. There are cases that are cited that stand for that proposition. At the end of the day, Judge, this is not a routine joint trial with overlapping proof. The state's most compelling evidence is directed at co-defendants, and it invites guilt by association. There are several different categories of inadmissible evidence, co-defendant evidence, that I believe is inadmissible as it relates to Mr. Murphy. And a group narrative in this case is clearly a concern, and severance is required under the rule, or alternatively separate jury panels, when the defendant's constitutional right to an individualized determination at both phases is not afforded.
Mr. Gonzalez.
I would love to talk about the evidence as suggested by the state and its propriety and its weight.
Let's not.
And its defensible.
It's
but
not. Listen,
nonetheless,
that's why we have juries.
As I stated in the beginning, Judge, that's not where we're at. What I can and what I would like to talk about is, again, inextricably intertwined. It's a word that's used.
I know, but we're getting, and that's fine, but we have a whole separate motion dealing with what's going to be admissible. And I feel like at this juncture, we should kind of hold that in abeyance until I've made my ruling on what's going to be admissible with regards to the gang history coming in.
Well, let me then, Judge, you've heard my argument as relates to the severance. I, quite frankly, am glad that the state would like the court to be hyper-vigilant in wrapping its arms around the Richardson case, because the Richardson case is not this case. It's so far from this case, other than the fact that it has similarities in players, similarities in historical
jurisdiction,
similarity in some of the things that the state has alleged are, again, inextricably intertwined. But let me first say that Richardson doesn't end with Richardson. It's Richardson and Hayes. And you know what happened with Richardson and Hayes? They got severed. And so the first thing is that this murder took place and co-defendant Richardson and Hayes were together. It was unfortunately a drive-by shooting where a child was killed.
And Mr. Gonzalez, I'm not trying to cut you off, I'm really not, but I feel like that discussion, at this point, what I want to hear from you, all right, is what would be the evidence that the state is seeking to admit that would be inadmissible as to your client if he were to go to trial alone?
Judge, what I want to tell the court is that if the state is relying on Richardson to tell the court that this inextricably intertwined evidence should not create a severance, because that's what the Richardson court said, you need to understand that this evidence was, there were individuals, 4 or 5 of them, that testified, to that inextricably intertwined evidence. They testified, they had live witnesses that said, I was with him when he did this. I was there when he had this gun. I was there and I was a member of the gang and he was a member of the gang. Again, the reliance upon the state's case here is squarely in the hands of law enforcement. Richardson and, of course, Hayes in his severed trial all had direct evidence being provided to the jury by individuals who were corroborating the evidence against Richardson and against Hayes. I would tell the court that if you read Hayes closely, and I really think that you need to,
I have,
when it comes down to the issue of severance, it is completely 180 from what the state's evidence is and what the state's arguments are for severance in this case, or the lack of it.
Okay.
So I would tell the court, again, I don't believe that any of the evidence found as it relates to the search warrant of Gathrigh's house, the vehicle of Gathright, the search of Chance's house, the interactions with Chance, whether it be by Instagram, whether it be with Ms. Andrews, whether it be to third parties, about his involvement in this and any other violent crime, as it relates to, again, as the courts noted, the celebratory issues, as it relates to vehicles that came down from Jacksonville that the state has no evidence that Mr. Murphy was in, vehicles that left Tampa to go their various directions. Nobody left out of the same parking lot. They didn't leave together. I think that fundamentally,
so your position is that if your client went to trial by himself, none of that evidence would be admissible?
No, it would not. I believe that. No, I believe that. I believe it's not part of any conspiracy. It's not part of any actions by a principal. And of course, I'd have my arguments as to both of those things on another day at another time. But essentially, again, the gang affiliation evidence.
Okay. I understand. Listen, I do need to give the others a chance to argue their motions, and I didn't give you guys time limits. I may start giving.
Yes, Judge, I understand.
But would you agree with me that if I make the determination, which you will disagree with, but if I make the determination that there is evidence regarding the previous history between these gangs, that it is inextricably intertwined as it relates to all four of the co-defendants, then there is not a basis to sever as to that issue. Do you at least agree legally based upon the case law? You may not agree with my decision, but do you agree that's the posture that we would be in regarding severance?
Based on what issue?
On the inextricably intertwined evidence, the history or the pre-events, not the homicide, but the pre.
Well, if the court lets it in, then I would suggest that that issue then would not be an issue for severance if the court lets it in. I mean, if the court lets it in, I would certainly take issue with the court's ruling,
right?
Because I don't think it should be admitted as to Mr. Murphy based on the totality of circumstances.
Okay.
But that would certainly just be, one prong of what I believe severance is buttressed on, and that certainly would be evidence of prior acts, and I don't mean just gang violence. I mean just acts that Mr. Chance might have allegedly been involved with that the state's going to try to introduce, as it relates to statements that he made at various different points in time. I believe that the forensic and the physical evidence is another reason why severance should be granted as it relates to Mr. Murphy. All of those, again, we've talked about post-fatality or post-homicide statements. That would create a basis for the severance, as I've argued. And then finally, Judge, and certainly not least in any way, shape, or form, would be the culmination and the cumulative evidence of the prior history.
Okay. All right. Thank you, Mr. Gonzalez. All right. Who wants to go next? Mr. Counsel for Mr. Chance or Mr. Gathright? Do you guys have a preference?
I can go, Your Honor.
Okay. Very good.
Going down the table.
Sure.
So, Your Honor, I'd just like to adopt all of Mr. Gonzalez's very eloquent arguments, and for the sake of time, not go back over those. I would point out, Your Honor, I recognize, of course, severance would not be convenient, it would not be efficient, but this system is not designed to be efficient or quick. It's designed to be fair and just. And I think the only way any of these defendants are going to get a fair trial in this case is to be tried separately.
And do you agree there's no Bruton problem as it relates to your client?
I do agree, but that's only part of the analysis, Your Honor. I think the rule is if it's appropriate to promote fair determination of guilt or innocence. And one quote I put in our motion is that it's from the Menendez case from the Florida Supreme Court many years ago. Severance should be granted liberally whenever potential prejudice is likely to arise. And I think we just got a little glimpse of the potential prejudice that's likely to arise in this case. I started to quote one of the things Mr. Gonzalez said early on, talking about the search of Mr. Gathwright's car, that there were a litany of firearms, magazines, ammunition, yada, 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 found. And we heard many, many times about what's found in Mr. Gathwright's car. And I'm not suggesting Mr. Gonzalez by any means is doing anything inappropriate. He's effectively advocating for his client.
Correct.
But in doing so, he's now essentially implicating Mr. Gathwright.
I know, but the courts have said that's not enough to get you a severance. Just because you're pointing fingers at each other, that's not enough.
Well, I think it's a case-by-case basis.
Correct.
And I think that it really depends on each individual case and the circumstances. And we have 4, I would suggest, very differently situated defendants. And one thing I would point out as well, Mr. Gathwright's name never, from what I can tell, ever surfaced in connection with that prior shooting of Mr. Jones until the casings were found. So it's not like, he's being investigated by Jacksonville. I was going to mention in a moment, but none of these Jacksonville deputies even knew who he was until Tampa contacts them. But now, obviously, as we see, Mr. Gonzalez is going to be bringing up, as he rightly should, that his client has nothing to do with this other investigation. And that really brings up an issue that's probably individual to Mr. Gathwright, because he's a little differently situated in that he has no connection at all to this gang. We took a week's worth of depositions of Jacksonville officers, I believe they're all detectives, and at least a couple of them are designated as gang experts. None of them knew Mr. Gathwright or even heard his name, as I recall, until TPD contacts them in connection with this. There's no evidence that he was part of this gang. The state has not alleged that aggravator as to him. And in all candor, I'm going to argue at every opportunity that he's not part of the gang. But the risk we run, number one, that I think raises issues for the other defendants, but the other risk we run, like the Hernandez issue, is that, and I took a quote from Hernandez, but I believe that the issue they were concerned about was that the jury, when they're looking at the prior acts of the brother that come in against the co-defendant, the jury certainly could have attributed to Hernandez as a possible participant in these acts, and that may have contributed to the verdicts of guilt. That's what I'm concerned about here, is that they're going to hear, and I believe it's frankly going to be a feature of the trial, the gang connections and the drill rap videos that Mr. Gathwright has nothing to do with. They're just going to assume, well, he must have been in this gang. He must have taken part in all these alleged prior acts. And if he were tried separately, maybe there'd be some evidence of the gang connection. Frankly, I would probably want some of the evidence to come in. Because again, he's not part of that. And that is the motive for this whole alleged homicide. But the problem in the joint trial, I think, is it's going to become a feature. We're going to see all these drill rap videos, I expect. We're going to hear from gang experts about this gang. The jury is going to have to compartmentalize that, hopefully see that he's not a member, but the risk, like the court was concerned about in Hernandez, is that they're going to just assume, well, he must be, because we've heard all this evidence. We've heard about all these prior acts. It was, frankly, a feature of the trial. He must have been part of it and just never got caught. That's the concern we really have, I think, at the heart of it. As to individual pieces of evidence, Your Honor, I think one that you pointed out are these post-homicide text messages. I don't believe
I've already pretty much ruled on that one.
Yes, Your Honor, I agree. There's another one that really, I think, has just kind of recently come up, and it's not mentioned in the response to Mr. Gathwright's motion to sever, but it is in Rashad Murphy's response, that apparently on the morning of October 7th, 2023, there's that's when I believe the first shooting of Mr. Jones occurred, or shortly after, but it states in there that there's a recorded video chat conversation that occurred on Spaces video chat room on X on June 6th, in which co-defendant Isaiah Chance asked the victim, "Hey, Foolio, your foot okay, cuh?" and stating he has bigger fish to fry. And then this is apparently the Spaces chat, which is something I was not familiar with, is public. And then it states that on June 6th, co-defendant Chance and Victor Jones continued to argue back and forth on the social media platform. And then Rashad Murphy texts co-defendant Sean Gathright. It states, Gathright and Chance are best friends, and Murphy instructs Gathright to make sure that Chance doesn't ruin the plan, letting him get worked up because they've got bigger things to tend to. So I have been through the iCloud dump for many, many hours, and I'd never seen that. And it never came up that I saw during the 2 days of Detective Ramos's deposition. But in any event, I'm pretty confident that Mr. Gathright, if that was sent to him, did not respond back to that. So now we have another instance of something that apparently Rashad Murphy allegedly texted him that I don't believe would be admissible in a separate trial, and frankly could be viewed as pretty damaging evidence to the jury. That I don't see how it comes in unless there's a context or a foundation established for a co-conspirator admission, but without any response from Mr. Gathright, I see no basis for it. I don't know if that's something the state's intending to admit, and quite frankly, I had never seen that until yesterday when Mr. Gonzalez called me frantically and mentioned.
And so you referenced in the state's response, what page?
Not in Mr. Gathrought's response.
Right.
It's in the response to Rashad Murphy on page 5.
Okay, let me just take a look.
Sub F on page 5.
Okay, I see it.
So that, again, Your Honor, when you're asking for individual examples, that's one that is particularly concerning to me, and I don't believe would be admissible if Mr. Gathright were tried individually, especially if there's no response, which I don't believe there is. And then last, Your Honor, just to kind of highlight again, this isn't the typical case because this is a death penalty case, and we're basically going to have 2 trials for each defendant in this case. Not only do they have a right to a fair determination of guilt, but they have a right to an individualized sentencing determination. And as Your Honor pointed out, there have been Florida Supreme Court cases that have found that it was not error when some co-defendants were tried separately in death penalty cases. But again, I think it's a case-by-case determination. And here we have 4 defendants on trial. There's going to be very different, I believe, aggravating circumstances at issue. The probably most significant one is the gang aggravator that, again, is not alleged as to Mr. Gathright, but I believe is alleged as to the other 3 defendants. We're going to have to hope that the jury, again, can compartmentalize that and not assume that it must apply to Mr. Gathright as well, which I think is a very dangerous thing to presume, especially when we're talking not just 2, not 3, but 4 defendants in this particular situation. And the other difficulty that I see that I don't really know if cases have addressed, but we don't really know what other defendants are going to present for mitigation. We don't know how the jury is going to compare each defendant. I believe there's a plethora of mitigation as to Mr. Gathright, but I don't know what we're going to hear about other defendants or how the jurors are going to potentially weigh that if they're being asked to decide the sentence as to each individual defendant, and potentially not just weigh aggravators from the state and mitigators from the defendants, but potentially weigh the mitigating factors that each defendant presents in comparison to one another. So for all of those reasons, Your Honor, I think that this is a very dangerous situation if this case is to go forward as a joint trial, and I think the only fair way to ensure a fair and just determination of each individual defendant's, not just guilt or innocence, but if we get to penalty phase, the appropriate sentence is to try them individually.
Brief, because you've heard mostly everything, and I'll adopt Mr. Wise and Mr. Gonzalez's motion, and I'm sure the court's read my motion. A couple of things I wanted to bring up. You talked about the McCrae case and improperly influencing, and that's one of the issues we would have. And some of the items that I believe it would not be admissible against Mr. Chance. You talked about Davion Murphy's statements. We would also bring up the casing found in Mr. Gathright's car that links to the 10-7 attempted murder of Mr. Jones. There's no link to Mr. Chance in that, other than rumor and the attempted murder happened in close proximity to allegedly someone that Mr. Jones used to date. And that's the only connection. The casing has no connection to Mr. Chance himself, as well as anything found in the search warrants of Mr. Gathwright's home. We would also argue that any aggravators that would be heard outside of CCP would not be applicable to Mr. Chance as well, including gang aggravators, because there's different gangs involved here, so the jury would hear different gang aggravators and that don't involve ATK. Further, Mr. Chance is not in any of the drill rap videos. His name is not mentioned. Mr. Jones does not ever diss Mr. Chance in any of the drill rap videos. He doesn't diss Tilly in any of the drill rap videos, so we would argue that any of those videos should not be admissible against Mr. Chance because they do not provide motive to Mr. Chance specifically. He's not mentioned, he's not in them. And I know you want to get into this later, but any mention of 1200 or bully gang, we would argue it's applicable and not admissible and is prejudicial against Mr. Chance, as he is the state's going to try to attempt to prove that he's a documented member of ATK, but only ATK. So we would argue that any mention of 1200 as proof of motive, or bully gang, which is a alleged subset but not a member of 6 Block, would be inadmissible against Mr. Chance. And we would also argue that all that would end up becoming a feature of the trial, as Mr. Wise said. All the prior inextricably intertwined stuff, which I know we'll get to a different day, and it will be impossible for the jury to put that aside, especially when we're talking about, again, gang that even the state would admit that Mr. Chance is not a member of, which would be 1200. And as Mr. Gonzalez stated, a lot of these prior murders are unsolved. And while the state may bring in witnesses from law enforcement to talk about the specifics of those murders, those witnesses will have no idea who committed those murders because the state and the detectives up in Jacksonville still have no idea who committed these murders. So based on that, and based on what I've written in my motion and what you've heard here today, we believe that a severance of Mr. Chance's case from this other co-defense is appropriate and necessary in this case.
Okay, very good. Thank you.
All right. Hey, thanks for making us. We just hit 22,900 subs, so appreciate that, you guys. Thank you so much. And if you can hear my voice, go ahead and hit the like button. Would really appreciate that as well. We have more pretrial hearings to watch. So that was part one. Excuse me. That was part one of them trying to sever. So we're going to go to part two. They must have taken a break. So we're going to jump over to part two. We're going to be doing pretrial hearings all day today, and then also Monday and Tuesday. Live trial is scheduled to start right now, Wednesday or Thursday.
So State, do you want to?
Still hasn't. They still haven't finalized the jury yet. They're still working on that. So if you like what you're seeing, definitely stick around today, and then join us on Monday and Tuesday as well. All right, so let's continue on. This is part two. This is still from the same day. They're asking for a separation, a severance. This is from February 26th of this year, 2026. All right, so let's continue on.
Have all of the defendants, the remaining co-defendants, make their argument and then respond to all of them, or you want to do it one by one?
I prefer to do one by one.
Okay, that's fine. So it seems to me, before you get going, that what this really comes down to, and the case law is articulated, the precedent, the binding precedent, is articulated pretty clearly in the McCrae case, McCrae versus State at 416 Southern 2nd 804. And that was a Florida Supreme Court opinion, and they stated as follows. The object of the rule is not to provide defendants with an absolute right upon request to separate trials when they blame each other for the crime. Rather, the rule is designed to assure a fair determination of each defendant's guilt or innocence. This fair determination may be achieved when all the relevant evidence regarding the criminal offense is presented in such a manner that the jury can distinguish the evidence related to each defendant's acts, conduct, and statements, and can then apply the law intelligently and without confusion to determine the individual defendant's guilt or innocence. The rule allows the trial court, in its discretion, to grant severance when the jury could be confused or improperly influenced by evidence which applies to only one of several defendants. A type of evidence that can cause confusion is the confession of a defendant, which by implication affects a co-defendant, but which the jury is supposed to consider only as to the confessing defendant and not as to the others. A severance is always required in this circumstance. In situations less obviously prejudicial than the Bruton circumstance, the question of whether severance should be granted must necessarily be answered on a case-by-case basis. Some general rules, however, have established, specifically the fact that the defendant might have a better chance of acquittal or a strategic advantage if tried separately does not establish the right to a severance. Nor is hostility among defendants or an attempt by one defendant to escape punishment by throwing the blame on a co-defendant a sufficient reason by itself to require severance. If the defendants engage in a swearing match as to who did what, the jury should resolve the conflicts and determine the truth of the matter. None of the co-defendants in this case, the Hunter case, made a Bruton-type confession, and the evidence presented was not so complex that the jury would be confused by it and incapable of applying it to the conduct of each individual defendant. So that would be kind of juxtaposed to the Hernandez case, which we've already discussed pretty extensively. The Hernandez case, as we discussed, had to deal with the co-defendant brothers' prior drug transactions coming in during the middle of the trial. The other case would be the Miller case, which I think some of you cited too, 756 Southern 2nd, 1072. It's a 4th DCA opinion. And in that case, one of the co-defendants had contacted the victim and apologized and also offered to pay the victim money to not proceed forward with charges. And in that case, even though it was not per se Bruton, the 4th DCA held that the acknowledgement of guilt by appellant's brother through his apology to the victim, that's another brother case actually, by appellant's brother through his apology to the victim and the offer to pay him to drop the charges undermine both defendants' theory of self-defense. Okay, so I guess just to start off, just to confirm with the state, you're not going to seek to admit these post-homicide statements by an inmate, Shane Payne, these are intercepted phone calls to Tayshawn Schatz Thomas or a phone call to LaShawn Walcott, correct?
That is correct, Your Honor.
Okay, so we don't need to worry about that. So my next question would be to you, would be as far as statements go, the celebratory statements made by Davian Murphy. These would be 2 messages sent from Mr. Gathwright's phone between 12:58 p.m. and 1:01 p.m. on June 23rd, 2024, hours after Mr. Jones's homicide. And the first message is, "I'm coming home, my thirst is quenched, pop a bottle of Don Julio today, Murphy." The second message is, "I'm coming home, my thirst is quenched, I love you, Murphy." All right, so it's not Bruton, but do we start to cross over into being a Hernandez or Miller issue?
Judge, I do not believe so, Judge. I believe that again, that's direct evidence against Mr. Murphy, and that is also inextricably intertwined evidence and gang evidence, Judge. And I do agree with McCrae that situations less prejudicial than Bruton is a case-by-case basis, but I still think that the court is on firm ground and not severing these defendants. And when you look at Victorino and you look at Hunter, those were death penalty cases where you had multiple 3 defendants. And when you talk about being complicated, that case, they had 6 murder victims, as well as it was, I believe, a 19-count indictment. So there were many more charges in that case. And this is not a RICO-type situation where jurors are going to have to be looking at Excel spreadsheets and sifting through that type of complicated evidence. This is a simple and straightforward gang rival case, Judge. And when you're looking at Victorino and Hunter, those are Florida Supreme Court cases. And in those cases, defendants were asking to sever out, and the trial courts denied those motions to sever, and those were both upheld by the Florida Supreme Court. And likewise, in this case, we have not 3, we have 4. There are no brutal issues which would require severance. And when you talk about, and the only reason why we went into the litany of factors, you, Judge, you sat in on the motion for pretrial defense, for pretrial detention for Rashad Murphy, and that same litany of facts going into the rival gang, as well as all of the things that the co-defendants, every defendant in this case did, was relevant, because this is a case where it was a group crime. They are charged as principals, and they are going to be held responsible for every action that their co-defendant did, because we can prove and show that they all intended for the crime to be committed, and they all did some act and participated into this crime. So when we talk about overlapping evidence, and Your Honor, you presided over one of the co-defendants that was severed out, this wasn't a case where only the evidence was admitted only as to what Ms. Andrews did. All of the evidence of all of the co-defendants was admitted. So when we talk about the evidence, with all due respect to Mr. Gonzalez, all of that evidence, all of the ballistic evidence, all of that evidence is going to come into evidence against Rashad Murphy, just like it will against Isaiah Chance, Sean Gathright, and Davian Murphy. And why we put in all of that facts into every single response into the pretrial detention motion is because they are charged as principals. So when we go back to the issue of severance, and when we talk about Hunter, the second DCA case, Judge, I think was the best argument for the defense, where
Hernandez.
What did I say, Fernandez?
You said Hunter, but it's Hernandez.
Hernandez. The Hernandez, the second DCA case, where they severed it out. And what was key in that Hernandez case was, that it was so prejudicial, was that the evidence that was admissible against his co-defendant, the co-defendant brother,
right,
would not be independently admissible in his own trial.
Well, isn't that really the crux, though, of the whole issue?
Yes.
Is that I would have to find that there is evidence the state is seeking to admit that would be inadmissible against the co-defendants. And the reason why I'm going to go back to these post-homicide statements made by Davian Murphy. They're not co-conspirator statements because the conspiracy's over. Mr. Jones is dead. So, and these statements did not come in, that I recollect, during the trial of the co-defendant Alicia Andrews. So, these statements, so I'm asking you, the state is seriously intending to introduce these statements or these telephone messages, these text messages, and are you telling me that if defendants Rashad Murphy, Sean Gathright, and Isaiah Chance were tried separate from Davion Murphy, would these be admissible? They don't come in and are co-conspirator, so why would they be admissible against them?
Judge, I think that it is because it is inextricably intertwined. If the evidence of motive is, and so that is also one of the reasons why we did provide the court with the Richardson case and all of the cases regarding to inextricably intertwined. And it's not just inextricably intertwined that that all of that evidence came in. It also came in as motive, and it came in as intent. And we are going to be able to provide evidence that this was evidence of that motive, Judge.
Yeah, I don't know. I don't know that this statement, if they're tried together, if this statement by Davion Murphy is coming in, just for that reason. Just so you know, I don't think it is. So the state may have to decide what you want to do. Just throwing that out there as one example of evidence that would seem to violate the Hernandez precedent in that it is prejudicial, and it's not admissible against the other co-defendants if they were tried separately. So I'm just letting you know.
Judge, I also want to talk about conspiracy and when a conspiracy ends. I know what is alleged in the indictment, but we are talking, there are two vehicles.
I know, but the conspiracy ends when Mr. Jones is dead. That's when it ends. Conspiracy's over. The object of the conspiracy has been achieved. He's dead. Because I researched this issue, so I'm very aware of the case law on it. So once Mr. Jones dies, there is no further co-conspirator admission of any statements. The conspiracy is over. So, anyway, okay, so go ahead.
Judge, going back to the question of whether or not they need to be severed out, and talking about Victorino and Hunter, again, in those cases, the trial court did not allow separation, did not find that there was anything so complicated about that evidence. And I think, Judge, that is something that is critical in this particular case. I don't think that there is anything that is so complicated about this case. And I know that Mr. Gonzalez had mentioned and was talking about the gang evidence. That type of rivalry is inextricably intertwined. Richardson is basically a primer for this case, and I do think that it is very similar. In that particular case, there were 6 other incidences of violence that came in that case to show basically, again, motive, intent, but also to show the jury an accurate depiction of the facts that were leading up to the offenses that occurred in this particular case. And when you look at the evidence that we are going to be showing, not just through gang expert testimony, we are not going to just be showing evidence through hearsay. Also listed with those gang experts in Jacksonville are first responding officers or officers that investigated each one of those incidences. So the jury is going to be able to know that those incidents really happened. And all of those incidents go to not just inextricably intertwined, but it goes to motive and intent, which was the other area why that evidence is critical in this particular case, because it shows the back and forth retaliation. And not just the back and forth retaliation, the Richardson case showed 6 prior incidents. They also showed all of the different rap videos that showed the motive. And in particular, Judge, there is going to be rap videos of Mr. Jones, the victim in this case, which clearly, again, it all goes to motive. I think Mr. Gonzalez says, like, all of this evidence wasn't going to go to motive. It clearly is going to motive. The victim in this case is known for producing these drill rap videos where he specifically is mentioning people that are associated or in the gangs that have been killed who all of the defendants know. And so it's not just the fact that you have 1200 or ATK. It is going to be clear based on the expert gang testimony that those two gangs are allied, and based on the video that Mr. Jones himself put on or put up on Instagram, that is the motive why all of the defendants in this particular case had a reason and did in fact want him dead. And so, Judge, going back to Hernandez and any concern about those prior instances, we believe it's the state's position that all of those instances are inextricably intertwined, as well as
each defendant, right? That's what you're saying.
Yes, and that it would come in against each defendant. So there is no reason that you would need to do a severance. And when you're talking about the penalty phase, just as Your Honor said, in Victorino and in Hunter, those were death penalty cases, and there wasn't anything so complicated about that 6 first-degree homicide count, 16-count indictment, that the jurors couldn't make a distinction and separate out the evidence to each particular defendant. And that's exactly what happened in that case. There were death recommendations by the jury as to some of the defendants, and then a recommendation for life as to other. And they also made distinctions as to who should get death with regards to a specific victim. So to suggest that where we have one victim of first-degree murder, that a jury would not be able to make a distinction, Judge, we believe that those two cases clearly show that juries can do as they're instructed, and there are instructions specifically that address that concern, that they would be able to separate out the evidence and make a decision based on what evidence applied to each defendant. I know that there are 4 remaining co-defendants, but again, that does not make this case more complicated or overly confusing or complicated that a jury could not sort it out. I know Mr. Gonzalez said he is not aware or familiar with social media, but that is something that would be for the state to be able to present to a jury in a clear way. There isn't anything so complicated about 4 defendants who actively grouped together to commit this crime. And so all of the inextricably intertwined evidence that we have talked about is relevant and would come in against Mr. Murphy. And again, I do want to speak to Mr. Gonzalez said, like, one of the other considerations in McCrae and some of the considerations for severing, where you're looking at independent evidence. There is going to be independent evidence and proof of the defendant's guilt, each one of the defendant's guilt, how they are responsible and tied to this crime, including, which Mr. Gonzalez forgot to mention, the fact that the defendant is the one that actually obtains one of the suspect vehicles, the silver Chevy Cruze. We know exactly how that vehicle is obtained, and it is, again, through a connection that Mr. Murphy has, that his particular client has, that he's the one that obtains it. That vehicle is driven down to Tampa. It comes in tandem without going to all the facts that Your Honor knows. That is just one of the pieces of evidence, as well as that video footage that is similar clothing worn by that individual, and the fact that all of the crime, all of the surveillance is captured on video, that is admissible against every single one of them, and the circumstantial nature of the case and the fact that they are principals, all of that evidence is going to come in, including evidence of the defendant's gang activity, which is not just based on hearsay or word on the street. There is documentation of those acts that occurred in videos, that those rap videos that we've heard about, where he actually was shown, and just because he didn't see the handshake or didn't understand the handshake, that again is for a jury to determine. But those are things that are going to come into play, and he has been certified, and I agree that the jury is going to make the decision whether or not he's a gang. But the reason why all of that is in there, and the reason why we talk about the inextricably intertwined and the motive evidence, is because that is what makes all of the evidence of those inextricably intertwined incidents admissible against each and every one of the defendants in this case, Judge. And going back to, I understand your position about the celebratory. I'll certainly talk with co-counsel about whether or not we believe we need those, or we'll make a decision about that. But that is evidence, again, that we want to come in, because there is also evidence, when we talk about the ballistics evidence in this case and the circumstantial nature of the case, the entire trip from Jacksonville and how all of the defendants get to Tampa is evidence. How both of the vehicles leave Tampa and go to Polk County and get recovered, and the evidence that is uncovered there, and one of their co-defendants then immediately goes to Jacksonville in another vehicle where there is additional evidence recovered in this case, and where there is evidence that is directly linked to this defendant, all of the defendants back in Jacksonville, and it is all of the defendants who eventually get back to Jacksonville, and all of the video surveillance evidence that shows at the Airbnb and then at, again, co-defendant Sean Gathrights' house, which includes that this defendant, along with testimony from an Uber driver that he drove and picked up the defendant from that Airbnb in Tampa back to Jacksonville, and all of the consciousness of guilt evidence when those vehicles are seized, including this particular defendant when he is found in the very exact same suspect vehicle utilized in the hunting and killing of the victim, Mr. Jones, in this case. So we believe all of that evidence is admissible against all of the defendants because this is a circumstantial case and they are responsible for all of the actions that they did in pursuant that assisted in this case, which included getting rid of evidence, which included removing both vehicles from Tampa to other locations where we weren't able to get them until days after the homicide was committed. So all of that evidence, we believe, should come in and shows why these cases should not be severed.
All right, well, in the way that I view this, there's two separate kind of tranches of evidence. So when we're using the term inexplicably intertwined, as my understanding is, we're talking about the pre-homicide gang violence history, and I'm assuming you would concede that if for some reason I determine that some of what the state seeks to admit as their inextricably intertwined evidence is only admissible as to some of the defendants and not others, then we've got a severance issue, correct?
Yes, Your Honor.
Okay, so if I find that all of the proffered evidence, or if I say to you, listen, I believe that this is the proffered evidence that would be applicable and would be inextricably intertwined as to all defendants, then we don't have a severance issue as far as that goes, right?
Yes.
Okay. And then we have this separate issue of evidence that would be admissible as part of either the conspiracy or as principles or as direct evidence, right? That's a separate tranche of evidence, so to speak, right?
Yes, Your Honor.
Okay. And then that would require kind of the same analysis. Is there any of that evidence that would be inadmissible as to one of these defendants if they were tried separately? That's what my inquiry needs to be, correct?
I agree, Judge. But
Okay.
I also think that because it is a principal case, that evidence would be admissible in their trial.
I'm not saying it is or isn't. Okay. I'm just trying to lay the framework.
distinction.
Yeah,
Okay.
make the distinction between the gang history inexplicably intertwined, evidence going to potential motive versus actual evidence that was part of the conspiracy and as principles to the offense. So, okay. Okay, very good. Thank you. Thank you, Mr. Wise. So, State, what is your response to that on, it is on page 5 of 20 of the State's response, talking about it, because I don't recall this, did this come in the Andrews trial?
Judge, I don't believe that it came in the Andrews trial, but Judge, that there is evidence of that conversation, and the defendant, Mr. Gathright, does respond, and this occurs before the offense when Isaiah Chance is in a conversation with the victim discussing the fact that he was shot in the foot before, and there is direct evidence tying Mr. Gathright and Mr. Chance to that October 7th motive evidence where the victim was shot in the foot. And so, Judge, there is dialogue from Mr. Gathwright's phone where he and Rashad Murphy are then discussing, because that is a social media site on Twitter that anybody can watch. So as that is going on, you immediately have this conversation by the defendant. It predates the offense, so certainly that qualifies as a co-conspirator statement, Judge.
And just so I'm clear, so there is this Spaces video chat room on X on June 6th of 2024, correct?
Yes, Your Honor.
In which Isaiah Chance has asked Mr. Jones, hey, Foolio, your foot okay, cuh? And I guess he also states that he's got bigger fish to fry. And then on that same day, as Mr. Chance and Mr. Jones are arguing on this social media platform, defendant Rashad Murphy is texting the co-defendant, Mr. Gathright, and Rashad Murphy instructs Gathright to make sure that Mr. Chance doesn't ruin the plan, letting them get him worked up because they have bigger things to tend to.
It says bigger shit to tend to verbatim, Judge.
Okay.
and some other cuss words. And then there is a response where you can like that. So Mr. Gathright likes that statement. And then he responds, ain't heard from bro, TD, but I'ma check it with So there is directly a response. And then there's another response from Mr. Murphy where he says he probably not gonna pick up, he on IG letting these, and then there's a bad word, getting out of character. So clearly referencing this conversation that is happening, and law enforcement is watching as well and recording that conversation that's happening on X.
Okay. And remind me, what was the day of the homicide?
The June 23rd.
June 23rd. Okay, so this conversation is happening June 6th.
Couple of weeks prior.
Okay, and so it involves, as we discussed, it involves Mr. Chance, or aspects of it involves Mr. Chance, Mr. Gathright, Mr. Rashad Murphy, but not Davion Murphy. I don't see him referenced in this interaction.
No, Your Honor.
Okay, so I guess my question to you is, would this be admissible against Davion Murphy, and if so, under what theory?
Because he also is a co-conspirator, Judge.
Okay, so you're saying this comes in via co-conspirator?
Yes.
Hearsay.
And Judge, with regard, and I know that you had said that the conspiracy ends with the death. If the state can provide, Your Honor, with any sort of case law having to do with flight after the crime,
sure.
Would we? Okay.
Yeah,
Thank
that's
you,
different. And it was, my comment was co-conspirator statements. Co-conspirator statements are inadmissible, my understanding, once the objective of the conspiracy is reached. Okay? It's co-conspirator statements.
All right, so that's them trying to get the defendants severed. We know that did not work for them, and they will be tried together. Alicia was the only one that got tried separately, and her trial was came to a verdict Halloween night 2025. All right, so now we've got a motion to suppress evidence. So this one's a long one. This is 6.5 hours, but there's probably lunch and some breaks, so it might not be that long. So settle in. This one's going to take us well into the afternoon, deep into the afternoon, I should say. And again, thanks for getting us over 22,900, you guys. We're up to 22,000.
Their counsel?
22,912. So appreciate that. Appreciate all the new subscribers, all the new people coming in. Make sure you hit the like button. And if you have any questions, read our description first. And then if you still have questions after that, please come in and ask away. All right. So this one takes place March 1st. So this is suppress evidence. This is a hearing to suppress evidence. Let me just post this up here. All right, so this was from March 1st. All right. All right, so this is a hearing to suppress evidence from March 1st. Thank you, Anthony. Super Bowl did it. Yes, Super Bowl did it. All right, speaking of, I'm going to go feed them. Aaron and I are going to go feed them. So I'll get you guys set up. Good vibes. Thank you. Appreciate your $4.99. This is going to be a complex trial. I'm glad you have made sure we'll all be well prepared. Thank you. Appreciate that. Yes, this will be a lot of names, a lot of moving parts, and we're just we're trying to wrap our heads around it and educate you guys as much as we can. And if you guys have information, if you're local to Jacksonville and or Tampa, and you're hearing things that we're not hearing, please let us know. You can email us and or just put it in chat as well. All right, Super Bowl. Come on, dude. All right. All right, we do ask that you don't use all caps. Appreciate that. So yeah, let's drop the all caps if you can. You don't need to all caps us. It just comes across as if you're shouting. So we do see your posts. So appreciate that you don't do all caps. All right, here, let's continue on with this.
Their counsel, state is present, and are we ready to get going on the motions to suppress?
Yes, Your Honor.
Yes, Judge, if I could be heard briefly.
Sure.
I wanted to request of the court, yesterday you asked me to attempt to provide you some case law with regard to the conspiracy issue. I have not had an opportunity to do that research between yesterday and today.
Well, that's okay, because I'm not going to rule on the motion to sever until I rule on the motion in limine regarding the gang evidence.
Yes, Judge.
Since they're somewhat interrelated, so you've got time.
Great, and along that same line, I was a little brief for purposes of brevity with regard to the state's response to the motion to sever yesterday.
Judge, I'm going to have to take issue with his definition of brevity.
You did speak for over almost 2 hours initially.
In the eye of the beholder.
Yeah, exactly.
But to that extent, when I am doing a short written argument to provide to the court with regard to conspiracy, I'd like to also be allowed, if the court would do so, to just address a couple of the issues in closing as part of that same file.
That's fine. The state can follow a reply.
And Judge, we also, in the same token, I think Ms. Ismer also would like, because some of the pieces of evidence that have been qualified as statements, we actually would like the court to see, because there is an argument that they are not statements. They actually are photographs and postings that are recovered from iCloud accounts and stuff of that nature. So we would like the opportunity to submit that as well. And it's just the statements that have been identified and listed in defense counsel's motions.
Okay, very good. We'll figure out a timeline, but I'm thinking, since I'm probably going to hear the gang evidence motions next Friday, that I will probably give you all until the following, maybe Tuesday, to submit whatever you're going to submit. Okay?
And as I understand it going forward today, Judge, we're going to put some witnesses on, particularly from Jacksonville today, just in terms of qualification as it relates to the motion that's going to be heard next week.
Yeah.
I just want to make sure I have it all straight.
Yeah. And so for today, as I indicated yesterday, because I think you do have out-of-state witnesses, correct, as well?
Not out of state, Judge. We just had from Jacksonville.
Okay. I'm going to, with regards to all of the pending motions to suppress where evidence is going to be taken, we can line them up however you all want to do them. I don't know if you have a preferred schedule, but I'm going to hear the evidence as to all of the motions, and then we will have argument after that. So, and I am going to limit you all to 30 minutes argument on your motions. If you need more time, if you're in the middle of something and it's an important point and you want additional time, that's fine, just ask me. But we're going to start off with a 30-minute time limit for argument. Okay, so do you all have a proposed schedule on the motions, or do you care?
I believe yesterday we concluded that Mr. Gonzalez would go first, so I was going to start off with, based on the witnesses I asked to be here first, was the motion to suppress statements on defendant Rashad Murphy.
Okay, very good.
And Judge, by stipulation, the state's going to be entering a video, audio of Mr. Murphy's statement without objection, and I'm going to be entering as defense number one for purposes of this motion, the actual transcript.
Okay, very good. Okay, so if we're ready to go, let's go ahead and state, call your witness.
Your Honor, the state would call Detective Ramos.
All right.
I don't want this to be done. I like to vote.
Okay, the rule of sequestration has been invoked. If there are any other witnesses here to testify in any of the motions, you are to remain outside, and you're not to discuss your testimony with any other witness until the hearings are concluded.
Can you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give is possibly the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning.
Good morning.
All right, you may proceed.
Thank you, Your Honor. Please state your full name for the record.
My name is Juan Ramos,
How are you employed?
as a detective for the Tampa Police Department.
And how long have you been with the Tampa Police Department?
Since October 13, 2015.
And where were you assigned in June of 2024?
Homicide.
Were you assigned as the lead investigator into the homicide of Charles Jones and the attempted homicide of 3 other members of his party?
I was.
And as the lead detective in this case, did you respond to Georgia on June 26th of 2024?
I did.
Why did you respond to that location?
We had probable cause for 2 vehicles, suspect vehicles that were used in the homicide, and I was notified that one of those vehicles was captured in Gwinnett County, Georgia, so I responded out there for that.
And this is 3 days after the homicide had occurred, is that correct?
Correct.
And you said at this point it was probable cause just for the vehicles involved, is that correct?
Correct.
At this point in your investigation, had you developed probable cause for any suspects?
No.
Had you at that point already viewed and obtained video footage from the crime scene as well as the 2 other locations the victim had been prior to his homicide?
Yes.
And is that what let me ask you this, what was the basis for the probable cause for the 2 vehicles, and what were the 2 vehicles?
Yeah, the 2 vehicles were a silver Chevy Cruze and a black Impala, and the basis for the probable cause was video collected at multiple scenes that the victim was seen at throughout the night right before he was murdered, and license plate readers and stuff like that.
And so had you at that point identified the license plates both for a silver Chevy Cruze as well as a black Chevy Impala?
Correct.
Did you run the tags on both of those vehicles?
Yes.
And those had been identified as the 2 vehicles involved in the offenses, is that correct?
Yes.
Now, you had been contacted by Gwinnett County Police in Georgia on June 26th of 2024. Who contacted you?
Lieutenant Christopher Cheeks.
And what did he brief you as to that particular vehicle?
He briefed me that the Silver Cruze was hitting off of license plate readers in their area, and that he was closing in on where he believed the vehicle was, and then he kept me updated and eventually told me that he found the vehicle.
And when approximately did you get alerted that the vehicle had been located?
Between 5 and 7 a.m. on the morning of June 26, 2024.
And when you got that information, were you given details as to whether or not any people or persons were located within the vehicle at the time the vehicle was located?
Yes, I was told that the defendant, Rashad Murphy, was driving the vehicle when they attempted to take it into custody, and then he resisted by trying to run away from it.
Was he taken in custody and arrested by Gwinnett County Police Department?
Yes.
And that was based on unrelated charges, is that correct?
Correct.
Has nothing to do with the homicide here in Tampa?
No.
And based on that, what did you do?
My second lead, Detective Campbell, and I drove out to Gwinnett.
Now, you said that you had PC for that vehicle involved in your case, is that correct?
Correct.
Had a search warrant been obtained prior to that?
No.
Did you know where the vehicle was?
No.
And after you found out the location of your vehicle, of that vehicle, did you get a search warrant, a joint search warrant for that vehicle in Georgia through Gwinnett Police Department?
Yes.
Now, you said you and your partner at the time, Detective Campbell, went up to Georgia, is that correct?
Correct.
For what purpose?
To facilitate the capture of the vehicle and the process of the vehicle, and then to attempt to interview defendant Rashad Murphy.
Was there additional investigation done by Gwinnett County Police Department into who owned that vehicle or who may have been with Rashad Murphy at the time?
Yes.
And who was that?
The person with the defendant was Charmaine Steiger.
Were you briefed as to whether or not she was in the vehicle at the time Mr. Murphy was pulled over, or was she located somewhere else?
Yeah, I was told that she was in a hotel room, inside of a hotel room in the parking, the hotel that the vehicle was captured in.
When the vehicle was captured, was there a cell phone that was located within the vehicle, the silver Chevy Cruze that Rashad Murphy was driving?
Correct.
Was that cell phone, was it seized?
Yes.
And was that part of an investigation that Gwinnett County did prior to you getting up to that location in Georgia?
Yes.
Was the phone searched by anyone in Gwinnett County prior to you getting there?
No.
And when you got to Gwinnett County, did you speak with, or did you ask to interview the defendant, Rashad Murphy?
Yes.
And is Mr. Murphy, is he present in the courtroom today?
He is somewhere. I saw him behind you.
I'm sorry, I'm blocking.
Yeah, no,
I
it's okay.
apologize. Your Honor, may the record reflect he's identified the defendant.
The record shall so reflect.
And where did that interview take place?
In an interview room at the Gwinnett County Police Department facility.
And at some point, do they have audio, do they have recording ability or capabilities there?
I can't recall there. I know that I had an audio device and I recorded it.
And
yes.
you did it yourself, is that correct?
Correct.
He was not under arrest at the time for the charges here in Hillsborough County, is that correct?
Correct.
And prior to coming to court, did I ask you to look at and listen to, or look at his DVD marked States Exhibit 1 that contained your audio recording, and then initial it so you could recognize it later?
Yes.
Your Honor, at this time, we'd introduce into evidence States Exhibit number 1.
Any objection?
No objection.
Okay, admitted.
Detective Ramos, is this a fair and accurate audio recording of the interview that you attempted to conduct with the defendant, Rashad Murphy?
Correct.
Who was present in the room?
Myself, Detective Campbell, and Rashad Murphy.
And did you introduce yourself and explain who you were?
Yes.
And did you read to him what is known as Miranda rights?
Yes.
And did he understand and appear to understand what you said when you went through his Miranda rights with him?
Yes.
And during the course of reading the Miranda rights, did he indicate to you that he wanted to talk to you?
He said he wanted to talk to a lawyer.
Okay. And after he informed you that he wanted to talk to a lawyer, what did you do?
I made no further attempts to interview him on this offense.
So you terminated the interview, is that correct?
Yes, we spoke for a couple minutes after, but it was just preliminary information and I was giving him.
Your Honor, may we publish the State's Exhibit 1?
Yes.
And Detective Ramos, was that the entirety of the interview that you had was captured on this audio?
Correct.
Less than 5 minutes?
Around there, correct.
How you doing, man? How you doing, sir? My name is Detective Juan Ramos. I am with the Tampa Police Department Homicide Unit. This is my partner, Detective Aaron Campbell. Also, your hand looks like it's kind of bound up right now. You all right right now? Okay. Okay, you can go first. All right, cool. Listen, we apologize, one, about, whatever's been going on. I don't know what's going on with Gwinnett right now. They have that thing going on, but we're here about something completely different, okay? Obviously, because you are under arrest, I have to afford you the opportunity to be informed of your rights. You guys say you don't have to talk to them if you don't want to. That's totally up to you. You get to make that choice, all right? Yeah.
I think you got to resist charge with them, and I don't know there's anything Tampa Police Department, you don't have any charges on you, like, we would have to talk to you right now, we live 500 miles. Okay? You redo your rights,
I'm trying to figure out what would Tampa before I promise you, I'm gonna have all the answers. I'm gonna have all the answers for you, okay? But I have, but you know the game. Okay, I legally have to explain this to you, and then I'll feel free to answer any questions you have if I can. Okay. Just so you know, you have the right to remain silent. If you give up right to remain silent, anything you say can be used against you in court. You have the right to consult with an attorney before you make a statement or answer any question, and the right to have an attorney present during questioning. If you want an attorney but cannot afford to hire an attorney, one will be appointed to represent you before or during questioning free of charge. You have the right to use any of these rights at any time you want during the interview, and you may stop this interview at any time. And do you understand those rights? Okay. Can you spell out your name for me? And then the last name? Murphy. Okay. And then this would just say you've had these rights read to you and you understand them, and then if you want to make the choice to talk to us, you would just initial here and then print and sign here. Okay? It's up to you. All right?
I really don't know.
Okay.
The police did all that to me, so I'd rather have a lawyer because my shoulders, I don't know what the fuck made them.
Okay, so just so you understand, this is not about what they did to you, okay? We are with the Tampa Police Homicide Unit, okay? We want to talk to you about something that happened in Tampa.
Just for the confusion.
Yeah, just so that, yeah.
About this, we're not. We're here to talk to you about campus.
Okay.
And when you talk to us, you have to let us know.
Yeah. At the end of the day, we wouldn't be doing our jobs if we didn't afford you the opportunity, okay, to have this opportunity. This is an opportunity that has to be afforded to you, okay? If you want to talk to us and we can talk out a little bit what's going on in Tampa, we can talk that. That's why we're here. We're here to give you an opportunity to talk about what's going on in Tampa. And that may or may not include, you know what I'm saying, to give you the opportunity to say, hey, if you have no involvement, you have no knowledge, but in order for you to tell us that, we have to agree to talk to us. You know what I'm saying? It's up to you, though.
I don't want to be against subpoena for like something I don't even have no knowledge of. But I have a lawyer present, like, this is what y'all about.
Okay.
Because I'm not sure.
How about your shoulder? Oh, shoot. That don't look right. Yeah.
Is it still dislocated or did they put it back in?
I just told me I go to surgery.
Oh, you got broken?
Oh, wow.
You got broken collarbone.
Okay, well, what's sorry that happened to you, man?
Hey, at least it's your left shoulder, not your right hand.
Mm-hmm. Let's just for the report, just verify some.
I'm like,
Just,
you know what I'm saying? But I need a
that's fine. Do you want my card? Okay. I'm gonna put my cell phone number on the back of it. Okay. That's my direct line. You can call or text or at any time. All right. And then my email and desk numbers at the front, all right? If you're going to consult with a lawyer and your lawyer wants to reach out to me and talk to me, you know what I'm saying, or you want to reach out to me and talk to me, I'm available 24/7. Okay.
Can we get a phone number for you?
Yes. I'm sorry, 904 327 6899. Okay. Okay. 092. Who's your wife? Sherman. Are you guys legally married?
We've engaged.
Okay.
We've been together since we were 13.
Oh, wow. Wow. Okay.
How old are you?
I'm 30.
Okay, you guys been together a whole time.
Okay. Okay. All right. All right. Well, since you've asked for your lawyer, we're going to terminate this interview. Okay. I'm going to turn this recorder off. All right.
Detective Ramos, after that interview, after the recorder was shut off, did you make any other attempts to interview the defendant, Rashad Murphy?
No.
And did you, at some point, after you left Georgia and conducted the investigation, that portion of it, did you at some point contact Detective Christopher Drabeck with the Jacksonville Sheriff's Office?
Yes.
Who is Detective Drabeck in relation to this particular investigation? What was his role?
He was assisting me in Jacksonville. He was essentially the lead detective in Jacksonville, my second in Jacksonville.
Was a lot of the investigation in this particular case done in Jacksonville and some of the evidence and search warrants conducted there?
Yes.
And was he the person that you would go to whenever you needed assistance or any of the searches done in Jacksonville?
Correct.
At some point during a briefing with Detective Drabeck, did you brief him as to what occurred in Georgia?
Yes.
And did that include the fact that the defendant, that you attempted an interview and that he invoked and requested an attorney?
Yes.
Was the defendant arrested on that day for any charges related to the homicide and related offenses that occurred here in Tampa on June 23rd of 2024?
No.
Was he in custody and was he arrested for separate charges that occurred in Georgia during the stop of that vehicle?
Yes.
Eventually, was he released from Georgia on that charge?
Correct.
When was the arrest warrant issued for the arrest of Rashad Murphy related to these charges?
Saturday morning, July 27th, 2024.
And so approximately a month after you had that interview with him in Georgia?
A little over a month, yeah.
A little over a month?
Day or two over a month.
And where was he arrested?
He was arrested in Jacksonville, Florida.
Where were you at the time?
In Tampa.
And at that point, did you, how were you alerted to the defendant's arrest?
He was arrested, I think, 3 days after on July 30th, and I was called by Drabeck in Jacksonville.
And at some point, was there a request made by the Jacksonville Sheriff's Office to conduct another interview of him regarding this particular case?
Yes.
Were you available to do it at the time?
At the time, no.
And so who did you request do that?
Again, who would have been the lead in Jacksonville, Christopher Drabeck.
And then at some point, were you then briefed by Detective Drabeck that he was able to conduct a recorded Mirandized interview with the defendant?
Yes.
Your Honor, at this time we'd pass the witness.
Okay, cross.
Good morning, Detective Ramos.
Morning, sir.
So, Detective Ramos, the interview that took place in Gwinnett County was on June 26, 2024, correct?
Correct.
And during the course of your initial interaction with Mr. Murphy, you read him Miranda in its entirety, correct?
Correct.
Okay. Did you do that by memory? Did you do it by a card or a piece of paper that you carry with you on a regular basis?
I believe that specific incident. Sometimes it's a card, sometimes it's the 310 form, the Tampa police form. I think that form we had, that time we had the 310 form.
Okay. And that 310 form gives Mr. Murphy the entirety of his Miranda rights in every respect, correct?
Correct. Typically, I'll read it and then I'll have them review it as well and look at it and then initial and sign if they agree.
And you explained it to him, correct?
Correct.
You asked him whether or not he understood Miranda, correct?
Correct.
And you asked him specifically if he wanted to exercise the right to speak to you, correct?
Correct.
During the course of the inception of this investigation, you were coordinating with Jacksonville because at that particular time, you had made a determination that the vehicles that were involved in the surveillance had Jacksonville plates or plates and owners that resided in Jacksonville, correct?
That was one of the pieces, yes.
And you were in communication with the Jacksonville detectives, specifically Detective Drabeck, on a regular basis.
Correct.
Throughout the investigation, and certainly in its inception when you were attempting to try to put things together.
Yes, correct.
And after the interview with Mr. Murphy, you communicated on a regular basis with Detective Drabeck. He knew you went to Gwinnett County.
Correct.
You told him that you had exercised or you had read Mr. Murphy Miranda, and he had exercised his right to not speak to you, correct?
Yeah, I told Drebeck that he invoked that we got no statement from Rashad.
Okay. And he was not arrested on that day because you didn't have any probable cause to arrest him, correct?
Correct.
And it's also a fact that you went there because you were going to interview him about this particular murder, not the resisting arrest without violence that he was actually arrested for in Gwinnett.
I was there for the murder in Tampa, yes.
You told him that, did you?
I told him that I was with Homicide and I was from Tampa, correct.
Right, and you were investigating an incident in Tampa. Detective Campbell told him, look, we're here because of Tampa.
Correct.
Detective Drebeck also knew that Charmaine Seiger, Mr. Murphy's girlfriend, was also detained in Gwinnett County, correct?
She wasn't detained, but he knew that she was present.
Well, when she was being interviewed, was she free to leave, to your knowledge?
To my knowledge, yes. Gwinnett had explained to her that they had no reason to hold her. She elected to wait there for the vehicle.
I don't have anything further.
Yep.
Okay, redirect?
No redirect, Your Honor.
Okay, thank you. Thank you, Detective Ramos. You can step back outside. Any other witnesses?
Yes, the state calls Detective Christopher Drebeck. Oh, I gotta show it to him.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may proceed.
Thank you, Your Honor. Please state your full name for the record.
My name is Christopher Drebeck
How are you employed?
with the Jacksonville Sheriff's Office.
And were you employed with the Jacksonville Sheriff's Office in June of 2024?
Yes, ma'am.
What unit were you assigned to at that time?
I was assigned to the gang unit.
During June of 2024, at some point, did law enforcement officers from the Tampa Police Department contact you with regards to the homicide of Charles Jones?
Yes.
What day did that occur?
It was in the morning of the incident.
And as that investigation was unfolding in Tampa, were you assigned a particular role to assist the Tampa Police Department?
Specifically that day, I was the on-call detective with the gang investigations unit. My supervisor reached out to me and informed me that Tampa Police Department was inquiring information relative to the death of Charles Jones. So I reached out to Tampa Police Department and began assisting in whatever way I could.
And how are you familiar with that name, Charles Jones?
He is a prominent member of the criminal gang 6 Block in Jacksonville.
During the course of the investigation by the Tampa Police Department, did you routinely get phone calls from Detective Juan Ramos, the lead homicide investigator assigned to the case?
Yes.
And did he often brief you with updates and seek intelligence based on your knowledge in Jacksonville gangs during the course of this investigation?
Yes.
At some point on June 26th of 2024 or after, did he contact you and give you an update as to the investigation that he did in Gwinnett County, Georgia?
He was routinely updating me in reference to his efforts as it related to that case.
Did he update you and brief you as to the locating the silver Chevy Cruze and coming in contact with a person by the name of Rashad Murphy?
Yes, ma'am.
Did he indicate to you, or what did he tell you with regards to his interaction with Mr. Murphy while he was in Gwinnett County, Georgia?
He advised that he attempted to interview Rashad Murphy, and it was a very short interview, and it concluded with Mr. Murphy invoking his rights.
And at some point, did you, even after that point, did you continue to assist Detective Ramos with different parts and aspects of this investigation, including the execution of search warrants and any other assistance that he needed done in Jacksonville, Florida?
Yes.
At some point, were you alerted that there were arrest warrants that were done for all of the defendants in this case, including Rashad Murphy?
Yes.
When did that happen?
Sometime in July, approximately a month later after the incident.
And you said, so July of 2024, is that correct?
Yes, ma'am.
Okay. Was there who were the first individuals that were located and arrested?
There were 3 defendants arrested initially. It was Isaiah Chance, Alicia Andrews, and Sean Gathright.
And was there a period of time that elapsed before Rashad Murphy was able to be located and arrested?
Yes.
When did that happen?
I believe it was a period of less than a week, a few days after the first 3 were arrested.
Do you remember the date that he was arrested on?
I believe it was July 29th or July 30th.
When he was arrested, were you present during the arrest of Rashad Murphy, or were you alerted by other gang members in your unit?
I was informed that he had been arrested.
At some point, did Detective Ramos ask or request of you to conduct a Mirandized interview of Rashad Murphy after he was arrested?
Yes, ma'am.
And when did that take place?
The evening he was arrested.
And was that on July 30th of 2024?
Yes.
And was it kind of in the early morning hours?
Yes, ma'am.
Where did the interview take place?
It took place at our Crime Gun Intelligence Center in Jacksonville, Florida.
And he had been arrested for the homicide and all of the related charges that occurred here in Tampa, is that correct?
That's correct.
Who was present when you did the interview of the defendant?
It was myself and Detective Craig Griffin.
Was that interview audio and video recorded?
Yes.
Did you read the defendant his constitutional Miranda rights?
I did.
Did you actually ask him to read some of that form himself, just so you could ascertain his ability to read and write?
I did.
Did he have any did he have any problem or any issue understanding when you were going over the Miranda rights with him?
No.
Prior to conducting the interview, were you aware, prior to conducting that, you said it had already been indicated to you that he had previously invoked, is that correct, and requested an attorney?
Yes.
But how long had that been when that occurred?
Approximately 1 month.
And after you went over the Miranda form with his rights on it, did you ask him to sign and date it and acknowledge that he understood all of those rights?
I did.
Is there also some preliminary background questions that you go over with him just to make sure or ensure that he is cognizant and he can comprehend everything that is going on?
Yes.
Prior to coming here today, did I show you it's been marked State's Exhibit Number 2 and ask you to view it so that you could recognize this particular DVD as the video that you had done with the defendant, Rashad Murphy, on July 30th of 2024?
Yes.
And did you initial and date it?
I did, and I see them at the top of the disc.
Your Honor, at this time, we'd introduce into evidence State's Exhibit Number 2.
Any objection? Okay, admitted.
And the room that he is placed in while he's waiting to be interviewed. Is the video recording going the entire time that he is in there?
Yes.
At some point, is he provided a blanket?
Yes.
Alright, go ahead and sit down. As soon as I can find some scissors, I'll send someone with them. I'll get in here to get those off you, alright? So just sit down, it's come.
And for the record, you're publishing the exhibit, and it looks like you're fast forwarding to a certain section, correct?
Yes, Judge, and I've already discussed it with defense counsel that there's about an hour of dead space, so we're going to fast forward it to when the detective actually comes
Which,
in.
for the record, is at what point in time?
It's like at 1 minute, Judge. I'm sorry, 1 hour.
I had to get one of these and get tired. You want one? You drink these? No? You ever had it?
Yeah, I've been drinking, but I laid it off the road.
Bad for you? Yeah. I hear that too. But I used to do this thing called chewing, like tobacco. And it's pretty bad for you as well. So I'm happy I'm not doing that anymore. Chew tobacco?
Yeah.
Well, I used to rip cigs, but then I kind of started chewing. Anywho, before I can speak to you about, obviously, whatever conversations we have, I just have to review this first. If you have any questions at all about it, just let me know and I'll be happy to explain it, okay? Are you able to read?
Yes.
You are? Okay.
I got a question.
Sure.
Yeah, I know how everybody should YouTube, but
Yeah. Well, let me tell you something. All the things you've ever watched on YouTube, right? Hear me out, because I understand your question.
Yeah,
I've been listen to me. I've been doing this job for a hot minute, so I understand your question. But your question is in reference to Jacksonville videos. We have probably different record request laws than what maybe Tampa might have, right? This isn't a Jacksonville case. You feel me?
Yeah.
So the conversation we have is important, but I do understand your concern. And I can promise you that what your concern is directed to like crime circus and all that shit you see on YouTube, that's Jacksonville related. We don't have control of that in Jacksonville. Tampa's a different story. Does that make sense? Can you demonstrate you're able to read by reading that first line for me?
Read the following rights under the United States Constitution.
Perfect. I'm going to read the rest, and if you have any other questions, Rashad, do people call you Rashad?
Yes.
Just let me know. You have the right to remain silent. Anything you say can be used against you in court. You have the right to talk to a lawyer for advice before you make a statement or before any questions are asked of you, and to have a lawyer with you during any questioning. If you cannot afford to hire a lawyer, one will be appointed for you before any questioning if you wish. And if you do answer questions without a lawyer present, you will still have the right to stop answering questions at any time and consult with a lawyer. Do you understand all that?
Yes.
Okay. Do you know how to sign your name?
Yes.
Okay, if you could print your first and last name on that line, and then sign your name on that line, and then once you do that, I'm gonna write my information just above yours. You're fine, man. It's like creeping up on 3 in the morning. Don't blame you.
That blanket help you out any? Yes, sir. All right.
Holy smokes.
Can I get some else?
I mean, what?
Yes, sir.
Piece of paper.
Yeah, no, I just.
Oh, that's fine, buddy. I mean, if you're yeah, just look. That's fine. I'm good with that. Just sign your name, and I'll sign right above it. Mine's not a hell of a lot better, anyways. So, my name is Chris. I don't know if I introduced myself when we were talking the first time, but this is my ID number. It's 78576. Some people call it a badge number, but that's mine. There's a couple questions down here. I'm gonna just go through real quick. Sir, what's your date of birth?
1994.
Damn, you almost got 420.
Yeah.
So you get to celebrate 2 days in a row.
Yeah.
Okay. So how old does that make you? You probably 30?
Just turned 30.
Big 30. Congrats.
All right, I got to pause it here because I've got some confusion going on here. So just bear with me for a second because I've got some conflicting information. So let's bear with me for just a second. Bear with me for just a second. This is what you guys are talking about.
Good morning.
So
Would you please state your
this was
name
Alicia.
and spell both names, please?
My name is Officer J.L. Mahamoudi Vega. First name J.
This is the Alicia Andrews trial. This is the arresting officer. All right, this is the arresting officer. All right, sorry about that. This makes no sense whatsoever. I got to try and figure this out. Okay, this is the arresting officer for Rashad Murphy.
That's the interior of your patrol vehicle?
Yes, sir.
And to the right, is there a computer mounted?
Yes, sir.
Are you pulling into the hotel?
Yes, sir.
And is that the hotel on the left?
Yes.
Above your steering wheel, is that the Chevy Cruze pulling into the parking spot?
Yes, sir.
This is in Gwinnett County. This is in Georgia. All right, so we have that. All right, so we have that, but then what is this? What is this then? This is Jacksonville police. So that's in what? I am so confused, you guys. Here, now check this out. Then we have this. Then we have this, and this is Jacksonville. I thought this was his arrest. They must have. Because then this is Jacksonville arresting him. Yeah. So then this is Jacksonville. So he gets arrested in Georgia, but then this is Jacksonville gets arrested. So they must have let him go.
And the kids, please, like 7 o'clock. I'm talking about the broadcast right now.
So, all right, so I'm still trying to figure out, okay, so let's go back to this. Oops, let's go back to this then. All right, so he got picked up, released a month later, got picked up again. Okay, so that was in Alicia's trial that officer was testifying that he got tased, and that was in Gwinnett. He got picked up twice. Okay, and then he was arrested on the conspiracy at his apartment. Okay, so he got picked up twice. All right, that's him picking up the hit money. All right, I didn't even know that about I totally missed that in Alicia's trial. I totally missed that in Alicia's trial. All right, this is good. This is good. I'm glad you guys are educating me. That helps a lot. That helps me a lot. Okay. All right. They had these kids 2 days after the hit. Yep, they let them all go. Self-snitch on Ace, but they haven't so far. All right. So I missed that in Alicia's trial, so that's good to know. So thank you, chat, for that. All right, let's get back to his interview.
What's your highest level of education?
My highest level of education, like 12, but really 11. I just like stopped on like.
Did you graduate high school?
No, sir.
What was the last high school you went to?
Coast.
Okay. So you were a was it a Stingray?
Yes, sir.
Nice. You can read, sir. You can also write. Is that correct?
Yeah, I can write.
Okay. It's just a question I'm gonna ask. Have you had any alcohol today?
Any alcohol?
Mm-hmm.
That was earlier.
What time was that?
Like 11, 12. Like 12 in the afternoon, going on like 11 a.m. or something.
11 a.m. 12 p.m. That's fine. What were you drinking? Just a beer?
Drinking it's like a wine cooler.
Okay, like a little White Claw?
You know, with the
high noon?
You know what turmeric is? Like the little orange.
I don't think I've ever heard of that. Have you?
The turmeric is like a shot, like a healthy shot.
Okay. I haven't.
Turmeric mixed with it's a turmeric tequila drink.
It sounds like something I would probably like.
It make you wake up? Get you energy, anything like that?
No, sure.
Okay.
Just get you in the mood. Have you had any drugs today?
No, I just smoke weed. I don't do drugs.
Have you smoked any? I'm sorry. Have you smoked any marijuana today?
Around the same time.
Around the same time?
Yes, sir.
Have you smoked your weed? You rip GDs or you blunts?
Blunts. I really like crap these. I don't like smoking out blunts because I don't like how harsh it is.
Rashad, do you wear any glasses?
No, I wear glasses. I used to wear glasses. I don't want them more.
So no.
And I wear glasses like since I like then my lenses when I was younger. Shiny. My brother like smoking drink.
Do you wear contacts?
Huh? Contacts? No, sir.
No contacts. Do you have any mental health conditions? You said physical health?
Like I fired my shoulder. I don't got no.
Shoulder?
Yeah.
Did you got old injuries? Old injuries you talk about?
Nah, Georgia I've been going to the doctor for my own shoulder, but Georgia when I went to Georgia, my shoulder I never feel like they really broke it. They broke it because I've been that bad.
Do you play football?
Yes, sir.
What high school you play at?
Coach Jackson, Gilbert.
What position you played?
Played running back, receiver.
Okay. I used to, so I'm around the same age as you. I used to play at White's. Maybe we,
So you know Preston Edwards, Richard Montgomery.
Casey Turner, Kevin Parker, Kevin House.
I played with like Steph Durham and Preston Edwards. Steph Durham.
Where they play at?
Steph Durham, he's a coach for Wilson High School.
Okay.
Yeah, but he used to go to Georgia Tech.
Okay. So you were playing when like Lewis Nix was playing, and he was at Reigns.
Lewis Nix.
He was the big defensive lineman at
I went
Reigns.
to Atlanta coach 2012, like second year.
Okay. Damn, so you was in there when it was fresh off. Yeah. So today is July 30th, 2024, and the current time is 0304. This is 311 West Monroe Street. You mentioned watching YouTube videos. I'm sure you've seen this room many of times, right? This is my office. This is at the state attorney's office. This is what we call a satellite.
When Jacob wanted to talk to me, he'll probably take me outside room and hit the back and you know what I'm saying?
Yeah, that's a little different.
Yeah, but you said it's not y'all, you know what I'm saying?
It's not. No, it's not. You know that. And yeah, no, I'm being a man telling you that. However, I will tell you that this is Tampa's investigation, and you're probably confused why they're not in here, right?
I really I don't want to talk to them because
they're nasty.
Nah, they don't know me. You know what I'm saying?
They don't know Jacksonville shit.
They don't know. They don't know. So
I agree.
Trying to talk to them and help me.
Chop it up, you can't.
Because it's you know what I'm saying? Because I don't. It was like 7 minutes. It was like if somebody put me on game about something, then I know how to.
Sure.
But ain't nobody putting me on. You know what I'm saying? They really left me in the blind. So if I wasn't in the blind, I wouldn't got in the car. and I wouldn't let nobody.
Well, in their defense, I think it's also fair to say that whenever you did talk to them that first time, they were probably really overwhelmed with a lot.
Which they had to travel. They had to travel 8 hours and all that to come and see me. So like,
yeah,
I respect it.
True. I think that's everything for me. Let me just sign that.
Yeah, I gave my family my Jesus Caller book.
Your what book?
My Jesus Caller.
Jesus Caller?
Jesus Calling. Like the book I had before I walked out the door.
Did you have it?
Yeah, I had it.
Or is it still in the apartment?
No, I brought it out to the apartment.
Okay. Did you ask someone to do that?
What? Yeah, I told them to give it.
I can promise you if you...
I read it with my kids every night.
How many kids you got?
I got 4, and I raised my brother and sister, so like 6, because I'm most dad, so I got like 6 kids.
You've got 6 children.
4 of my
and but 4 of them are yours. How old is your oldest?
My oldest is 11. My second child is 8. Prosper, he just turned 7 June 23rd. Okay. And Gabrielle, she's going to be 6 November 1st.
Wow, you've got a little army, dude. You get to see them every day? Are they always with you?
Yeah, my kids live in
Tampa. Okay, that's fantastic. I'm sure you really appreciate that.
I don't even, like, I don't even remember spending no more than a week for my kids.
Yeah. So I think it's fair to say there's probably no secret why you're here. Ultimately, what I was getting at, the reason Tampa isn't here, they've got a lot going on. So they asked us to step in. Unfortunately, what that means for us is since we didn't do the investigation ourselves, I can't really, because I used to work in the homicide unit for Jacksonville, I don't anymore. But unfortunately, what that means for us is if you were to lie about anything, I probably wouldn't be able to call you out on it. That's what I like to do for my cases. This isn't my case. But I say that to say, let's be honest as we can. Does that make sense?
Yeah.
So I'm sure you have a lot of questions. I know I have probably a few, but I'll let you have the room, and you can start off wherever you'd like. How do you feel like you ended up here?
I ended up here about like not about letting people hold stuff and put stuff in my name, like that's just like it's the typical thing, when people can get Airbnbs and all that.
Your
stuff.
Honor, I'm going to stop it at 1 hour and 11 minutes and 36 seconds into it. I know that Mr. Gonzalez and I agreed that the entirety is on this recording, on this DVD, as well as you have a transcript of it.
Okay, very good.
And Judge, just to supplement that, I will be arguing and giving the court some context about specific statements made that are not going to be testified to under oath, but stipulated to by way of the video being the best evidence of what was said.
Sure. Okay.
Detective Drabeck, during the course of that interview that you just watched, when you were going over his Miranda rights, you explained to him that this was specifically in regards to the Tampa homicide. Is that correct?
Yes.
Did he ever indicate to you after you read those Miranda rights or during the entirety of the interview that he wanted a lawyer or state that he did not want to talk to you about this incident?
No.
Your Honor, at this time we pass the witness.
Okay, cross.
Morning, Detective.
Morning.
So, Detective, just so I'm sure I understand the chronology here, in communication with Detective Ramos during the inception of this investigation, you were aware that approximately a month prior, Mr. Murphy had invoked when Detective Ramos traveled to Gwinnett County, correct?
Yes, sir.
And throughout that process, you continued on kind of a live basis, on a regular basis, to collaborate with each other as it relates to the investigation going on in Tampa and the investigation side that was in Jacksonville, correct?
Yes, sir.
And the precipice for the interview that occurred on July 30th was Mr. Murphy's arrest in Jacksonville for that murder.
Yes.
And that was the same murder or the same set of facts that Detective Ramos went to Gwinnett County to interview him for a month earlier.
As far as I'm aware, yes.
And you would agree with me that although you may not recollect verbatim every word that occurred during your portion of Mr. Murphy's interview on that date and his responses on that date, that the video and the audio and the transcript of the interview would be correct as to what was said between you?
Yes, sir.
The July 30th interview was not initiated by Mr. Murphy, correct?
Correct.
And was it Detective Ramos that contacted you, or vice versa, you contacting him saying, hey, Murphy's in custody?
Yes.
That would be you to him?
Yes.
And his response was, go ahead, I would like you to interview him.
Yes.
Did you all discuss his prior invocation?
At that time, no.
And is there any reason why you attempted to interview him knowing that he had previously asked for counsel and invoked his rights as it relates to this same and particular incident?
Yes.
Why?
Because I wanted to obtain his statements that he was willing to provide in reference to this investigation.
After he had previously invoked?
Yes.
Did you talk to him about his previous invocation?
No.
And did you consider this to be a separate interview?
Yes.
And you were aware, obviously, that the arrest in Jacksonville was an arrest for the murder in Tampa?
Yes.
Do you recall why Detective Ramos was not able to come to Jacksonville and conduct that interview on the Tampa murder?
I don't recall.
During the course of your initial interaction with Mr. Murphy, after you read him the advisements, you essentially just say, hey, if you have any questions, let me know. Is that a fair statement generally?
At the conclusion of reading his rights, I did ask him if he understood. His response was yes, and then I followed up with that with what you just said.
Okay. Do you recall whether you ever asked him whether or not he wished to waive those rights?
I believe that's included within what's read to him.
Okay. And so your commentary or your questioning of Mr. Murphy and his responses would be in the transcript, the video, the audio, correct?
Yes, sir.
And it's your testimony that you believe that you asked him whether or not he wished to waive those rights after the advisement was read? And if you don't have any independent recollection, I understand.
My understanding that the rights that are read to him, that's included.
Okay.
I didn't provide any additional follow-up to that.
You didn't ask for an acknowledgement from him after he read it as to whether or not he wanted to waive it?
I feel like that would be a bit redundant, so no.
Okay. And you proceeded then to ask him, hey, look, just print your first name and your last name on that line and we'll get going.
Yes.
Give or take a word here or there.
Yes.
And during the course of the form and the instruction on the form, you talked about the absence of the Tampa detectives being there on that particular day for the interview, correct?
Yes, sir.
And he indicated to you that he didn't want to speak to the Tampa detectives.
He makes a comment alluding to that, yes.
Yeah, I mean, pretty much said verbatim, I don't want to talk to them.
I don't know what the quote was, but yes.
That's fine. And certainly that you remember that type of a dialogue happening with regard to you explaining to him, you're Jacksonville, they're Tampa.
Yes.
Homicide, but you used to. You
Yes.
recall that line of questioning?
That's how I positioned it, yes.
And you went on to ask him and tell him, well, you know, even if you lied, I probably wouldn't be able to call you out because I don't really know anything about this.
Correct.
Initially, Mr. Murphy denied being in Tampa, didn't he?
He did.
And you began a series of kind of warnings to him where you were telling him, hey, look, your co-defendants are painting you as a mastermind, and you know, this is going to be the most important conversation of your life, and that these are the kind of things where lives change. And again, I'm not talking about specific language, but in general, do you recall that line of questioning?
Yes, sir.
And then you went on to discuss with him at length the strength of the investigation in Tampa and how good they are down there and what great investigations they do, and that you wouldn't be messing around if you were him. Do you recall that line of questioning?
Yes.
At that particular time or somewhere near it, Mr. Murphy then made an admission to you that he had been in Tampa, but he did not have anything to do with any shooting or any murder.
Yes.
Did you indicate to him that he's never seen anything like what a Tampa interview would be like, and that you're not bluffing about what that would be for him?
I don't understand.
Do you ever recall telling him that, hey, look, this is a Tampa investigation, right? Not Jacksonville. I'm not bluffing you because you've never seen anything that takes place in Tampa and the way they do their investigations and their interview.
I suppose you could phrase it that way, yes.
Okay. And again, listen, I'm not trying to put you on the spot. There's no way for you to know exactly what you said verbatim. Do you recall that general line of questioning, and would you defer to the transcript?
Yes, sir.
And Mr. Murphy told you he didn't want to talk to any Tampa detectives, correct?
Yes.
Because they don't do things like things are done in Jacksonville.
Mr. Murphy was expressing that Tampa wouldn't have the knowledge base of Jacksonville stuff.
And at one point in time, you told them, yeah, they're nasty. Are they nasty? Talking about Tampa detectives.
I said that, yes.
I don't have any further questions. Thank you.
Okay, redirect.
Just briefly. Detective Drabeck, when he said he didn't want to talk to any Tampa police detectives, there were no Tampa law enforcement officers in the room, is that correct?
Correct.
And during the course of your interview, you're allowed to use strategic tactics when questioning suspects, is that correct?
Yes.
Was it made clear to him that you were speaking to him about the Tampa homicide?
Yes.
Was that the only reason he was arrested, was for the Tampa charges?
Yes.
And during the course of that entire interview, did you make him any sort of promises of any kind during that interview in order to get him to talk to you?
No.
I have nothing further, Judge.
Okay, thank you. May this witness be excused?
Yes, Your Honor.
Okay, you can remain outside. I don't know if you're needed for any other motions today.
He is.
Okay, then don't go anywhere. Okay, any additional witnesses?
No additional witnesses, Your Honor.
Okay, so defense, do you have any additional witnesses?
I do not, Your Honor.
Okay, very good. Okay, so I'm gonna, as I indicated, I'm gonna hear argument later on. All right? Okay, so that is the testimony in total for Rashad Murphy's motion to suppress statements. All right, are we going to stay with let's see, Mr. Gathright has, looks like 2 motions. Mr. Murphy, Davion Murphy has 1, and Rashad Murphy has 1 additional defendant's motion to suppress cell phone. So which motion do you all want to take testimony on next?
Judge, what were they again? I'm sorry.
This is what I show. So this is what I show we've got as far as motions to suppress. Rashad Murphy has a motion to suppress cell phone. Davion Murphy has a motion to suppress search and seizure of Davion Murphy. Sean Gathright has a motion to suppress evidence obtained following the warrantless search of the defendant's vehicle. And Sean Gathright has a motion to suppress evidence illegally obtained from the defendant's iCloud accounts. Is there any other motion to suppress that's going to require testimony that I have overlooked?
Not motion to suppress, Judge. I do. Judge, we do also think that there's testimony required for the motion in limiting gang chart, but we can do that in the afternoon as well.
Okay.
Well, Judge, I'm sorry, I didn't recognize, it looks like, I mean, I have on my schedule 3/6 of 2029, the motions in limine.
Right, but I think that, that the state wants to put on some evidence.
Testimony?
Yes.
I'm sorry.
And
I'm
so.
sorry. I was confused.
Okay, so I tell you what I'm going to do. I'm just going to take a quick 10-minute break. You guys figure out the schedule for the testimony for the remaining witnesses, and then I'll come back and we'll proceed, okay?
Okay, thank you.
All right, thanks.
Ryan, did you want to do the one for the cell phone next, or somebody else?
What motion do you all want to take testimony for next?
I believe we're going to stick with Rashad Murphy and do his motion to suppress cell phone.
Okay, very good. Yeah, sure. All right, so we'll have Detective Ramos back on the stand. Oh, and we don't have a court reporter, so we can't do anything. Never mind. I can't see you, so I need to remember to look before I start talking. Okay, yes, come on up, Detective Ramos. You remain under oath from your previous testimony. We're now moving on to Rashad Murphy's motion to suppress cell phone. Okay, you may proceed.
Again, please state your name for the record.
Juan Ramos.
Detective Ramos, I'm going to go back to your time in Gwinnett County when you were there investigating Rashad Murphy. At some point, was there another detective with Gwinnett County Police Department that was assisted you in the investigation?
Yes.
Who was that?
Detective Angela Carter.
Were you alerted that there was a cell phone in the silver Chevy Cruze when the defendant Rashad Murphy was stopped by Gwinnett County Police Department?
Yes.
And based on that, was there the detective Angela Carter, did she reach out to you during the course of the investigation prior to you getting to Gwinnett County?
Yes.
At some point, do you know, were you alerted or were you briefed that she had conducted a consensual interview with Charmaine Steiger?
Yes.
And during the course of that, that Ms. Steiger had consented to her, Detective Carter, looking at the phone?
Yes.
At some point during that interview, was the consent withdrawn?
Yes.
Based on that interview, did Detective Carter learn who that phone belonged to?
Yes.
And what was your understanding of the information that Detective Carter got from Ms. Steiger?
That it was a phone mutually owned by Charmaine Steiger and Rashad Murphy.
And after the consent was withdrawn, was it at that point determined to get a search warrant for that particular phone?
Yes.
Was there a joint search warrant done as you as the joint affiant with Detective Carter because you were located in the jurisdiction of Gwinnett County?
Yes.
Did you assist and provide Detective Carter with the probable cause to get the phone?
Yes.
I'm going to show you State's Exhibit number 3. You familiar with this?
Yes.
Is that a copy of the search warrant as well as the affidavit that is the support that lists the probable cause to search that phone belonging to Charmaine Steiger and Rashad Murphy that was taken from the silver Chevy Cruze back in July of 2024?
June 2024.
I'm sorry, June of 2024.
Yeah. Yes.
Your Honor, at this time, we'd introduce into evidence State's Exhibit number 3.
No objection.
Okay, admitted.
And I'm gonna ask you to take a look at that.
Sure.
You're familiar with the PC, is that correct?
Correct.
You assisted in the drafting and provided the basis for all of the probable cause, is that correct?
Correct.
Is there anything that was in the search warrant that was incorrect or misleading for the application of the search warrant?
No.
At the time, I believe you've already testified that there was probable cause to seize the silver Chevy Cruze, is that correct?
Correct.
You did not have probable cause at that time to make an arrest of the defendant on that day, did you?
No.
Was he considered a person of interest based on the investigation that you had done to date?
Yes.
Is that the reason why you wanted to interview him on that day?
Correct.
Specifically asking you about the facts and the circumstances, I believe on the affidavit, the first page of the affidavit and application, where it says, based on the facts and circumstances. Did you read that paragraph for the forensic download of the iPhone and what was given for as the reason?
Yes.
Is there anything that is deceptive or inaccurate in that account?
No.
And specifically, you list in there you want the location data to clarify the timeline of her, and you're referring to Charmaine Steiger and Murphy's trip to Gwinnett County from Jacksonville, Florida, and because GPS application was displayed at the time the phone was retrieved from the Chevy Cruze, is that correct?
Correct.
And it does make a reference that originally with Steiger's consent.
Correct.
And does at some point, did you conduct an interview with Charmaine Steiger?
Yes.
And did Detective Angela Carter conduct an interview of Charmaine Steiger prior to seeking this search warrant for that cell phone?
Yes.
And based on those interviews, was she asked about her whereabouts as well as the defendant's whereabouts, and in particular, the silver Chevy Cruze?
Yes.
And does the search warrant and the affidavit for probable cause outline all of that?
Yes.
Okay, Your Honor, at this time we pass the witness.
Okay, cross.
Detective, to back up just a little bit and set the stage here.
Sure.
This was the infancy of this investigation, correct?
Day 3.
And during the course of day 1 through 3, you were able to seek and review video surveillance from various locations that identified this silver Chevy Cruze, correct?
Correct.
And certainly you had no way of knowing who the occupants were or why it was involved or any backdrop other than that is the make, model, and color of this car. We know who the registered owner is, correct?
Yes.
And you haven't developed at that stage of the game any additional information relating to the registered owner. You haven't spoke to them yet. you had to determine whether anybody else could be developed as a result of simply the ownership of the car.
Yeah, I hadn't spoken to the registered owner.
And so what you did do, though, is you did an alert on the vehicle so that if it was found anywhere through any means, that it would be stopped and secured and held for further investigation, correct?
Correct.
Okay. And this had no evidentiary basis or no person or persons attached. It was the vehicle and the vehicle itself and the vehicle alone.
Correct.
And when the license plate readers determined that the Chevy Cruze was in Gwinnett County, you were alerted that there were individuals being detained and the vehicle had been secured, correct?
I was alerted that one individual was detained and the vehicle was secured, yes.
Okay. Were you aware or made aware that there was another individual in the hotel at that time that might have had some involvement with the car?
Yeah, but I don't believe she was arrested or anything, yeah.
Okay, but she was detained to the extent that she was taken to the police headquarters and there was a request made from her for an interview, correct?
We talked to her, yes. Again, my understanding of that was that she went willingly with the police department and agreed to stay there.
Okay, and the way that it was determined or the way the car was found was through license plate readers.
Correct.
You talked to Ms. Doherty about the search warrant.
Yes.
And so you kind of used a fellow officer type of situation in this regard. You were working with Detective Carter as a fellow law enforcement officer from another jurisdiction, and you had made a determination that you wanted to search his phone, correct?
Yeah, it's a co-affiant search warrant. I was working with Carter, correct.
Okay. And certainly Detective Carter wouldn't have had any information about any of the evidentiary backdrop or the probable cause for the search warrant. That would have been supplied by you.
I wouldn't agree to that. We spoke about, I briefed her on what we had on the case at that point, and so she had some knowledge going into the interview of what was going on, and then obviously she's developing new information with her interview with Charmaine Steiger, so we're working together as a team.
So the part of it that she would have direct knowledge about would be what happened with that vehicle once it got to Gwinnett County.
Correct.
Essentially, the portion of the affidavit all the way up to that point, which is toward the end, would have been information you developed in the investigation prior to that.
Yes.
And it's fair to say that the one portion or the one part of the affidavit that involved or where Mr. Murphy was mentioned was that Jacksonville had provided you some general intelligence from their sources that revealed that Mr. Chance and Mr. Murphy could be people of interest in this murder, correct?
Prior to the capture of the Cruze, yeah, correct. That was the one piece of information that Jacksonville had obtained.
Okay. And what other additional information you might have had at the time that the affidavit was done is that Mr. Murphy was in custody because he was in possession of the Cruze.
Yeah, that added to the probable cause, him being in possession of the Cruze and fleeing from it when they tried to stop him.
Okay. And relating on your reliance in that affidavit to produce probable cause, Jacksonville never gave you any evidentiary basis whatsoever for their opinion that Mr. Murphy could be a person of interest, correct?
Direct evidence? No. I mean, again, they were sourcing information from multiple sources, so.
Sources that you weren't aware of, correct?
I was not notified what the sources were, correct?
Sources that they didn't tell you who the sources were, correct?
Correct.
You're not aware if there's any witness that provided any information that might indicate that Mr. Murphy was involved, correct?
Witness, no.
There were no forensic evidence that had been developed that would implicate or cause Mr. Murphy to be a person of interest, correct?
Physical forensic, no. I was aware that they were monitoring his Instagram account, and they were extracting some of the information from there as well to verify the intelligence that they were getting.
you are not suggesting under oath to the court today that your probable cause affidavit for this phone would have included any information regarding Mr. Murphy, an alleged Instagram account, or anything in that Instagram account that would implicate him, correct?
I don't believe I mentioned the Instagram account up to this point, no.
And there were no forensics, obviously, that would cause him to be a person of interest. Would you agree?
Up to the, yeah, correct.
No video other than a vehicle that we've been able to identify, correct?
He wasn't identifiable in any video up at this point, yeah.
So it was based on this information that we've just discussed that was generally given to you by the Jacksonville detectives that created this portion of the probable cause affidavit for you.
It's not just the information, it's also what happens when the car is captured. It's the totality. So the PC isn't based solely off of what Jacksonville says. It's also his capture, the fact that he's in the car and in possession of the vehicle that we did have probable cause for.
Okay, so you already felt like you had probable cause to do a search warrant for the vehicle, correct?
Correct.
Okay, and that was intent to do that.
Correct.
And you're not suggesting that the fact that he was an occupant of that vehicle days after the murder would be evidence that he committed this murder, correct? You agree?
I would think that it's definitely important, you know, in the investigation, or it's you know, it's definitely part of the probable cause, the totality of circumstances, him being in possession of the vehicle that was used in the murder.
And you weren't aware at this particular time that the owner of the murder was related to him, correct?
At this point, no.
So your rationale in then seeking a search warrant for the phone was that you had a search warrant for the car, Mr. Murphy was in the car, so he possessed the car, and when he ran from the car, ultimately a phone was found in the car, correct?
The phone was found inside of the car,
Okay.
correct.
And that phone becomes an extension of the car.
The phone was definitely a part of the car, correct.
Well, essentially, your admission when you authored the factual basis for the probable cause for the phone was that the phone was an extension of a car, correct?
The phone was a part of the car, yes.
Okay. Prior to your seeking the affidavit and the warrant for the phone, you didn't, between that time frame, come into or become aware of any additional information as it relates to Rashad Murphy being a suspect in this murder than what we've already discussed, correct?
No.
Nothing further.
Okay, redirect.
Just briefly, Your Honor. Detective Ramos, this, even though that there was a search warrant done on that vehicle and that it was contained in the vehicle, you did a separate search warrant to actually, and approved and authorized you and Detective Carter to go into that phone. Is that correct?
Correct.
And you said that there was, it wasn't just the basis of the information from Jacksonville, but you did include the intel from Jacksonville, is that correct, as part of the basis for this search warrant?
Correct.
And you just referred to it as intel. You didn't list or try to say that this was based on any sort of eyewitness testimony or anything. You specifically put in there, honestly, that it was intel derived from the gang detectives who work in Jacksonville. Is that correct?
Correct.
Listed them by name.
Correct.
And then did you then go in and detail the two names that they had come and provided to you as suspects in this case prior to the defendant being found in the suspect vehicle?
Yes.
And who were the two suspects that they believed, based on their intel, had something to do with this homicide?
Isaiah Chance and Rashad Murphy.
And then Rashad Murphy is found in that vehicle within how many days of the homicide?
3 days.
All of that part of the facts and basis of the search warrant?
Yes.
And then I want to go specifically to the phone. The phone at first was utilized and given to Charmaine Steiger, who said that she also shared use of that phone. Is that correct?
Correct.
She was willing to open that phone and talk to Detective Carter about the phone?
Yes.
All of those facts are contained in the search warrant. Is that correct?
Yes.
And during that interview with Detective Carter, she was questioned as to her whereabouts and the defendant's whereabouts during the time frame of the homicide. Is that correct?
Correct.
As well as that silver Chevy Cruze.
Correct.
And during the course of Detective Carter's interview, did Ms. Steiger, when she was alerted that that car was down in Tampa for a homicide, did she start to change the information she was provided about providing Detective Carter about her and her knowledge as to the defendant's whereabouts that weekend?
Yes.
And is that part of the basis why at that point, and included in the search warrant, that the phone was then seized and a search warrant was going to be secured? Because at some point, Ms. Steiger did not want her looking at that phone anymore. Is that correct?
Correct.
All of that disclosed and part of the search warrant?
Yes.
All right. I have nothing further, Judge.
Okay, thank you. May this witness step down?
Yes, ma'am.
Okay, thank you. Any additional witnesses from the state?
No, Your Honor.
Any witnesses from the defense on this motion? Mr. Gonzalez? Okay, very good. Okay. Next will be...
Judge, I know that Mr. Wise had to step out, and he has a couple of them that we'll have to wait, but I do think there is one for Mr. Davian Murphy.
Correct. All right, so we'll move on to Davion Murphy, motion to suppress, search and seizure of Davion Murphy. All right, and state who's going to be your witness or witnesses for this one.
Detective Nieder.
Detective Nieder?
Nieder, yes, Your Honor.
Okay, and that's N-E-D-E-R?
Yes, Your Honor.
Okay.
N-E-A-D-E-R.
N-E-A-D-E-R. Davion Murphy's motion to suppress, search and seizure. Okay, detective, raise your right hand. The clerk's going to swear you in.
Yes.
All right. Ms. Ismer, you may proceed.
Sir, would you state your name for the record?
Detective Richard Nieder,
Where are you currently employed?
in Jacksonville Sheriff's Office.
And how long have you been employed with the sheriff's office?
Be 10 years in September.
What is your role with the sheriff's office at this time?
I'm a detective in the Gang Investigations Unit.
And how were you employed in June of 2024?
I was employed by the Sheriff's Office as a detective in the Gang Investigations Unit.
Did a part of your duties include following or monitoring one specific gang?
Yes.
Did your duties also include making sure that you maintained some level of knowledge as it related to the other relevant gangs in Jacksonville as well?
Yes.
Did you ultimately have an opportunity to assist in the investigation into the homicide of Charles Jones?
I did.
And as a part of your role in that case, did you in part conduct or participate in an interview of an individual by the name of Davian Murphy?
Yes.
And do you recall when that interview occurred?
It was, I don't remember the exact date and time, but it was after his arrest in Jacksonville for the warrant that he had.
Would that have been subsequent to the homicide of Charles Jones?
Yes, it was many months after.
And did it take some time for law enforcement to actually locate and arrest Davian Murphy on the homicide warrant?
It did.
Once he was subsequently arrested, were you aware or notified by the arresting unit that arrested Mr. Murphy that he was in custody?
Yes, our unit assisted our SWAT team in arresting him, along with our U.S. Marshals team.
At the time of Mr. Davian Murphy's arrest, was there a photograph produced to you of him at the location of his arrest?
Yes.
Were you able to ascertain what he was wearing at that time?
He was wearing a tan jacket and pants, is what I recall.
And had you received that before you actually completed the interview with Mr. Murphy?
Yes, I saw that prior to interviewing him.
Did a formal interview actually take place?
Yes.
Where did that occur?
At our strategic office, which is located inside of our state attorney's office in Jacksonville.
And was that interview recorded in some way?
It was.
When you had an opportunity to actually speak with him, did you read him Miranda and go through the full formal process of an interview?
Yes, we did.
During the course of that interview, does his clothing or attire change in some way?
Yes.
How is that?
I believe the jacket came off and he was wearing a tank top, like a wife beater, white style tank top.
With the clothing that he was wearing at that point, could you see more of his body?
Yes.
What parts of his body were exposed to you visually?
After the jacket was off, was
Yes.
his arms.
His arms?
And his neck.
And was there anything that you annotated or marked down, took note of, that was of importance or potential value to your assistance in the investigation?
Yes, prior to him taking his jacket off, I could see the tattoo 1200 block on the back of his neck. And then after he took his jacket off, I observed several other 1200 gang tattoos.
At the conclusion of the interview that you conducted, or towards the end of that interview, did you have an opportunity to ask Mr. Davian Murphy if you could photograph those tattoos?
I did.
And tell me how that came about.
I asked him, JSO procedures, if you have tattoos on your body, they photograph them at the jail. I asked him if I could take pictures of them inside of the room, and I believe his response was like something like facts or like for sure. I took that as like a consent to photograph his body. Also advised him that they were going to be doing it at the jail as well.
When you spoke to him or asked him about the taking of the photographs, was it a situation where you believed you even needed consent to take photographs?
I don't believe so, because I was either going to take them myself or they were going to be taken at the jail, and I would just pull them from our jail inmate photos.
Is it standard process or procedure for your agency in working with the jail that you will assist the jail in taking photos? Is that typical? Or
I don't assist the corrections officers take the photos, but yes, if you go through processing into our jailhouse, the corrections officers will photograph the tattoos that are on your body that is within reason, like legs, body, neck, face, arms. They don't do like private areas tattoos.
would the photos include chest and back? Is
Yes,
that an open
yes, it
area?
would. That would be an area that they would take photographs of the tattoos.
Did you take photos of the tattoos that you saw visually while you were in the course of your interview?
Yes, I did.
And ultimately submitted those photographs as well?
Yes.
When you indicated that you took photographs of pertinent items, you said you saw a tattoo of 1200. What is that, if any, significance to you?
1200 is the name of a gang on our city's east side. It stands for the 1200 block of East 1st Street, and it's the gang that Davian Murphy is associated to.
Were there other tattoos that you photographed that you recognize as having been related to what has now in court been this ongoing rivalry?
Yes, ma'am.
And would that have also represented people who have died as a result of the violence back and forth?
Yes.
For purposes of documenting those things, did you also make a note or write a supplement which indicated that you took those photographs which could be used by you or other officers in your agency?
Yes.
And are you familiar with the statutory criteria for determining whether someone meets gang eligibility requirements?
Yes, ma'am. And tattoos is one of them.
Pass the witness, Your Honor.
Okay, cross.
Good morning.
Hey, how are you?
Good, how are you doing?
Good.
All right, so I want to just start off with this interview with Davion Murphy was recorded, correct?
Yes, ma'am.
And have you watched it?
I have not.
You have not watched it?
I've watched like bits and pieces of it, but I've not fully watched the whole thing over again.
Okay, so if it was yourself and who else was in that?
I believe it was Detective Drabeck.
All right.
Detective Drabeck would have been like the lead on the interview, and I would have been like a second chair, like helping him.
If I were to show you portions of that interview with Davion Murphy, would you recognize them?
Yes, ma'am.
You recognize it? Detective, I want to show you just portions of that
Okay.
interview. I'm hoping that.
Are you going to be introducing the interview into evidence, or?
I am, Judge, and I have it on a thumb drive, and I wasn't expecting to go up this soon, but I do have it on a thumb drive as well as the photographs, so it will be defense. It will be the entire interview, but I'm just going to play portions for the court and for the detective.
Okay, so for the record, this would be what, defense exhibit? I thought we had 3 that was entered, though. That was okay, all right. Okay, so we're going to preliminarily, this will be introduced as Defense Exhibit 2, which would be the recorded interview, I guess, in its totality of Davion Murphy.
Judge, did you say it was defense number 2?
Well, that's what the clerk said.
Yeah, I already have one, I just wasn't spoken on yet, but it's already labeled 1 for defense. It's transcripts.
But is that for this defendant?
Does it not say 1, exhibit number 1?
It says 1.
1 as it relates
Also,
to
Rashad
Rashad
Murphy, I'm sorry.
This is a
So this would be 1 for.
Yes. Okay. All right, this will be Exhibit 1 for Defendant Davion Murphy. Okay.
Just have to allow access from your phone. Whatever that is on your laptop to mirror. Yes. Click the display settings.
You know, I did it before, so we can
ready. You ready? Here we go.
See that?
Yes, ma'am.
All right, perfect, thank you. So, for this portion of it, which is defense for Davion Murphy, Exhibit 1, thank you. Do you see, and I have it stopped, but the beginning of this video appears to be Davion Murphy walking into the interrogation room, and in front of them, there's someone that's standing in a black T-shirt. Is that?
That would be Detective Drabeck.
And then you would be?
I believe I'm behind him, maybe walking in behind the patrol officer, or the transport officer that's there also.
Who pulled his jacket down?
Was not me, so I'm not sure. It could have fell based on the angle of his arms. With your hands behind your back, your shoulders really aren't providing much supportive clothing.
I didn't mean to interrupt you. All right, so let me just kind of sort of play. So then behind him would have been
Yeah,
himself, but-
I haven't entered the room yet.
Okay.
That's me in the green hat.
Yes. And do you see Mr. Murphy kind of pulling up his shoulder and putting his jacket further to cover himself?
I wasn't paying attention to that point, but I
Okay,
can't
well,
really see what he's doing up there.
All right, let me rewind it for you. Let's watch it again. You see the kind of the top of the screen there?
Mm-hmm.
Top left?
Yes.
You'll see his shoulder, his body kind of move where he is repositioning his jacket.
Yeah, I saw that. Let's see that. I don't know if he was doing that for his jacket or the fact that his shoulder may have been uncomfortable by him being in handcuffs. He could have been stretching, or I don't know what his actions were at that time.
If he wanted to stretch, surely after his handcuffs were off, he would have stretched and probably waited, right?
Yeah, you could. I mean, rolling your shoulder would be a form of stretch.
Okay, but it's your testimony that you, nor anyone that you saw or you were present with, pulled his jacket down, meaning Davion Murphy's jacket down.
I did not.
All right, so let me kind of stop it there. You had indicated that Mr. Murphy, Davion Murphy, had, consented? You had read him Miranda, and then he consented to these photographs?
Towards the end of the interview, I asked him about his. I asked him if I could photograph them. I let him know they're going to do it at the jail, and I believe his response was something along the lines of like, "For sure," which implemented to me that I could photograph them.
So it's your testimony that you asked Davion Murphy if
We were speaking about his tattoos, and I asked if I could photograph them, and he responded with facts, for sure.
All right, so then I'm going to speed this interview up, and hopefully I have my times correct. And I'm going to stop. I'll stop at 2:01:01. Wait. Should be 25. We'll stop at 2:01:20.
And is there audio?
No, you're good. I don't have it yet. He is finishing it up.
We don't look alike, dog.
Y'all about the same time. Yeah. He is.
Should I stop? Can you?
Sure, I just didn't know if there was audio, so.
There is audio, I just didn't think the first part was
Yeah, that's
relevant,
fine.
but, okay.
Finishing it up. It just takes a while because we got to get the info from Tampa to here. But what I want to do is I'm going to take some pictures of your tattoos. That way it kind of speeds it up at the gym.
Okay, so at that point, you're telling Mr. Murphy, Davion Murphy, that you're going to take photographs of his tattoos. You're not asking him. Would you agree?
And he agreed with me.
Okay, let me back that up.
All right, one last thing we got. No, you're good. I don't have it yet. He is finishing it up.
We don't look alike, dog.
You don't think so? Y'all about the same time. Yeah. He is finishing it up. It just takes a while because we got to get the info from Tampa to here. But what I want to do is I'm going to take some pictures of your tattoos. That way it kind of speeds it up at the jail.
I'm saying all of them are still current though, and ain't getting nothing.
They don't have them at the jail.
Oh, in the prison? Y'all don't got them y'all can't get them from prison?
So did you ask him or did you tell him? Because it appears from this interview that you're actually telling Mr. Murphy, Davion Murphy, that you're going to take photographs of him.
Yes, I said I'm going to take photographs of your tattoos, and he responded with facts for sure, and then undressed himself, giving consent to photograph his body.
Facts for sure. What does that mean?
Facts for sure, it would be like a yes, and then with the fact that he took his jacket off, mean that he was allowing me to photograph him.
Well, didn't he ask you before he started unzipping his jacket, don't you have these photographs from DOC? Did you already have these photographs? And you indicated no, they didn't have them.
And I answered that our jail did not have photographs of his tattoos.
Okay. So at your direction, Mr. Murphy, Davion Murphy, begins to unzip his jacket.
No, ma'am.
Agreed?
I would not agree with you. I didn't tell him to take his jacket off.
All right. Would you agree that he's in a confined interrogation room, right?
Correct.
With yourself and Detective Drebeck, right?
That right there is Detective Matthew Jones. That's not Drebeck, but yes, ma'am. He was at one point.
Thank you for that correction. He's in a small space, right?
Yes,
With
reasonable.
two detectives.
Yes.
He's just been, and during that interview, would you agree with me that Mr. Murphy, Davion Murphy, indicates to you that he's been drinking and smoking marijuana really the entirety of that day?
I don't recall what he said his plans were that day, what he did that day.
All right, fair enough. Would you agree with me that he really didn't have much of a choice, if that's what you're indicating to the court, is that he agreed or he consented to these photographs?
No, I wouldn't agree with you on that.
All right, so let's kind of play the remainder of this, okay?
Okay.
And I'm at 2:01:53 seconds.
Did you get him in prison?
Yeah, all these came in prison. These are all prison tattoos.
All right. Soldier. Yeah. Did you join in prison? Soldier.
No, I don't know what that is. It's just a Buddha man.
What's KD? You can roll it. You can roll it.
KD, that's my little sister. That's my little sister. You say KD Cosmetics.
Okay.
Makeup.
That's her lips.
Yeah. Her lip gloss brand. She wants to start a makeup company.
187. Nice. What's 490? What's 490?
Time.
There's no 90 minute time. Money bags. Where's the free case badge tattoo at?
Free case badge?
Yeah.
I don't know, fool. I don't know who that is. Who is case badge?
Oh man. Is that like a Celtic thing?
Nah, Saint something. I just remixed it in my own way. Be different.
Oh, okay. You said Saint?
Yeah, the Saint something. You talking about the middle of my neck,
New
right?
Orleans Saints?
Nah, yeah, New Orleans Saints.
You a Saints fan?
Yeah. I just mixed it up in my own way, try to be different. Yeah, that's my favorite player though.
For real? He was wrong.
How many photographs did you take?
Back all the time.
I don't know the exact amount.
Right. Who's Jacoby Wright?
My little brother.
How many brothers you got?
No, I know that's the picture you wanted to get. No, that.
At that point, the photograph that you appear behind Mr. Davion Murphy, and he's got the red tank top on, you're actually pulling his tank top down, right?
No.
No? Okay.
That's the picture
That's
you
the
wanted
money
to get.
one, ain't it?
No, that's the picture you wanted to get.
What's the belly looking like? What you got there? You been on Ozempic?
No.
She's fooling. Check out that. Let me get this. I've been cutting back. And then let me get this Avery one. There's K4 on you. What are you?
All right, so that is in fact you in that interview room taking those photographs, right?
Yes, ma'am.
All right. I want to show you what I'm going to mark as Defense Exhibit 2 for identification. Should be a composite of first witness, unless they mark first.
It's a composite?
It's a composite.
Do you have them marked to A, B, C, D?
I don't have a mark there,
So-
but I would say there was a composite of 1, 2, 3, 4, 5.
Well, do me a favor, do you have a pencil or pen? On the back of them, as you're showing the witness, just put to A, B, C, D, so the record's clear what photo is being shown, okay? So just mark them as you go. Do you have something to write?
You need a pen, counsel?
All right, so
Is there going to be any objection to these being admitted?
No, Your Honor.
Okay, so,
it's going to show
do we have
you
an
this.
Elmo? Can you show them? What are you going to do?
I was going to identify them if you want.
Yeah, the state is conceding that
You're
they can be
good.
admitted, so you don't need to lay the
Do you
predicate.
want to look at them?
It doesn't matter to me one way or another. I don't mind.
All right, so then I'm going to, this is, we got to switch to the Elmo, right?
The tech guru needs to intervene.
Okay, so this is going to be,
So you're showing him, what is this, two?
this is going to be 2A.
Okay, very good.
Did you take that photograph?
Yes, ma'am.
Okay, so this is going to be 2B. Did you also take that photograph?
Yes, ma'am.
This is going to be defense 2C. You took that photograph as well?
Yes, ma'am.
And those are the same photographs that we were watching you take in the interview?
Yes.
And this photograph as well, which is going to be 2D. You should probably zoom out. 2D?
Yes, ma'am.
All right. And 2E. Oh, what's it, F? D.
I thought she's on E.
E.
Yeah. Yes, yes, ma'am.
And then 2F.
Yes.
All right, you would agree with me that all of these photographs thus far are of Mr. Murphy, Davion Murphy, in just a red tank top, right?
Yes.
The jacket has been removed that he had on.
Yes.
And this is going to be G, 2G.
Yes.
You took that one as well? And 2H, that one as well?
Yes.
and 2I,
Yes.
and then 2J.
Yes.
And in 2J, would you agree with me that that would be your hand, that you're pulling down the back of Mr. Davion Murphy's?
Yes, it appears I'm pulling it down to obtain the full photograph, so you can see the entirety of the tattoo.
So your testimony earlier, when you had indicated to us.
Yes, I must have mistaken about pulling it down. I couldn't see it in the video, and I didn't recall it, but seeing this photograph refreshes that I did pull it down to view the entire tattoo.
All right, fair enough. And then K, that's a photograph of Mr. Davion Murphy's stomach.
Torso area, yes, ma'am.
Torso area, thank you. And he's pulling up his shirt, right?
Yes, he did.
At your direction?
I don't know if we exactly told him to pull his shirt up. We asked him if he had body tats, and he showed them off.
And then 2K. You
Yes.
took that one as well?
That one, yes, ma'am.
And would you agree with me that Mr. Murphy during that interview and during that last portion, he had indicated to you that the tattoos that you had just taken of his body, right?
Yes.
Were obtained while he was incarcerated, in prison.
Yeah, he did say that he got some of them while he was in prison, yes.
And do you know the time frame? Do you know when Mr. Davion Murphy was released from prison?
I don't know the exact date that he was released, but if I recall correctly, it wasn't very long before he was back in our custody.
Do you know how long he was in prison?
I do not.
But it was more than a couple years, right?
I don't know his exact prison time.
Did you ever obtain a search warrant or, and that was compound, but this part here, at a hearing, did you or anyone from the Tampa Police Department obtain a search warrant for Mr. Davion Murphy's body?
No, I did. I'm not sure about Tampa. I can only speak for myself. I did not.
Well, they did. So did that have changed your position as to whether or not you felt that you could direct Davion Murphy to lift his shirt up, for you to pull his shirt down in the back, etc.?
No.
Would you have waited?
No.
Is there a reason why you did not obtain a search warrant first?
He was under arrest, and I didn't forcefully take his clothing off to photograph him. I asked him, or I didn't ask him, I said, I'm gonna take photographs of you, and he took his clothing off by himself. And at our jail, they were going to photograph him regardless. So I would have obtained those photographs, whether I did them myself, or if I went to the jailhouse and had them printed off.
Okay, so it's your testimony that when Mr. Davion Murphy went to the jail, they would have photographed both the front and the back.
All of his tattoos, yes, they would have photographed his tattoos.
Did the jail in fact do that?
I'm not exactly sure. I would have to go back and look.
Did you obtain any of those photographs?
No, because I took them myself.
Okay, so if the jail had taken additional photographs of Davion Murphy's tattoos,
I wouldn't have got them because I wouldn't have needed them, because I already had them.
Okay, do you know if they, but as you sit here, you don't know if they took them?
They should have, but I did not go back and double check because, like I said, I did not need them anymore.
Do you know if the Tampa Police Department took them when he was transported to Tampa?
I'm not sure how Tampa and Hillsborough County works, ma'am.
Is it something that, well, is that something that a trained detective, either in a gang unit or homicide unit, would want to obtain?
I already obtained them, so I had no reason to figure out if they photographed their inmates or not.
Do you know if Mr. Murphy, Davion Murphy, had any tattoos below his waist?
That, like I said, we don't photograph in those areas. We only photograph the body.
So if the below his waist would have been photographed either by Jacksonville at the detention facility or in Tampa regarding potential gang affiliated tattoos, you wouldn't know anything about that.
His lower half would not be photographed by the Jacksonville Sheriff's Office.
What if there was gang tattoos that were affiliated with the tattoos that you had taken?
That's not, our jail doesn't photograph below the waist. It's your body, your neck, your face, and your arms.
What if the individual did have any tattoos above the waist and had tattoos that were affiliated with the gang below?
I'm not sure. I don't know how to answer that because that's not what our policies and procedures are.
Would you, if you knew, if you had either on Instagram, what have you, that someone had a tattoo below the waist, either on their thigh, their ankle, what have you, is that something that you would have sought a search warrant for?
I would think it would depend on the circumstances of the photograph.
Well, I'm telling you what the circumstances are, because you indicated that Jacksonville Jail does not take photographs of anything below the waist, right? That's what you testified to.
Correct.
Okay. So if an individual had gang tattoos that you were aware of as a detective, right, you would have sought a search warrant in order to obtain photographs of those tattoos below the waist?
I can't speak on what I could have or should have done or would have done.
Hypothetically,
If he would have had tattoos below his waist, I would have addressed that situation at that time, but based on my investigation, that the tattoos that I photographed were on his body, and I did not photograph anything below his waist, so I can't tell you if I would have done something or I would have done something. At the end of it, I didn't, because I didn't photograph below his waist or anything.
All right, so hypothetically, with your training and experience, right, you're a gang detective at Jacksonville.
Correct.
In Jacksonville. Hypothetically, if you had an individual, a person of interest that had tattoos that you know of, that had tattoos below the waist, what would you have done?
I mean, I don't like speaking on hypothetically. I work off facts.
Factually, I'm giving you a factual hypothetical. I'm giving you that factual hypothetical. Let's just pretend they are the facts. What would you have done? Would you have?
Ma'am, I can't answer that. We're talking about pretending and hypotheticals. That's not realistic to me. I work off facts and things that are happening.
Answer the question.
Ask and answer.
I'm going to sustain the objection.
Do you know if the Tampa Police Department obtained any photographs of Davion Murphy from the waist down?
I do not. I would have to ask Tampa that.
You already testified that Mr. Murphy received these, and he admitted that he received the majority of the tattoos that, or actually he said all of the tattoos that you had taken, right, of him in prison.
I don't know if he said all of them or some of them, but he said he did receive some of the tattoos in prison.
Fair enough. And because you did not attempt to or believe that Mr. Murphy consented to any photographing of below the waist or check with Jacksonville Police Department or, well, he wouldn't be, Jacksonville Police Department as to whether or not he had any tattoos that were gang-related that perhaps he didn't receive in prison. You can't testify to that.
Yeah, I'm not, doubt you kind of lost me on that question, I'm sorry.
I know it's kind of complicated. Do you know whether or not Davion Murphy has any tattoos below the waist that he did not receive in prison?
Oh, I do not. I don't know what tattoos he had prior to prison or the ones he got in prison. We didn't discuss that.
Did you have the tattoos that he allegedly, photographs of the tattoos that allegedly are from when he was in prison? Because you had indicated to Mr. Murphy that you had those or could get those.
Yeah, I could reach out to the Department of Corrections and ask them. They would have like photos as he went along his time in prison. If they noticed more tattoos, I would imagine that the Department of Corrections would photograph them. I've never worked for the Department of Corrections, so I don't know how they operate or what they do, but if he says that they got him and the prison will have documentations, that would make me feel like that Mr. Murphy has noticed that corrections officers have photographed his body over time.
All right. Those are all the questions I have for you. Just wanted to make sure that this was good for the clerk. Thank you, sir.
Yes, ma'am.
When you entered the interview room where Mr. Murphy was located, were the tattoos on his neck visible without any questions or follow-up whatsoever?
Yes.
Were the tattoos on his hands visible without any questions or follow-up whatsoever?
Yes.
Did you have an opportunity to ask him, not command or demand, but to photograph his tattoos?
Yes.
Regardless of whatever his response would have been, would you have still photographed his tattoos based on the observations you made?
Personally, I would not have, if he would have said no, I would not have taken his jacket off of him. I would have just waited and got the jail photos.
Okay, well, you know that the jail is going to take photographs of his tattoos at that point?
Correct.
And you also know that you could, or that the photos exist in the Department of Corrections records, because the defendant not only admitted it, but you're familiar with their processing of inmates.
Yes, that would have just taken a lengthy amount of time to obtain them, dealing with those guys.
But they are in existence and also available.
Yes, they should be.
So inevitably, you would have had them from the Department of Corrections based on the defendant's statements and your knowledge of how the Department of Corrections photographs inmates.
Yes.
And their tattoos during the course of their stay in Department of Corrections custody, correct?
Yes.
And inevitably also would have received them from the jail.
Yes.
There was a lot of conversation or questions that you were asked about above the waist and below the waist. When you're talking about below the waist, are you talking about private areas? For example, a tattoo on someone's genitals would not be something you standard or typically would have taken.
Correct.
Without something else.
Correct.
Now, you were asked about what is visible. If you saw a gang tattoo on an ankle during the course of your interview, is that something you would have photographed?
Yeah, if I could see it.
Now, when you said to the defendant, "What's the belly look like?" obviously you were referencing his stomach.
Yes.
But you didn't make any other kind of command, demand, instruction beyond that, correct?
I did not.
No further questions, Your Honor.
Okay, thank you. May this witness step outside?
Yes, yes.
Okay, thank you, Detective. Any additional witnesses from the state?
No, Your Honor.
Okay, any witnesses for the defense? Okay. All right, very good. That concludes the evidentiary portion of Davion Murphy's motion to suppress. So you want to move on to Sean Gathright?
Yes, Judge, and I believe Mr. Wise is back.
Yes, he is. Okay, all right, you ready to go?
Yes, Your
Okay, state, do you care which one we start with?
Judge, I know the one of the search of the traffic stop and house, we have 5 witnesses, but not, I mean, if you want to do a couple and then go to lunch, it's up to you, Judge.
Okay, let's go ahead and get started at least. Are there any witnesses that you would call initially that will be done completely as far as testifying goes?
Barry, I don't think we'll need again, but I was going to call him third in the...
That's fine. I'm just asking the question. Well,
Judge, I'd rather just go chronologically.
that's fine. Just call a witness.
Okay. Detective Juan Ramos.
We're doing the, I believe, the motion to suppress evidence obtained following the warrantless search of the defendant's vehicle.
Yes, Your Honor.
Okay, Detective Ramos, welcome back. You remain under oath, and we're now proceeding forward with testimony for Sean Gathwright's motion to suppress evidence obtained following the warrantless search of the defendant's vehicle. Okay?
Yes, Your Honor.
And Judge, can I forego background because
That's
we've
fine.
already taken it?
Yep.
Detective Ramos, I'm going to ask you with regards again to the homicide investigation of Charles Jones. You had developed probable cause for the black Chevy Impala, is that correct?
Correct.
Can you tell the court how it is that you came to identify the black Chevy Impala?
The Impala was identified through a mixture of video surveillance footage that was obtained from the homicide scene and at least 2 other locations where the victim was tracked, and then ultimately that was compared to images from license plate readers, and the license plate readers gave us the identity of the vehicle, specifically the license plate number.
And did you run the registration of the black Chevy Impala?
Yes.
And who did that come back to?
Damali Lyle in Jacksonville, Florida, defendant Sean Gathwright's mother.
And is that near or close in time to when you were able to identify the silver Chevy Cruze?
Yes, the way we identified them is they were traveling in tandem at some of these readers.
And you were able to also identify a license plate for the silver Chevy Cruze?
Yes.
Did you run the license plate, the tag for that particular vehicle as well?
Yes.
After you had, and who was the registered owner of the silver Chevy Cruze?
And Jasmine Glennon.
After you had identified both of the suspect vehicles from the video surveillance by running them through the license plate readers, what did you do with that information?
I put them into the state and national databases of felony wanted vehicles.
Now, I want to ask you about both the silver Chevy Cruze and the black Chevy Impala. When you ran the registered owners, were any of them, did they live in Tampa?
No.
So there was no indication, and you did not have any reason to believe they were within your jurisdiction of Hillsborough County, is that correct?
Correct.
And so what type of BOLO did you put out for those vehicles?
FCIC is a statewide database and NCIC a national database.
And what does that do?
That puts the vehicle information, license plate, VIN number, all the descriptors and case number into a database. So if any law enforcement runs that plate, they can see the hit and know that the vehicle's wanted in Tampa.
Okay. And after you are alerted, what is your intent at that point?
To seize that vehicle for evidence.
During the course of your investigation, did you get alerted to a hit by another law enforcement agency of the black Chevy Impala?
Yes, Polk County.
When did that occur?
June 26th as well, June 26, 2024.
A couple of days, 3 days after the homicide, is that correct?
Correct.
Were you at any point during the investigation, were you in a position at that time of hearing that alert to respond to Polk County?
No, I was on my way to Georgia.
To conduct the interview of Rashad Murphy, is that correct?
Correct.
Did you request for other detectives of the Tampa Police Department to respond to Polk County where the Chevy Impala had been located?
Yes.
And who was that?
Detectives David Alverson and Matthew Kirkpatrick.
And after they responded to that area and made contact with the Polk County Sheriff's Office, did they relay back to you what had occurred during their part of the investigation?
Yes.
And what were you briefed as to that?
That the black Impala was located and taken into custody, that at the time that it was located and taken into custody, it was being driven by defendant Sean Gaithwright's grandmother, and that the detectives obtained a statement from Sean's grandmother and viewed some footage from her home in relation to this homicide.
And since Sean Gaithwright was not with the vehicle at that point, did you know where he was?
No.
And had there been, you said that there was some video footage that was recovered, that included Mr. Gaithwright, the date and time when he arrived at his grandmother's house in the Chevy, the black Chevy Impala.
Correct.
And were you briefed as to what he did when he got there?
Yes.
And is that based both on the detectives Alverson and Kirkpatrick viewing the video footage themselves, as well as conducting an interview with defendant Sean Gaithwright's grandmother?
Correct.
And based on that information, did you receive any information about any sort of other vehicle that was now at play in your investigation?
Yes.
What was that?
A gold 4Runner. I was told that Sean Gaithwright arrived to his grandmother's house, swapped out things that were in the black Impala, put them into a gold 4Runner, and left in that gold 4Runner.
Based on the information from the grandmother, was there any indication at that time from the grandmother that she saw any sort of firearms or weapons?
No.
But you were given a description of what he was driving, is that correct?
Correct.
And were you also given information that he had removed any sort of items that were in the black Chevy Impala and placed them into the Toyota 4Runner?
Correct.
After you received that information, did you then brief Detective Draybeck as to the information that you had received from Detective Alverson?
Yes.
When did that occur?
The same day, the 26th.
Were you, did you provide Detective Draybeck with a description of that Toyota 4Runner?
Yes.
What sort of information were you able to give him?
So I was able to find out that that vehicle was registered to Damali Lyle as well, so I was able to give him the license plate number, make, model, year, color, full description on the vehicle.
And after you did that, did you also tell him or ever direct him to stop that vehicle or any orders in relation to that?
Yes, I asked him to see if they can put some resources into looking for that vehicle, because I believe that, Sean Gaithwright was in that vehicle and items might have been taken out of the Impala and put into that vehicle. So they started searching for that vehicle, and they found it.
And was that to conduct surveillance of the video? I'm sorry, surveillance of that particular car?
The ultimate goal was to get it stopped and try to establish probable cause to search it.
And all of that was conveyed to Detective Draybeck with the Jacksonville Sheriff's Office, is that correct?
Correct.
And now I want to ask you, I know that you were not there when that vehicle was stopped or searched, is that correct?
Correct.
There were items later that were searched based on whatever Jacksonville Sheriff's Office authority was to search it, is that correct?
Correct.
Everything that was later done, were you briefed as to that?
Yes.
Okay. And included in there, were you later learned that there were firearms as well as cell phones and laptops and stuff of that nature that were recovered from the vehicle?
Yes.
And before looking at any sort of cell phone, would you have obtained a search warrant to do that?
I would have, yes.
Were you alerted that the cell phones that were obtained in this case, that they were new phones?
Yes.
And based on that, did you then decide to do a search warrant for the defendant's iCloud account instead?
Correct.
Did you ever search or seize the defendant's phone?
No.
And as far as the search warrant, again, for the house that was later done on Sean Gathwright's house, did you participate in that search warrant or execute that search warrant on behalf of the homicide case here?
No.
What is your understanding as to how they did the search for Sean Gathwright's house?
Jacksonville had their own probable cause for Sean Gathwright's house, and within that search warrant for their probable cause, the scope included firearms and firearm components.
And so was that a probable cause search warrant that was done for a homicide investigation that occurred in Jacksonville and had nothing to do with the homicide that occurred here in Tampa? Is that correct?
Correct.
So they had executed a search warrant, and it was authorized by a judge, and they did that on their own for their own case. Is that correct?
Correct.
And during the course and execution of that search warrant, they received, and within the purview of the search warrant, were authorized to take firearms and ammunition. Is that correct?
Correct.
And they processed it and they seized it for their case. Is that correct?
Correct.
And they ran NIBIN and conducted testing on those items pursuant to their investigation. Is that correct?
Correct.
And you were relayed information after those items were processed for their case that it was connected to your case. Is that correct?
Yes.
All right. Your Honor, we pass the witness.
Okay, Cross, Mr. Wise?
Thank you, Your Honor. Your Honor, I know the iCloud warrant came up, but so clear we're going to be doing that motion separately.
That is correct, Judge. Because you had also brought up the phone, I just wanted to touch upon it.
Morning, Detective.
Morning, sir.
Detective Ramos, you first learned of Sean Gathwright's name, correct me if I'm wrong, after you connect the Chevy Impala to his mother and then learn that his mother, Damali Lyle, has 2 children, including Mr. Gathwright, correct?
Correct.
And when you come upon that information, you contact, I believe it's Detective Drabick in Jacksonville, and ask him about this Chevy Impala that you've now seen on the license plate readers. Is that correct?
We spoke about it, yes.
Yeah. And he wasn't familiar with that particular car, correct?
No.
And when you and at that point, had you developed the Sean Gathwright name, or does that come at a different time?
The very first time that I know of the Sean Gathwright name is when I ran the license plate registration to the black Impala and saw that the registered owner was Damali Lyle, and then I did some research into her and saw that she had 2 children that lived at the same address.
Right. And so when you come upon Sean Gathwright and you believe he may have maybe a person of interest to you at that point, you asked Detective Drabick about Sean Gathwright as well, correct?
There wasn't much. At that point, we had not located the vehicle yet, so I did not have the information from grandmother or the video footage of him driving the vehicle to the house after the murder. So there wasn't much discussion prior to the capture of the Impala about Sean Gathwright.
Okay, but at some point prior to the traffic stop, ultimately in Jacksonville, you have asked Detective Drabick about Sean Gathwright, correct?
Well, I believe we spoke about him, yes.
Okay. And Detective Drabick didn't know who Sean Gathwright was.
They didn't have any real history on him at that point.
I mean, he wasn't even familiar with the name, right?
From what I can recall, yeah.
Now, by the time you have connected the Impala and the Gold 4Runner, and you relay that to Jacksonville detectives, I think Detective Drabick, that is on or about June 26th at noon. Does that sound right?
About that, yes.
Okay. And you have said that the ultimate goal was to have that 4Runner stopped and develop PC to search it, correct?
Correct.
I mean, but you agree with me, you've got to have a legal basis, number one, to stop the car, and number two, to search the car, right?
As the Supreme Court's ruled, the pretextual traffic stops are perfectly legal, so
Well, sure.
they had to develop their own PC.
Right.
But yes, it's a pretextual stop.
Pretextual stops are legal, but
Yeah.
you've got to have cause to stop the car first, right?
I believe they developed their own cause, yes.
Right, and you would agree with me, based on what you had seen to that point, you don't have enough to conduct a traffic stop of this Forerunner.
At that point, the decision was made prior to that there wasn't enough probable cause to seize the vehicle itself for this investigation, yes.
And you're aware, even if a traffic stop is made, then you have to have probable cause to search the car for some reason, correct?
Again, we had the information that items were removed from the car and placed into that car. So again, there was some evidence that that car was in play in relation to our murder, but there wasn't a warrant that we were seeking for that at that
And
time.
just to clarify for the record, we're talking about the Forerunner, right?
Yes.
Okay, thank
And
you.
to ask again, my question is, for the Forerunner, you recognize, you're a seasoned detective. If you pull it over for a traffic stop, an alleged traffic infraction, you got to have some probable cause to search the car. You can't just go in and search the car.
Correct,
right?
correct.
And at that point, even with your suspicions, was not enough to justify seizure and search of the car.
On its own, no.
And you said about noon on the 26th, you're notifying Jacksonville, basically that you're hoping to be able to search this car.
I told them that a suspect in this homicide, was likely traveling in this vehicle, and I asked them to look for it, yes.
And then within approximately 2.5 hours of that time, the car has been stopped and searched. Does that sound about right?
It was that same day in the afternoon, yes.
With about 2:30 that afternoon?
I can't recall the exact time that they stopped the vehicle, but it was somewhere in that afternoon.
Approximately 2.5 hours after you contacted them, does that sound about right, that they would have stopped it and searched it by that point?
I can't recall.
Okay. And I think you covered this, but you don't have any part in the stop and search of the car in Jacksonville, right?
Correct.
Well, are you in Georgia at that point or in Tampa?
I'm either traveling to Georgia or in Georgia.
Okay. You mentioned the knowledge you had of Jacksonville, then obtaining a search warrant for Mr. Gathwright's house later.
Correct.
But you were aware that they were relying on evidence that was obtained from that traffic stop to get the search warrant for the house in Jacksonville, correct?
Correct.
And you also mentioned that evidence is taken from the house that is being investigated in connection with the case in Jacksonville. But there's also evidence taken from that house that you ultimately rely on in your investigation, correct?
Correct.
That's all I have. Thank you, sir.
Okay, redirect?
No, Your Honor.
Okay. Okay, Detective, that's it for this motion. So, all right, so it's 12:02. Is the next witness lengthy or
No, Judge.
short? Okay, let's go ahead and call that next witness then.
Detective calls Christopher Draybeck.
This is Sean Gathwright's motion to suppress evidence obtained following the warrantless search. It's the same one, yeah, we're not done yet. Gleaned from the warrantless search of the defendant's vehicle. You may proceed.
Detective Draybeck, on June 26th of 2024, again, were you contacted by Detective Ramos from Tampa Police Department in reference to a gold Toyota 4Runner?
Yes.
And were you given details as to the make and model and the connection to the black Chevy Impala and Sean Gathwright by Detective Ramos?
Yes.
Was there a request from Detective Ramos to conduct surveillance on that vehicle and see whether or not probable cause could be ascertained or developed in order to do a search of that vehicle?
Yes.
Who were the two detectives who were assigned to surveil the vehicle?
I know ultimately Detective Chris Berry and Detective Craig Griffin took on that role.
And was that, and you were aware that that was being done, is that correct?
Yes.
And did you participate in the surveillance of of those vehicles?
No.
Okay. Your Honor, that's all I have for Detective Drabeck.
Okay, Cross?
Good afternoon.
Detective Drabeck, you're in the gang unit in Jacksonville?
Yes.
You're contacted by Detective Ramos at some point back in June of '24 and asked about a Chevy Impala with a certain license plate number, correct? Does that sound familiar?
Yes.
You didn't, that Impala and license plate number was not familiar to you, correct?
It was not.
All right. And then you're asked, I don't know if it was the same time or sometime, within a day of that, maybe, you're asked about a guy named Sean Gathright as well, right?
I don't recall if he specifically asked about Mr. Gathright, but I do recall him inquiring about the vehicle.
Okay. And you recall him, telling you that he found the name of a woman, Damali Lyle, that the vehicle was registered to, and she had 2 children. One of them was Sean Gathright. Does that sound familiar?
Yes, I do remember him mentioning Miss Lyle.
And I guess what I'm ultimately getting at is before the name Sean Gathright is relayed to you from Tampa Police, however it may come, that was not a name you were familiar with at all?
No.
Correct. You're not present when the car is searched, the 4Runner, is that right?
Correct.
But am I correct, you author the search warrant for Mr. Gathwright's residence later on?
No.
Okay. Do you have any part in providing any of the information that's going to be relayed in that search warrant affidavit?
No, sir.
Okay. And am I correct, you're present when that warrant is executed, but you don't actually go in the house?
I was present at the point of the residence being secured and the search warrant being read to the occupants of the residence. At that point, I left.
Okay. And did you have any communication with Detective Ramos at any point after that regarding the search of the house?
As it relates to Sean Gathwright's residence,
Yes.
no, because I was not there.
Thank you, sir.
Okay, redirect?
No redirect, Your Honor.
Okay, thank you. You're done as far as this motion goes. All right,
you.
is the next witness lengthier?
No.
Let's go ahead and call the next.
Maybe just a little bit. but
That's
pretty-
fine.
Okay. Detective Barry?
And is that the witness that will be done after he testifies?
Yes.
Okay.
solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may proceed.
Thank you, Your Honor. Please state your full name for the record, spelling your last name for the court reporter.
Christopher Berry, B-E-R-R-Y,
How are you employed?
Jacksonville Sheriff's Office.
How long have you been with the Jacksonville Sheriff's Office?
10 years and a couple months.
Were you working on June 26th of 2024?
Yes,
On that date, what unit were you assigned to?
I was assigned to the Criminal Apprehension Unit.
Were you tasked with conducting surveillance on a gold Toyota 4Runner involved in an investigation, a homicide investigation for Tampa?
Yes,
Who were you assigned to do that with?
I was working with the gang unit.
And on that date, June 26th of 2024, were you given some information about
Hold
where
on.
the look?
Mr. Harmon, Ms. Isber, you all need to whisper. Go ahead.
On that date in conducting surveillance, where did you go? What area of town?
It was the Northside by the airport.
Why did you go to that location?
That's where we were told. I come in to work a shift with them, and that's where I was told they were.
And approximately what time did you go to that location?
It was in the afternoon. I don't recall. It wasn't dark, and I know it wasn't early in the morning.
Who were you working with?
The gang unit.
Was Detective Griffin one of the detectives that you were working with that day?
Yes.
And what sort of vehicle were you in?
If I recall in the time, I think I was in an F-150.
At some point, did you observe or see or come into contact with that gold SUV?
I did.
And can you explain where that happened?
It was the 2700 block of New Berlin Road. I can't remember the cross street. It's in between Dunn Creek and Yellow Bluff.
And what were your observations at the time?
It was driving above the posted speed limit, and that had dark window tint, so a traffic stop was conducted.
What sort of area were you in at the time?
It's mostly a residential area.
And do you recall what the speed limit was?
I don't recall off the top of my head, somewhere between, it'd be 35 or 45.
And you said that there were 2 reasons the vehicle was stopped. Is that correct? You said
That's correct. The tint, yep.
And what else, speeding?
It would have been above the posted speed limit, but I didn't have an actual, basically I was just doing off of visual estimation.
Visual estimation.
Yep.
Do you receive training in order to be able to make visual estimates of speeding?
Yes.
Can you tell the court what sort of training you receive in this area?
It's a state accredited class through the state of Florida.
And do you receive a certificate after you complete that course?
Yes.
How long is that course?
40 hours.
40 hours. And can you tell the court what sort of training that certification class, that week-long class entails?
Basically, you go out and do, the class as a whole will go out and do traffic enforcement, but it's more or less training as in visual estimation of how fast a car is going, and then you would, verify it with a laser or radar.
At the end of that week-long class, are you actually tested to see if your visualization of the speed, estimate of the speed is accurate and tested against an actual radar recorded reflection of the speed?
Yes.
And is there a requirement in order to get that certificate? Is there any sort of requirement as to your accuracy to the actual reflected speed on the radar?
Yes.
And what is that?
It's between 3 and 5.
And were you able to pass, and were you, when you say 3 or 5 what?
Miles per hour. So
3 or
your
5.
estimation has to be when the what was captured on radar laser.
So that's how you're tested, and that's how you are certified. You actually give an estimate, and it has to be within 3 to 5 miles of the actual recorded speed by radar.
That's correct.
And did you pass that, and were you certified with that estimation?
Yes.
And so after you did that, do you still, in the course of being in the gang unit, do you still actively do that on a regular basis?
During patrols, yes, you could.
Approximately how many times would you say you have to do that in any given month?
It just depends. That's not my on-view activity. Is not my normal course of duty.
But it is something that you have done more than once, is that correct?
Oh, absolutely.
And that was something that you were certified and trained to do?
Yes.
And back on June 26th of 2024, you did a estimation as to speed on that Toyota 4Runner, is that correct?
That's correct.
And was that over the speed limit?
Yes.
And do you recall at this time whether or not you can remember how fast he was going over the speed limit?
I don't recall exactly. It was, based off of the tint and then that also second violation.
So you had a second reason to stop that vehicle, is that correct?
Correct.
And how was the Toyota 4Runner violating the tint requirement?
Based on the visual estimation of how much you could see into the car, the tint looked darker than what it was supposed to be. Once the traffic stop was done, a gang detective had a tint meter, and they measured the tint, which showed above or below, however you look at it, above or below the allowed amount.
It was in violation, is that correct?
Correct, yep.
The legal amount of tint that could
That
be
is
on the
correct.
car.
And then I wrote a citation for that.
You actually gave him a ticket, correct?
Yes.
Okay. And when you stopped him, was Detective Griffin, was he present as well when the vehicle was stopped?
He was right behind me, yes.
Did you ask for the defendant's license?
I did.
And at some point after receiving that license, you stepped away from the vehicle, is that correct?
That's correct.
And then there was interaction with Detective Griffin.
That's correct.
Your Honor, at this time, we'd pass the witness.
Okay, cross.
How are you?
Doing well, how are you?
Good.
All right, so Detective, you weren't familiar with Sean Gathright before this traffic stop's conducted, correct?
No, sir.
And this is happening about 2 in the afternoon ballpark, is that right?
It would be, if I had referred to the arrest report, then I'd be able to tell you the exact time, but it was in the afternoon.
Okay. And you are a member of the Criminal Apprehension Unit?
That's correct.
So you're not a traffic officer at this time,
That is
right?
correct.
Criminal apprehension, you're trying to apprehend
Criminals.
potential criminals, right?
Yep.
Okay. So you're, in this kind of situation, you're going to be looking for a reason to try to stop a target vehicle. Is that fair?
Yeah.
And that's ultimately what Jacksonville is trying to do at this point, right? Trying to find some reason to stop this forerunner?
Correct.
And you're primarily working, I think you said, with Detective Griffin, correct?
He was, so it just, I went out to help them during this incident, and it's just kind of with a vehicle moving, traffic, it's just how it ended up. I was the first one in line.
Gotcha. But you, at that point, you and Detective Griffin are more or less in the same area of, I think it's New Berlin and Dunn Creek roads.
Right. We passed that going, I could call it westbound, but past Dunn Creek going west on New Berlin.
Okay. You're in separate vehicles, though, right?
Yes, sir.
And I think when the forerunners first spotted, you're basically, you're closer to it than Detective Griffin, correct?
It was at the River City Marketplace. I don't remember our exact route. I remember being at the River City Marketplace, which is farther away from where the traffic stop was conducted. I don't remember the route of how we got there, how we made it to Dunn Creek, or to New Berlin passing Dunn Creek.
At some point, though, before the traffic stop's conducted, you and Detective Griffin received information from other law enforcement that this target forerunner has left the residence that it was parked at, right?
So I don't know that I was out there when, if it was at a residence and as it left the residence, they followed it. I remember being out there and becoming a part of this investigation when it was at River City Marketplace.
Okay, all right. Well, ultimately, when you first spot the forerunner, you're maybe 50 yards away from it at that point, is that correct?
I don't remember exactly, maybe a car length or two,
Okay.
from what I recall on Dunn Creek.
Let me ask this, when you first spot the car, where is Detective Griffin in relation to you?
He would have been behind me.
Okay, how far behind?
Well, when you say first spot, when we were traveling on Dunn Creek, I wouldn't call that the first time I spotted it, because it was at River City Marketplace and we'd already seen it.
Right.
When we were traveling on Dunn Creek, it would have been target vehicle, me, and then Detective Griffin was behind me.
Okay. And before the traffic stop is initiated, because I think it's Detective Griffin who actually initiates the stop, am I correct?
So he was behind me. I was the one that initiated he would have, the defendant would have saw my lights first. When you work in a shift like this with a larger unit, somebody that gets on the radio and calls out the traffic stop, I don't even know who that was that would have done that. Anybody could do it. So I could do the traffic stop with another officer, like another detective behind me. A third detective could pull up and they say, hey, did y'all call this out? Basically get on the radio and say, hey, traffic stop this place this time, blah, 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 and read it out. That could be, so who's saying that called it on the radio may not be, it could have been, I don't know if Detective Griffin did that or who.
Fair enough. But in any event, when you're observing the traffic infraction and then initiating the stop, you and Detective Griffin are in close proximity to each other.
Absolutely,
right?
yes.
And you pursue the car for about a quarter of a mile before you initiate the traffic stop, is that right?
It would have, anywhere from the traffic stop was done in between Dunn Creek and Yellow Bluff. Okay. That's a 2-lane road, so there's not, usually if I'm conducting a traffic stop, I'm finding a place where I can conduct it and there's a safe place to pull over, which there was because we were at that convenient store.
You didn't prepare a report in connection with the case, correct?
No, I did not.
But you were where Detective Griffin did?
I wrote a uniform traffic citation.
The citation, right,
Correct.
but not a separate police report.
That is correct.
Detective Griffin did, or
I believe so. So from this incident, I was a part of it. I had to leave and go do something, and then I come back, so I wasn't a part of the search of the car or any of that stuff.
And you wouldn't have any reason to think that whatever Detective Griffin documents in his report or what he recalls would be incorrect, right?
I don't think so, no.
If he said that it was followed for about a quarter of a mile, would you have any reason?
I would agree, yeah.
Okay.
From the River City Marketplace to the time where the traffic stop, no, that's more than a quarter of a mile, but from the time that it was, I guess you could say, decided to do a traffic stop, Dunn Creek to the stop location. That's probably about right.
Okay. And the sole bases for the traffic stop are speeding and window tint.
Correct.
You don't recall what the speed limit was in the area where you pulled him over?
So it's going to be anywhere from 35 to 45. I don't recall off the top of my head. But it's a residential area. It's somewhere in between 35 and 45.
Okay. And you didn't issue a citation for speeding, correct?
That's correct.
And you didn't write a report, right?
That's correct.
You didn't document anywhere what the estimated alleged speed was the forerunner was driving?
No, sir.
And you don't remember what you think the speed was there?
It's somewhere between 35 and 45. I don't know the exact speed limit on that road.
But I think you testified in direct, you don't remember how fast you thought the forerunner was going either. Right?
I don't recall offhand. Go ahead, sorry.
You don't recall how fast the forerunner was going? I didn't mean to cut you off.
Not offhand.
So we just have to take your word for it now, a couple years later, that that forerunner must have been speeding.
I remember it above the speed limit. I don't recall, and I know that we wrote a citation for the tint violation under Florida statute, and
I'll ask you about that, but as far as the speeding goes, we've got to rely on what you tell us now a couple years later that it must have been speeding.
Yes, sir.
Okay. And I don't remember if this was covered on direct, and it's probably, clear now, but no one clocked the forerunner on a radar gun, right?
That's correct.
Let me ask about the window tint now.
Yes, sir.
The windows that you believe were in violation were rear windows in the vehicle?
Yes, sir.
And the citation you ultimately issue was for the tint being less than 15%?
Yes, sir.
You didn't measure the window tint yourself, correct?
I think it was Detective Bias that did the violation.
And you don't know what the results were of his testing?
On there, it should be possibly on the comment, should be in the comment section of this uniform traffic citation.
Okay.
But offhand right now, I do not remember what he said it was. And it would be reported on body cam as well.
Yeah, that was one thing actually I forgot to ask about. Neither you or Detective Griffin have dash cams when the traffic stop is conducted, right?
No dash cams.
And did you have a body cam?
I did.
You did, but it wasn't activated until after the search begins, is that right?
Well, I was never part of the search. It should have been from the time I did the traffic stop until, I was never part of the search. So real quick, I did the traffic stop, went back to my car to run the license and then ultimately write the citation. More detectives showed up. They were a part of the search of the car. I never searched the car, never was a part of any of that.
Yeah, and that was probably, a misleading question I asked. Before the traffic stop is conducted, you don't have the body cam running. Is that right?
It should have been on, from my recall. When time I do the traffic stop, turn the lights on, I should have my first interaction with him and then go back to my car to write the citation.
Okay. With the body cam, as you recall, would it have captured the visual speeding?
I don't know, based on where my camera is on my vest or was at the time, I don't know if it picks up how fast I was traveling.
Okay. Mr. Gathright is cooperative with you, would you agree?
For me, yes.
And when the traffic stop's conducted, he gives you his driver's license?
That's correct.
You run the license, there are no issues with the license, right?
Not that I recall offhand. I mean, if there was a suspension or something like that, then I would have probably wrote a citation for a suspension. Or if he was on an ID card, he would have got no driver's license, never had one or something to that effect.
Okay. And you also ran the license plate, right, for the forerunner?
You could go back and pull the records. Probably I did, more than likely. I don't recall. At this moment, don't remember typing it in, but I know for a fact it was done because when the traffic stop was called out, it would have been ran by dispatch.
Okay. And whether you ran the plate or not, you at least get the license, run the license. And while you're doing that, you have contact with Mr. Gathright, get the license, go back to your car and run it. Detective Griffin stays with Mr. Gathright at the car, correct?
Correct.
And it's not until you come back to the car that Detective Griffin tells you that he has believed to smell a faint odor of marijuana. Is that right?
I don't remember having any, from what I recall from my body camera, I do the traffic stop, go back to my car, and then I never leave my car and go back up for the search or when he was pulled out. I was never up there for
Okay.
that.
All right.
There was other detectives that arrived, but it wasn't just me and Detective Griffin the whole time.
So Detective Griffin doesn't even tell you then that he's detected marijuana?
I don't recall being told that by,
And you never smelled the odor of marijuana either, correct?
I was with him for a couple seconds to get the license and go back to the car.
But at that time, I mean, you're in close proximity, you're right at the driver's side window, right?
I never smelled it, no, sir.
That was my question. But
Yeah.
you're right next to the car, right? At some point, like,
I walk up, tell him the reason for the stop, get his license, and go back. I did not stand there for a decent amount of time.
but you're right at the driver's window. I mean, you're right there to where he can hand you the license without reaching
That's correct.
far out, and you don't smell marijuana.
Not that I recall.
No other questions, thank you.
Okay, redirect.
Just briefly, Your Honor. Detective, you did this visual estimation while you were in your vehicle, is that correct?
That's correct.
And you were able to discern that he indeed was speeding, is that correct?
He appeared to be driving above the posted speed limit.
And that was the basis why you pulled him over, as well
Along
as,
the tent. That is
tent.
correct. 2 violations.
and even though you're not the one that actually measured, you were there present when another detective from the gang unit came out and measured the actual tint, is that correct?
That's correct.
And based on that, based on your observations, as well as the confirmation, you issued a citation.
That is correct.
I have nothing further, Judge.
Okay, all right, may this witness be excused?
Excused, yes, Judge.
Okay, thank you, you are free to go.
Thank you.
All right, just press, search the vehicle. State who's going to be your next witness.
Detective Griffin.
For the record, defendants are all present with counsel, states present.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Yes.
Okay, you may proceed.
Thank you, Your Honor. Please state your full name for the record, spelling your last name.
Detective Craig M. Griffin, Griffin.
How are you employed?
Currently with the Jacksonville Sheriff's Office,
How long have you been with the Jacksonville Sheriff's Office?
almost 17 years.
What unit are you currently assigned to?
Currently assigned to the Gang Investigative Unit.
How long have you been in the gang investigative unit?
A little over 5 years now.
And were you working on June 26th of 2024?
Yes, ma'am.
On that day, were you tasked and assigned with conducting surveillance on a gold Toyota 4Runner?
Yes, ma'am.
And was that part of an investigation that was jointly being done with the Tampa Police Department for a homicide that occurred down here in Tampa?
Yes, ma'am, it was.
Who were you working with on that particular day?
Other members of the gang unit.
And what was your assignment?
More or less assigned to the outer perimeter of the neighborhood.
And you were conducting surveillance on that gold Toyota 4Runner, is that correct?
That's correct.
And was the purpose to see whether or not you could see a traffic infraction?
Yes, ma'am.
And where were you, do you remember where you were stationed at when you first saw the Toyota 4Runner?
I was on New Berlin Road.
That located in Jacksonville, Florida?
Yes, ma'am.
Did you have any information as to where to set up in order to put eyes on that Toyota 4Runner?
No, ma'am, just in the general area.
And did you at some point while you were stationed there see the Toyota 4Runner?
Yes, ma'am, I did.
Did you also have like a tag information as well as the description and make and model?
We had a description, make and model. I don't recall if we had the tag or not, but I believe we did.
And at some point you said that you saw that. Do you remember approximately what time it was when you came into contact and made visual observation of that vehicle?
Roughly around 1400 hours, 2 o'clock.
2 o'clock. 2 o'clock in the afternoon?
Yes, ma'am.
And can you tell the court exactly what you observed?
I observed the vehicle traveling south on New Berlin Road. Observed it for a little while. I've seen that it was traveling at a high rate of speed. Got up closer to guesstimate the estimated speed in which it was traveling, seen that it was traveling faster than the posted speed, and also observed the dark tinted windows on the vehicle, and then decided to do a traffic stop.
Was there another detective, Detective Berry, that was also working and in a different vehicle?
Yes, ma'am. He was with me.
And you said that you made a visual observation that it was speeding over the posted limit. Is that correct?
That's correct.
Do you have any sort of training or certification in being able to visualize and estimate speeds of moving vehicles?
Yes, ma'am. FDLE offers a course in speed and radar measurement, in which is a week-long course that I took and passed in early 2019, 2020.
And do you become certified after you take that class?
Yes, ma'am.
Can you tell the court what that entails, that sort of training that you did?
So that training is in large part of you going out and observing vehicles traveling. You match their speed with what you estimate they to be, and then you verify it being using either your speedometer, a laser, or radar.
So there's something to measure what your estimation is that correct?
Yes, ma'am.
Okay. And at the end of that week-long course, are you then tested to see your accuracy in your ability to be able to estimate the visualization or visualize the actual speed?
Yes, ma'am. There's actually two exams. One is strictly based off the estimation of speed. It's approximately 50 cars in which you have to estimate the speed, and then another was an actual written exam at the end.
Okay. And when you are looking at these 50 different cars and estimating speed, is there a score that is considered acceptable for you to be certified in this area?
Yes, ma'am.
And what is that?
You had to be 50. You had to be 100% correct.
You had to guess the speed of all 50 cars 100% correct?
Yes, ma'am. Within 5 miles per hour, plus or minus.
And you were able to do that, sir?
Yes, ma'am.
And you became certified in this area?
Yes, ma'am.
And during the course of your work in the gang unit, is that a skill that you continue to utilize in your work?
Yes, ma'am, I do.
Approximately how many times would you say that you would have to visualize and make those speed estimates?
Once to twice a week.
So that's something that you have regularly kept practice at, is that correct?
Yes, ma'am.
And going back to June 26th of 2024, did you have any sort of radar gun with you or anything other than your ability to visualize the speed?
No, ma'am, just the my speedometer in my car, which is regulated through our city department.
And so you were in a moving vehicle at the time when you are surveilling the Toyota 4Runner involved in this case?
Yes, ma'am.
So you have that visualization as well?
Yes, ma'am.
And was the car going greater than the speed that you were going?
Yes, ma'am.
And you said that it was going greater, it was speeding over the speed limit, is that correct?
That's correct.
Was there another basis to pull over the vehicle?
There was.
And what was that?
The dark window tint.
And did you have emergency lights on your vehicle?
Yes, ma'am.
When did you initiate those?
Shortly near New Berlin and Sap Road.
And was your intent to conduct a traffic stop at that time based on your observations?
Yes, ma'am.
And did you and did Detective Berry do that?
Yes, ma'am.
And it's who received who received Sean Gathrigh's license?
Detective Berry was the first to make contact with him, and then I walked up and made contact as well.
Okay. And what did Detective Berry do when he first made contact with the person in the Toyota 4Runner?
He identified who he was and then asked for his driver's license, I believe.
What happened at that point?
Mr. Gathright handed him his Mississippi driver's license, and Detective Berry then went back to his vehicle.
Did you remain at the driver's side door of the vehicle?
I did, yes, ma'am.
Was there one or more occupants in the vehicle?
No, ma'am, just one.
And you said that you guys received a license, and who did that belong to?
Mr. Gathright.
And is Mr. Gathright, is he present in the courtroom today?
Yes, ma'am.
I'm sorry, sir, can you please point him out and describe what he's wearing?
The light-skinned gentleman in the orange jumpsuit.
We're approximately in the lineup, because we have...
Oh, I'm sorry. He has on a red. He'll be the one in the middle.
from where I'm looking at. I only see 3. I can't see the other one.
Okay.
Next to the lady in the pink.
Okay.
To the left of her.
All right, very good. Thank you. The record shall so reflect that he's been identified.
So after Detective Berry received his license, did you remain at the driver's side door with the defendant?
I did, yes, ma'am.
And what happened while you were at the driver's side door?
We engaged in a conversation.
And when you were engaging in a conversation with the defendant, did you make any other observations?
I did, yes, ma'am.
And what was that?
I detected an odor of marijuana.
Okay. At that time, was the window up or the window down?
The window was down.
And you said how long had you been with the Jacksonville Sheriff's Office?
Going on 17 years.
And during your 17 years with the Jacksonville Sheriff's Office, have you had occasion to come into contact with cannabis or otherwise known as marijuana?
Yes, ma'am.
And do you recognize the smell or odor of marijuana, both burnt or in raw form?
Yes, ma'am.
And is that what you detected back on June 26th of 2024?
Yes, ma'am.
And besides your on-the-job training, your lengthy experience at the Jacksonville Sheriff's Office, did you receive any sort of courses or additional training in that area, being able to detect the odor of marijuana and other narcotics?
I've taken courses in the past put on through HIDA in reference to drug recognition.
And how often would you say during the course of your employment with the Jacksonville Sheriff's Office that you had occasion to come into contact with cannabis, also known as marijuana?
Several times throughout the month.
After you detected the odor, what did you do?
I asked questions in reference to the odor that was coming from the vehicle.
Can you tell the court what specifically did you ask of the defendant?
I believe I asked Mr. Gathright if he had smoked today or if he was in possession of any marijuana.
And what was his responses to those questions?
He said no.
And after you asked him those questions, what did you do?
I asked him to step out the vehicle.
Why did you do that?
So do a probable cause search of the vehicle in order to locate the marijuana.
And did you then proceed, did you yourself conduct the search?
Yes.
Were there other detectives from the Jacksonville Sheriff's Office, the gang unit, present during that time?
Yes, ma'am.
But you are the one that searched the vehicle, is that correct?
That's correct, yes, ma'am.
Can you tell the judge what happened during the search of your vehicle?
Mr. Gathright stepped out. I asked him to step to the back of the vehicle. When he did that, I then began the search of the vehicle. Observed a black backpack in the passenger seat. Inside that bag, located I believe a grinder or a mason jar that had marijuana residue. I also located a plastic bag of what appeared to be mushrooms. Continued searching, found a firearm in the center console. And then at that point, we stopped and I told them to detain Mr. Gathright.
So when you are searching the vehicle, are you searching for marijuana during the entire search of the vehicle?
Yes.
And during the course of conducting that search for marijuana, you came across a firearm, is that correct?
Yes, ma'am.
What type of firearm was it?
It was a Glock handgun
Where was it located?
in the center console.
And you said at that point you stopped the search?
Yes, ma'am.
Why did you do that?
Just to have Mr. Gathright detained.
And why did you detain him at that point?
Because at that point, I had probable cause to place Mr. Gathright under arrest.
For what?
For armed possession of a controlled substance, along with drug paraphernalia.
And is there also a violation with the defendant's age and possession of a handgun?
Yes, ma'am. At the time, he was 18.
And what age do you have to be to own the handgun?
21.
And there was no one else in the vehicle, is that correct?
No, ma'am, there wasn't.
Did you then have a inventory search done on the vehicle?
We did, yes, ma'am.
And was the vehicle inventoried for all of the contents?
That's correct, yes, ma'am.
What was located other than you had testified to the drug paraphernalia as well as the drugs, is that correct?
That's correct.
Did you do any sort of presumptive tests on the cannabis that was collected?
Other than based off of odor, no, ma'am.
And you said that he was placed under arrest for that, is that correct?
Correct, yes, ma'am.
As well as for the handgun?
Correct.
And the inventory search of the vehicle, were there additional firearms or parts associated with firearms that was recovered during the inventory search of that vehicle?
Yes, ma'am. If I recall correctly, there were firearm parts and accessories along with shell casings, cell phones,
and live ammo, I believe.
All of that was inventoried, is that correct?
Yes, ma'am.
And is that standard procedure when a person is arrested and a vehicle is taken into custody?
That's correct. Yes, ma'am.
Also, part of the standard procedure and protocol when conducting an inventory search, what happens when there is ammunition and firearms that are recovered in any sort of search?
They go through a process called nibing.
And that is done in every single case, whether there are firearms and ammunition, regardless of it's an inventory search or a search warrant, is that correct?
That's correct. Yes, ma'am.
And that is standard procedure?
Yes, ma'am.
And you said that he was placed under arrest, is that correct?
Yes, ma'am, he was.
I want to ask you about, and what were the charges again?
Armed possession of a controlled substance along with drug paraphernalia, and then he received a citation for the dark window tint.
And I want to ask you about the speeding. You did your own independent estimation of the speeding based on your training and qualifications, is that correct?
That's correct, yes, ma'am.
Did you cite or give him a traffic ticket for the speeding?
No, he's only issued a warning.
And why not? And why issued only a warning?
It was convenient at the time to issue a warning. He had already read the citation for the dark window tint.
And after all of the search and surveillance of that vehicle was completed, did you report your results to Detective Drabeck or officers from the Tampa Police Department?
Yes, ma'am.
Your Honor, may I have one moment?
Yes.
Your Honor, we pass the witness.
Okay, cross.
Hello, sir.
Detective, you were familiar with Sean Gathright prior to the day you conducted traffic stop, right?
I was not, no, sir.
And when you conduct a traffic stop, there's basically somewhat of a concerted effort amongst Jacksonville gang unit detectives to try to find a reason to stop this forerunner. Is that
Yes.
fair to say? And when you were in the area of, I think it was New Berlin Road and Dunn Creek Road, you had gotten word from another officer sometime around that point that the target forerunner had left a residence.
That's correct, yes, sir.
And was it believed to be heading in the direction where you were positioned?
I don't remember where it was headed to. It was more or less they notified us that the vehicle had left.
Okay. And it's about 5 to 10 minutes later that you actually see this gold forerunner, is
Correct,
that right?
yes, sir.
And at that point, you're with Detective Barry as well?
That's correct, yes, sir.
Separate cars, but you guys are kind of in the same general area?
Yes, sir.
And when you first see the forerunner, am I correct, you're about 50 yards away from it approximately?
Yes, sir.
And you don't have a dash cam in your car?
No, sir, I don't.
And I think you're wearing a body cam, but you don't activate that until the traffic stop is actually beginning, right?
Correct, yes, sir.
You follow the forerunner for about a quarter of a mile?
Yes, sir.
Before you stop it, right?
Mm-hmm.
Okay. And the sole basis for the stop, just so we're clear, is the speeding and the window tint violation?
That's correct, yes, sir.
If you recall, when we had the deposition, you may recall this, you didn't recall what the speed limit was on that road where he was stopped. Do you know now? Do you remember what it was?
I didn't go and check. It's either 35 or 45.
Okay.
I can't remember.
And you didn't use any kind of, I think this was covered already, but you didn't use any kind of radar gun, laser, or anything to clock how fast the forerunner was going?
No, just my odometer itself.
Okay. Well, was it were you pacing it with your odometer, or were you visualizing it as you described?
So the way it works is you visualize and you guesstimate the estimated speed, and then what you do is you get close to the car and you start speed matching, and then at that point you verify through your speedometer how fast the vehicle was going.
Okay. And you did all that in that quarter mile distance that you were following?
Yes, sir.
The class that you told us about on direct that you took that taught you how to estimate speed.
Yes, sir.
That was in 2020?
2019, 2020.
2020. So 4 to 5 years before this took place?
Yes, sir.
All right. And did you have any kind of follow-up class since that time?
No, sir.
You wrote a report in the case, correct?
Yes, sir.
And I know you didn't issue a citation for speeding.
No, sir, I did not.
You didn't list in your report what you believe the speed that the forerunner was going might have been?
No, sir, I did not.
The tint, you did not measure the window tint on the truck, correct?
I didn't. Somebody else on scene did.
And just for the record, I'm sure we all know, but a 4Runner, by the way, that's a sport utility vehicle, right?
That's correct.
And you don't know what the readings were on the tint meter, whoever may have done that, you don't know what the results were?
No, they should be on the citation.
The citation that was issued by a different officer?
Correct. Yes, sir.
All right, when you initiate the traffic stop, Mr. Gathright pulls over at basically the nearest safe location he sees, right?
That's correct. Yes, sir.
He's cooperating with you.
He is. Yes, sir.
He provides his driver's license to Detective Barry.
Yes, sir.
And I don't know, do you or Detective Barry, somebody runs the plate, right? The license plate?
Yes, sir.
And there's no issues with that, right?
None at all.
And no issues as far as you know with the driver's license either, right?
None that I know of.
And you're at the side of the car for some period, several minutes, right? While Detective Barry's running the license and all that?
Yes, sir.
You're talking with Mr. Gathright?
That's correct.
You don't see any signs of impairment or anything to suggest he's under the influence, right?
No, sir.
And at some point, you smell this odor of marijuana.
That's correct. Yes, sir.
You're not able to distinguish whether it might be burnt or fresh marijuana?
That's correct.
And you described it, I think, in your own words, as a faint smell.
Correct.
When you go on to conduct the search, am I correct, the marijuana or suspected marijuana is inside a mason jar?
Mason jar or grinder? I believe it was a mason jar.
All right, and I was going to say, would looking at something help refresh your recollection on whether it was a grinder or a mason jar, specifically your depot transcript?
Yeah, that's fine.
Okay.
I want to say mason jar.
Okay. And I think this came up, so maybe this will refresh your recollection.
Yeah.
May I approach?
Sure.
This is a portion of, the depot is in a long binder over there, but
No, I got you.
that page probably would be right.
Okay.
Just take a look at it and let us know if that refreshes your recollection.
Mason jar with marijuana residue. Yes, sir.
Did that refresh your recollection as to what it was in?
Yes, sir.
And am I correct, it was a mason jar?
That's correct.
And the mason jar had a lid on it?
Yes.
And then that mason jar was inside another bag, correct?
It was inside a backpack.
A backpack? Okay.
Yes.
And the backpack, it wasn't one of those transparent backpacks that someone like carries into a football game?
No, sir.
What I'm getting at is you can't see what's inside the backpack until you open it up.
That's correct.
And the marijuana that's inside is what you might describe as residue?
Correct. Yes, sir.
Small amount.
Correct.
In fact, it's such a small amount that you can't even weigh it.
That's correct.
So obviously it's not weighed. Is there a presumptive test done on the marijuana?
No, sir, just the odor based off of after you open the mason jar.
Okay. And to get to the mason jar, you got to unzip the backpack too. Right?
Yes, sir.
As far as everything else that's found in the car, basically the guns, the firearm parts, the ammunition, they're basically in two separate sealed bags, correct?
Correct.
So really, when you're stepping outside the car, and before you actually start the search, you don't see anything in the car that's suspected contraband?
No, sir, not off plain view, no, sir.
And the sole basis for the search is the faint smell of marijuana?
That's correct, yes, sir.
That's all I have. Thank you, sir.
Okay, redirect?
Yes, Your Honor. Detective, you observed the faint odor of marijuana and your search revealed marijuana, is that correct?
Yes, ma'am.
You said that there was also mushrooms, is that correct?
Yes, ma'am.
And the firearm.
In the center console, yes, ma'am.
All that basis of the arrest, is that correct?
Yes, ma'am.
As far as having another officer come and actually write up the citation, is that usual practice?
Yes, ma'am, we work as a unit.
Nothing wrong with that?
No, ma'am.
Nothing unusual about having another detective with the unit actually do the measurement of the Toyota 4Runner SUV?
No, ma'am, not at all.
And just the fact that it's a sport SUV utility vehicle, that does not exempt it from the laws concerning window tint, is that correct?
No, ma'am.
Nothing further, Judge.
Okay, very good. Is this witness done, or does he need to?
He does need to stay.
Okay, very good. You're done for now. Remain outside. Okay, and who's your next witness?
Just one more witness for this motion, Detective William Parker.
Do you solemnly swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, you may proceed.
Please state your full name for the record.
My name is William Parker.
How are you employed?
I'm employed as a detective with the Jacksonville Sheriff's Office.
What unit are you assigned to?
I'm assigned to the homicide unit.
How long have you been with the homicide unit with the Jacksonville Sheriff's Office?
Almost 2 years.
And back in June of 2024, did you become aware of a search that was done on a Toyota 4Runner on June 26th of 2024?
I did.
And was that as a result of a search of that vehicle and some NIBIN results?
Yes.
How did you become aware of those results?
I received a report from our firearms laboratory stating that there was a match to a shell casing that was found in the vehicle to a murder I was investigating.
And is that still an open and pending investigation?
It is.
So no arrests have been made on that case, is that correct?
That's correct.
But you are the lead detective assigned to that particular case?
Yes.
And as part of Jacksonville Sheriff's Office policy, any sort of firearm or ammunition or rifle, any sort of firearm and related type of parts, that would be sent to NIBIN if it was taken in an inventory search or any sort of other search warrant, is that correct?
That's correct.
And you just happened to get those NIBIN results after the search was conducted, is that correct?
Yes.
Prior to that, had you had any knowledge or had you heard of the name Sean Gathright before?
No, I haven't.
And during the course of your investigation of the unrelated homicide that occurred in Jacksonville within your jurisdiction, after you received those NIBIN results, what did you do?
I drafted a search warrant for SeanGathright's residence.
So you authored a search warrant for the residence, is that correct?
Yes.
And that was related to your investigation that occurred in Jacksonville?
Yes.
And did you take that search warrant to a judge within your jurisdiction in Duval County?
Yes.
And did that judge approve that search warrant?
Yes.
And was there a search warrant that was, as a result of that approval by the judge, then conducted on Sean Gathright's house?
Yes.
When did that occur?
On the 27th of June.
And without going into the facts of your case, when talking about the search warrant, what was the scope of the search warrant? What were you looking for based on the probable cause to search that residence?
It was firearms accessories, cellular devices, and any other evidence that we found relevant to my investigation.
And is that what was done when the search was executed, items located pursuant to that search warrant that you found within the scope of that search warrant?
Yes.
And all of those items were taken and collected as evidence in your case based on probable cause for your investigation, is that correct?
Correct.
Your Honor, may I have one moment?
Yes.
Your Honor, we pass the witness.
Okay, cross.
Good afternoon, sir.
Good afternoon.
So, the case that you're investigating, unrelated homicide, I believe it was called, or separate homicide, Mr. Gathrights' name did not surface in that investigation in any way until you hear about the knife and hits that ultimately are derived from the evidence found during the search of the Forerunner.
That's correct.
And you rely on that evidence ultimately to obtain the search warrant for Mr. Gathrights' house.
Yes.
Correct? When you conduct a search of the house, I mean, obviously you're looking for evidence, I assume, that might be relevant to your homicide. But ultimately you also find evidence that you learn has since become relevant in the case we're hearing today, correct?
Correct.
And that includes, I think, 2 rifles that were found within the house?
Yes, sir.
There were quite a few rifles found within the house, right?
There were several guns.
And they were in, I believe, a locked safe, correct?
That's my recollection.
And that safe was in the master bedroom of the house?
Yes.
There were also, I think, 9mm casings found within the house that ultimately become evidence in the case we're talking about here?
Yes.
I think that's all I have. Thank you.
Sir.
Okay, redirect.
Just briefly, that was the property, the type of items of evidence that was specifically listed within your search warrant, is that correct?
Yes, firearms and firearms accessories, ammunition.
Nothing taken except what was authorized by the court, is that correct?
Yes.
Nothing further, Judge.
Okay, very good. May this witness be excused, or does he have to stick around?
He's excused.
Okay, you're done.
Thank you, Your Honor.
Okay? All right, any additional witnesses on this motion?
No, Your Honor.
Okay, and defense, do you have any witnesses you wish to call? Okay, very good. Okay, so, next up, I believe, well, we've got Mr. Gathrights' motion to suppress evidence illegally obtained from the defendant's iCloud accounts.
I spoke with Mr. Wise before the break, Your Honor, just to confirm, it is not, based on the content of the motion that was filed by defense, an argument other than anything legal. So there's no objection. If I'm mistaken, please let me know, Mr. Wise, but there's no objection to the actual substantive probable cause. They're just arguing breadth, so it'll just be legal argument. We do not need to make that one a priority today, Your Honor.
Is that correct, Mr. Wise?
Well, I'm sorry, I may have misunderstood. It is legal, but I think Detective Ramos would testify. I recognize there was a search warrant in this one, so I might arguably need to call Detective Ramos, but I would like to take some testimony from Detective Ramos. I'm sorry if
That's all right.
I'm not suggesting it was not probable cause, but I think his testimony will be relevant to the overall.
Okay, does somebody want to call a witness
Yes,
for
sir.
Sean Gathrights' motion? I don't care who or what, just a witness. So, Ms. Ismer, you're gonna, all right, she's gonna call Detective
Detective
Ramos.
Long. I would also ask just now, Your Honor, that the court take judicial notice of the preliminary responses that were given for the predicates for the detective.
As far as his training experience?
Yes,
Yes, that's fine. Okay, Detective Ramos, back again. You remain under oath, and this time you're testifying regarding Sean Gathrights' motion to suppress illegally obtained evidence from the defendant's iCloud accounts.
Yes, Your Honor.
Okay, very good. You remain, go ahead.
Detective Ramos, did you have an opportunity to coordinate with the Jacksonville Sheriff's Office regarding the evidence seized from the Forerunner that was searched on June 26th of 2024?
Yes.
Did the evidence include cellular devices?
Yes.
Were those items, to your knowledge and based on your communications with Jacksonville, seized from the possession of or at the time of the contact with Mr. Sean Gathright?
Yes.
And as a result of your information regarding some evidence and cell phones being collected, was a search warrant also conducted on Mr. Gathrights' residence the following day, June 27th of 2024?
Yes.
Ultimately, did you also, in this case, prepare a search warrant for a return on an iCloud as it related to both of the devices that were seized from that vehicle stop on June 26th of 2024?
Yes.
And did you, in submitting that search warrant, obtain a signed copy of that warrant that was approved by a judge?
Yes.
What did you do with that warrant once that was approved?
I served it to Apple.
And based on what you served to Apple, how many returns did you expect? How many accounts were there?
It was, I think there was multiple accounts. Yes.
Did one or was one account accurately reflected as redman5x at iCloud.com?
Correct.
And was the secondary account rockoutsean at iCloud.com?
Correct.
Having served those warrants upon Apple, did you actually include in the probable cause section or in the search warrant itself a period of time for reference for Apple to return the information?
Yes.
And why did you elect to include from June 1st of 2024 to July 12th of 2024?
So I was asking Apple for any backups that were done during that period, specifically because that period covered the entirety of the planning phase of the murder and then up to the point where I was drafting it where the suspect was still outstanding.
At the time that you drafted the warrant and included in your probable cause for the warrant, did you have confirmation that the Chevy Impala connected to Mr. Gathright had been identified as having been used in the homicide?
Yes.
Did you include in the warrant or the application the identification or preliminary identification of a Rashad Murphy and Isaiah Chance as potential suspects?
Yes.
Did you have the information that Mr. Gathrights vehicle had been linked in some way to Mr. Chance at that point?
Yes.
And how was that vehicle linked?
I'm sorry, which vehicle?
The black Impala, I apologize.
Yeah, so the information that we had linking Isaiah Chance and Isaiah Chance and Sean Gathright is that Isaiah Chance's personally owned vehicle was caught photographed at Sean Gaithright's house, so we knew that they had been at the same house at the same time.
Did you also include the license plate reader information that you had about both vehicles that were leaving from Tampa, driving in tandem in the application?
Yes.
Did you include in the application as well the identified suspect vehicle having been in Tampa at the time of the homicide?
Yes.
Did you include information about your conversations or confirmations of SeanGathright's location and subsequent acts after the homicide with his grandmother?
Yes.
And with the video evidence subsequently obtained?
Yes.
Did you have an opportunity also to confirm the use of the defendant's phone in the video footage that you recovered from the Ring doorbell camera from the Airbnb residence?
Yes.
And did you have an opportunity to confirm with the Jacksonville detectives over the course of the investigation that there had been an ongoing or long-standing back and forth between some rival gangs in Jacksonville?
Yes.
At the time that you made the application, and did you include in your application portions of those conversations leading to relevant information about a planning or a motive to having committed a homicide in the Tampa area?
Yes.
And did you have that information during the course of your investigation in order to determine how far back you would seek the information be produced by Apple?
Yes.
Included in your standard search warrant, what is the language that you previously referred to in your testimony as a backup mean?
An Apple device will back up all of its data, or at least with whatever the customer elects to be backed up into the cloud. So the way Apple stores it is as a complete backup, which would be similar to like a phone extraction, a copy of all the data on that phone.
Did you include in your request information regarding requests to Apple for photos, messages, videos, etc.?
Yeah, the common stuff you would find in a iCloud backup, yes.
Is that standard procedure for your law enforcement agency?
Yes.
Are you trained as a law enforcement officer to include that information because you don't know where relevant information will be located?
Correct.
Did you receive a return on both of the accounts previously mentioned, Redman5X and RockoutSean at iCloud.com from Apple?
Yes.
Did you have an opportunity to review the content of those extractions?
Yes.
In your review of the content of those extractions, were there images or contents between the dates of 6/1/2024 and 7/12/2024 which related to or referred to your investigation?
Yes.
were there contents from that same time frame which also connected or in some way or included backups outside of that time frame?
Yes.
Is that to be expected when you request the actual backup from the device?
Yeah, so the time period that I'm requesting, I'm asking for a backup that was done during that time period. They have no way of separating stuff that would have been outside of that time period. That's the backup done at that time period, which could include items from before that time period.
So, for example, when you receive an extraction, if we go off of Cellbrite, does each image, for an example, have a created date, modified date, access date?
Correct.
If you subsequently access a photo you took a week ago and text it to a friend, are there multiple dates attached to that photograph?
Yes.
Is that why you are requesting not only a time frame for the backup itself, but also from the content before that?
Yes.
Specifically as it relates to the dates that you requested in this case, you're indicating that you only intended to include those times for the backup.
For backups done during that period.
Is there any way for you to determine without actually contacting Apple or having the information that was provided to you from Apple for the device when a device had actually been previously backed up?
No.
Is there any way for you to know that without having personal knowledge of it?
No.
And is that also a part of the basis for why you request such a time frame?
Correct.
May I have one moment, Your Honor?
Yes.
I will pass the witness.
Okay, Mr. Wise?
Yeah, there's it.
All right. Ramos, when you authored the search warrant affidavit for this iCloud, you set a date range for information that you would be searching. Is that correct?
No.
You do not?
It's not a date range for information that I'm searching. It's a date range for backups within that date range. So that's what I was asking for.
So you listed that you were seeking specific technical data information pertaining to the use of the Apple accounts with the below listed information, and you list the Rockout Sean Apple ID and the Redman Apple ID.
Correct.
And then you list for the dates of 6/1/24 through 7/12/24, correct?
Correct.
So where in that is it a limitation to only information that's backed up?
Apple has no way of parsing out or giving you certain context for a date range. For when it comes to iCloud accounts, when you back your phone up, that entire backup is in the cloud. So the date range, is specifying the iCloud backup date. So if the account was backed up within this date range, then the expectation would be that backup would have some content that might be relevant to the investigation.
Okay. Well, when you ultimately get the Apple iCloud, I mean, you're able to sort all the information by date. Even you can sort files by date created, date modified, or date accessed. Would you not agree?
Yes, the viewer that we use, so they give it to you as raw data, and then it gets parsed out in either a viewer called Cellbrite or Axiom, and there's a ton of ways you can search. You can search by keywords, by date ranges, by specific files, JPEGs, videos, messages. So there's a bunch of different ways to sift through the information.
And it's your testimony that Apple cannot limit the data that it provides to certain dates.
I'm not aware of what Apple is capable of doing. What I'm testifying to is what the typical procedure is when you request an iCloud backup, that they're not going to separate. They're just going to give you the whole backup, whatever's been backed up to the cloud on that date.
I guess what I'm asking, and what I guess I'm not understanding, is what is the point of even putting this date range in the search warrant? 6/1/24 through 7/12/24.
So that specific search warrant template is an electronic communications, or some of the warrants, depending on what you're looking for, have a pre-fill for date range. That one comes with a pre-fill for date range, and so, I mean, in theory, I could just say, I'm going to do any iCloud backup that you have for this. But that one required a date range, so I chose that date range.
Okay. So you had no intention then of only looking through the iCloud material for the dates of 6/1/24 through 7/12/24?
I'm going to look through whatever they send me in good faith. If they do limit it to that, then, that's what it's limited to. But again, I'm asking for an iCloud backup within that date range.
Okay, so if they send you, and for instance, in this case, they did send you data that went back at least as far as May 12th of 2021. Does that sound right?
I believe so, yes.
Yeah. I mean, clearly they sent you years' worth of data from the Rocked Out Sean iCloud account, right?
It would be whatever was in the backup, yes.
Okay. Well, do you want to look at it to refresh your recollection as to how far it could have gone back?
No, I'm aware that it went back years.
At least 2021, right? So you didn't limit, so you looked through all that?
If they send it to me, yes, I would look at it.
Okay. And when you prepared the search warrant affidavit, you also listed categories of specific technical data information requested, right?
Yes.
And that was also, and I assume you drafted the warrant that was ultimately signed.
Yes.
And you parceled out various categories. Would you agree that you're basically asking for everything that's going to be in the iCloud?
Correct.
Including, you had listed you're requesting device registration info, including name, address, email address, and telephone numbers associated with the account, right?
Yes.
And that you wanted the contents of all emails associated with the above listed account, including stored, preserved copies of emails. Basically, you wanted all emails linked to this account, right?
I wanted all the data they had linked to that account.
Yeah, I mean, well, I'm going to still go through it all, but basically, these categories are written in a way to encompass everything that's going to be in the iCloud account.
Yeah, because again, the way that you back up your iCloud, okay, you can elect to only back up photos or only back up videos or only back up text messages, or you get, so I don't know what the individual customer has elected to back up. So as a cover, we just ask for all the topics that I know that are optionable to back up.
So then going back to the categories, you requested and was ultimately listed in the search warrant, the contents of all instant messages associated with the above listed account.
Correct.
And FaceTime call invitation logs.
Yes.
Were also requested.
Yes.
All iCloud data associated with any backups of iPhones associated with this account.
Correct.
Correct.
Yes.
Contact data for all contacts, including names, addresses, dates of birth, and email addresses and phone numbers. Correct.
Yes.
And you requested and were given access in the search warrant to log in IP addresses with port IDs.
Yes.
And you were requested access and given permission in the search warrant to search all records and information regarding locations where the account was accessed, including all data stored in connection with location services.
Yes.
And then it goes on to state contents of all files, including photographs, videos stored in iCloud or other server or Apple facilitated format, including all iOS device backups.
Yes.
Jumping ahead to one other category, you request and you're granted permission to search records of games, videos, or other remotely accessible data and the associated IP address from which the remote access was made, correct?
Yes.
And again, you request and are granted permission in the search warrant to search all files, keys, or other information necessary to decrypt any data produced in an encrypted form when available to Apple.
Correct.
For the record, I'd like to show you a copy of the search warrant. It was attached to the motion, but I'll show you what's marked as Exhibit 1. Take a look at that.
Yes, sir.
You recognize that?
Yes, this is the search warrant for Sean Gaithwaite's iCloud account.
And that's the one that we've just been discussing that you drafted and
Correct.
was signed. Okay. I'd move at this time into evidence defense exhibit 1.
No objection.
Okay, defense exhibit 1 as to Sean Gathright, be admitted.
Now, as to the information you included in the search warrant affidavit, I mean, you include several pages of information in the affidavit. right?
For the probable cause?
Yes, sir.
Yes.
And it spans dates, I believe, of June 22nd, 2024 to about June 28th, 2024. Is that right?
But majority of the activity occurred in those dates, yes.
And I mean, and you do more investigation after, but basically what I'm getting at is the alleged acts that you're saying constitute probable cause, those basically transpired during those dates of 6/22 and 6/28. Does that sound right?
The majority of it, I mean, we had information that there was a planning phase that, or at least the victim started advertising a couple weeks in advance.
Well, that was, you got to my next question.
Yeah.
There's ultimately a flyer posted by Charles Jones, Julio Foolio.
Correct.
That he's going to be having a show in Tampa.
Correct.
Right. And you believe that's where this conspiracy basically begins, right? Because the plot is to go to Tampa and commit these crimes in Tampa while he's there for the show.
Correct.
And that flyer is first posted on June 14th, correct?
Correct.
So before June 14th, these people involved in the case, as far as you know, would have no idea that Charles Jones, Julio Foolio, was going to be in Tampa until June 14th.
I wouldn't testify to that. I don't know if they have insider information.
Sure.
Yeah.
But looking from the outside in, the only evidence you see, or the earliest you see any indication that Charles Jones is announcing this show comes June 14th.
Correct.
You recall in your deposition, we were discussing this, and you testified that you, in the iCloud search, came upon some photos that you believed were depicting Sean Gathright making what you thought might be gang signs. You recall that?
I'm aware of them, yes.
And at the time, you didn't recall which photographs we were talking about, what dates they would have been, or what gang signs you're seeing.
Off the top of my head, I mean, I can't quote specific dates that they were taken or.
Well, I mean, since that, Deb, because I asked about it, for several questions, right? I mean, have you gone back and looked to see which photos you were talking about?
I have reviewed the photos. I mean, I don't have off the top of my head, I don't have a memory of how many photos we've set aside or what dates they were taken. I'd have to review, the files.
Can you agree with me that whatever photos it would have been you were talking about, they would have been created and last accessed sometime prior to June 1st, 2024?
If you're referring to the photo specifically where he's throwing up what we believe to be gang signs, yes, those photos were, the dates on them were prior to June 1st.
I mean, long prior to June 1st, 2024.
Yeah.
Right? Like, not even in 2024.
I can't recall the exact dates, but yes, it was way before June 1st.
No further questions. Thank you.
Sure.
Okay, redirect.
You also had information in your investigation that in the month of June, obviously long before that, but certainly in the weeks leading up to Mr. Jones's death, Mr. Jones was on social media or prominently in disagreements or disputes with rival gang members. Is that correct?
Correct.
In the weeks leading up to the offense.
Correct.
And when we talk about the dates encompassed in the backup that you actually received, do you recall specifically a photo that was retrieved from the extraction from Rashad Murphy's device of firearms on the ground?
Yes.
And the information or data attributable to that photograph, that would have been within the time frame of June 1st and July 12th that you retrieved, correct?
Correct.
Now, in the extraction or the data that actually comes from Mr. Gathright's device, that photograph originated or was present on Mr. Gathright's device in advance of that, before that.
Correct.
Okay. And that is a way in which the data or the information for when that photograph would first appear on Mr. Murphy's device in one time frame, but backed up on another device before that would make it relevant to have that information as a backup, correct?
Yes.
The time frames that we're talking about are specifically for information that would have been at least preserved for that user's account at that time, correct?
Correct.
Are you ultimately trained with your agency to only look at times by sorting by date created or date modified?
Under certain circumstances, but no, I mean, are you asking if I get a whole download or?
Well, when you are taught to utilize or trained in utilizing Cellbrite and Axiom, do you oftentimes find files that don't have a date created, date modified?
Correct.
Specifically, look to, or let's reference the information that you obtained from the new device that Ms. Andrews had when you investigated her cell phone device. Did all of that backup information include the date by which Apple provided it to you, or were there certain specific dates actually annotated for each item?
They had different dates. It could be a date that the phone is being set up, and those files are going onto that phone, and then it could also be a date of the actual capture date, so they're different dates.
And have you received downloads before where the dates and time for each of the items that you're actually looking at are the same? Meaning it would be impossible that all these pictures were taken at the same time, but the same date and time is reflected.
Yeah, there are times where, especially when you set up a new device, where a file could be 4 years old, and the only date you're going to see in Celebrite is the date that it was put onto that device, which is not the same date that it was captured, and we would have no way of knowing when that image was captured.
Is that why you cannot strictly rely upon date created, date modified timeframes?
Correct.
Are you, as a part of your just standard operating procedures as a detective within the agency, trained to utilize or to view items of evidence on these extractions even when they do not have a date or time attached to them?
Correct.
Is it unusual to not have a date or time attached to an item of evidence on a cell phone extraction?
It's not unusual at all.
In fact, if an item has been deleted or removed from a device itself, but you're able to at least recover the, quote, deleted file, are there oftentimes you have no trace of date, time, created, modified, any of that information?
That is correct.
Is that information, if that item was backed up in some way by Apple or had not been written over, still available to you to at least open or view?
Yes.
Even though the software provides to you that it has been deleted from the device?
Correct.
Can you specifically say with any certainty, unless essentially you're a member of a conspiracy itself, where items of potential evidence will be located on these cellular devices?
No.
And is the language that was included of backup of the iPhone or iOS device backups in the search warrant that you provided all standard within your agency as required by Apple for this particular cloud return?
Yes.
I have no further questions, Your Honor.
Okay, very good. Thank you, Detective. Any additional witnesses from the state on this motion?
No, Your Honor.
Defense, any additional witnesses? Okay. Are there additional motions that we need to take testimony on?
Judge, not additional motions, we just wanted to make sure that we called the detectives that we listed as gang experts, just to, I know that motion's going to be heard later, but because they're here,
yeah,
we wanted to go ahead and call them. There are 4 of them, just to go through their expertise credentials.
Okay, very good. All right, who's going to be first up?
Detective Richard Nieder.
Okay, very good.
Your Honor, because I know that this kind of incorporates a couple of motions. This is specifically as to what was filed on February 7th as the defendant's second motion in limine for Rashad Murphy for the Dauber challenge. We'll have that.
Go ahead and have a seat, Detective. What date were we supposed to hear that?
We are making a record of which motion we're having it under since we're bifurcating.
Sure. When was this one supposed to be heard?
This one was filed February 7th of 2026. We have it on our list for We have it on our list for the 27th, the AM session.
Okay, and tell me again
Number 9, it should be.
Rashad Murphy, defendant's first motion in limine, testimony regarding Ghost 187?
My number 9 is second motion in limine and Dauber challenge.
Okay. I have it as number 10 on my list. It's okay. Let me find it real quick on my cart, and then we'll get going here. You may proceed.
Sir, would you please reiterate for us the amount of time that you've been with the Jacksonville Sheriff's Office?
I'll be 10 years in September.
And what is your current title?
I'm a detective.
What is your current assignment?
I'm in the gang investigations unit.
How long have you been in the gang investigations unit?
I'll be 4 years this fall.
What are your day-to-day activities in the gang investigations unit?
My day-to-day activities deal with monitoring social media, documenting gangs, gang members, also purging gangs and gang members.
When you indicated that you had some service with the sheriff's office in advance of your time in the gang unit, talk to me a little bit about what your day-to-day duties were then.
So I started off in patrol, and I rode the city's Eastside. In patrol, you answer calls for service, so anybody who calls a non-emergency or 911, you're the first uniformed officer there to handle that. After that, I moved on to a community problem response unit, which is a citywide task force that deals with assisting other detective units, whether it's serving subpoenas, arrest warrants, locating victims. We also do social media investigations there, where we have done like Instagram live takedowns and things of that nature, like Instagram and social media investigations dealing with firearms and drugs.
And does that somewhat encompass a large part of what you still do today?
Yes, ma'am.
In your time with the sheriff's office in Jacksonville, was the gang rivalry, at least between ATK, 1200, 6 Block, prevalent or known to you and the other officers and detectives?
Yes, it was known to me, yes.
Did you have an opportunity to investigate gang-related or gang-motivated crimes or offenses that occurred even before you were in the gang unit?
I wouldn't say that I investigated them personally. I was a part of the investigation, but I was never the lead investigator on any of those things until I became into the gang unit.
Well, I mean, in a way that, did you respond to these offenses, whether you took over the investigation for the latent investigation thereafter or not? I'm not asking. I'm just asking whether you responded to the offenses.
Yes, I responded to, like the city's east side is a heavy gang territory. I've responded to many shootings, homicides and stuff of that nature in that area. Also the community problem response unit, I had the opportunity to apprehend multiple victims and suspects and witnesses of the gang shootings and wars and stuff.
Do you have a significant amount of contact with the members of the community that are either witnesses, victims, members, etc.?
I would say yes.
Now, as it relates to your time specifically in the gang unit itself, how do your day-to-day duties now differ?
My day-to-day duties now is strictly towards gang activity rather than the wide variety of everybody in Jacksonville that's committing crimes.
So on any given work week for you, is your ultimate job or responsibility to follow up, study, or investigate gang crimes?
Yes.
And are you assigned specifically to do those tasks for one specific group?
Yes.
And what is the group that you are assigned to?
I'm assigned to ATK.
What does ATK stand for, if you know, based on the information you've been able to collect in your time with the gang unit in Jacksonville?
What I've been told that it stands for, and that it's Ace's Top Killers.
Now, when you talk about investigating these groups, is it only that you respond to crime scenes, or are there other types of investigations that you do behind the scenes, office work almost?
We do all sorts of investigations, not just respond to the scenes.
And what are those all sorts of investigations including?
We've done like shooting investigations, we've done drug investigations, firearms related investigations, fraud investigations.
When you say you monitor social media, what does that include?
I monitor the social media accounts of the members and associates of ATK along with their associated groups, which would be like their allied groups. I monitor those accounts as well, see their posts and their stories and kind of see what's going on in their world.
When you say allied groups, are those also groups that are associated to or associated with ATK?
Yes.
When we talk about allied, is that groups that get along with ATK?
Yes, they would get along.
What, if anything, is their commonality versus 6 Block?
The one thing that all the ATK's allied groups have is a common enemy, and it is like the 6 Block bully gang, we got, like the Northside of Jacksonville.
And as a part of your role in taking ATK or being the primary detective for that group, are you also investigating and studying and focusing on the associated and allied groups?
I do, but just not as much as my time towards ATK.
Does your role in the gang unit include you responding or providing information about ATK or that you might have about those allied groups to other detectives to further their investigations?
Yes.
And do you work with other detectives in the gang investigations unit?
Yes.
Do you become a part of that unit? Do you have to be a detective before you go there?
Not necessarily.
And do you have any kind of specialized training in gangs or their investigations?
You do once you get there. You attend trainings and conferences and stuff of that nature that teach you how to handle and operate a drug or a gang investigation.
Did you specifically attend those trainings?
I have.
And tell me about the trainings that you have received or attended.
I've received classes through HIDA, which is a federal agency, courses about gangs. I've received training through the Florida Gang Investigations Association. It's a week-long conference where they teach classes about gang investigations, and not just that, but how to dissect cell phone downloads and stuff like that. I've taken a technology conference that has taught how to read towers and do cell phone downloads and what to look for and how to get into the weeds of a cell phone download. I've also taken it's a REOC course on robberies that occur within gangs.
Do the conferences and trainings that you attend help to advance your investigative techniques when you're looking at these cases and investigating them?
It does. It teaches us what other agencies are doing throughout the country and how it may apply to us, to where we can go back and use their techniques to help solve ours, and they may use some of our techniques to help solve their crimes.
Do you share some of the things that you're seeing with your location, area, jurisdictional specific gangs?
Yes.
When you attend these types of conference, are they more generalized for the bigger or more well-known gangs like Bloods versus Crips or things like that when they're giving you examples? They're not focused on Jacksonville gangs, correct?
Generally, they are to what we would call a national gang, which would simply mean that it's everywhere across the nation. Most people would know Bloods and Crips and stuff, but that's generally what these conferences are focused on.
And while you're learning the investigative techniques that are used, are you also sharing the new information or ways that crimes are happening in Jacksonville related to your specific gangs
Yes.
with other detectives?
Yes.
And in your role with the Jacksonville Sheriff's Office, do you not only provide information about ATK or ATK's affiliates to other officers in your agency, but also across the state?
Yes, if they call with questions, all of those questions would come to me.
Specifically as if it's ATK related?
Yes.
Are you also in your role familiar with the other prominent or more prominent gangs or groups in Jacksonville?
Yes, I would be. I'm familiar with the other, I would say, stronger groups of Jacksonville, which would be the 6 Block Bully Gang. We got Northside area, as well as like the 1200 Out East area.
While you're investigating offenses that you believe to be related to ATK or in some way linked to ATK, do you work with the detectives for 1200, 6 Block, or whatever the affiliated or related groups are?
Yes.
And do you all share information about those offenses?
Yes, we do.
Do you utilize the information that you have to help other detectives, whether in your jurisdiction or outside of your jurisdiction, to establish motive for cases? So if you have specific information about ATK and their rivals at the time, do you share that?
Yes.
Do you also monitor, in addition to social media accounts, YouTube or music video sharing applications?
I'm sorry, you say that again?
Do you monitor music videos? Do you watch music videos in addition to looking at social media accounts?
Yes.
Included in the social media accounts that you're familiar with, do you monitor or are you familiar with YouTube?
Yes.
With Twitter or now X?
More familiar with YouTube than X.
What about, have you viewed posts on X or Spaces as a part of your job duties?
Yes.
What about Instagram
Yes.
and Facebook? Is that something that's utilized?
By some, but it's not real common.
What, if any, is the methodology or the way that you go about looking into these accounts when a crime is reported? How do you know where to go or what to look for?
Generally, if there's like a shooting, something like that, and your victim is going to be on one side, you would go to the other side, which would be the opposition's. That's a good place to start and just figure out who's dissing him and talking about the crime.
Is it common that when you are able to identify a victim at a scene, pretty quickly thereafter, a rival group is taking credit for that?
Yes.
And do you utilize whoever is at least the most vocal about taking credit for those offenses as a part of your investigation and kind of work back from that to ascertain whether there's evidence at all relevant to your case?
Yes.
So if there is a crime and you respond and the victim is present, you work back from the identity of the victim to determine potential suspects by looking at other gangs.
Yes.
And do you know, for example, if you respond to a location and an ATK member is the victim, what rival gangs to start looking at first?
I would start with the Northside groups.
And is that just based on your experience and having investigated these cases?
Yes, that would be you would go to the opposition, would be the first people talking about it, at least.
Were you familiar, although not a member of ATK, with an individual by the name of Charles Jones at the time of his homicide?
Yes.
And was that just as a part of having a peripheral investigation to your work with ATK, or was that something well known in Jacksonville?
I was well known in Jacksonville of who I would take that back. I wouldn't say well known because Jacksonville is very large, but if you lived in those neighborhoods, you knew who Charles Jones was.
And how long would you say the ongoing rivalry between ATK and 1200 and 6 Block has been going on?
Well, I can only speak for 2017 and on because that's when I officially became a police officer and was on my own on the street, and that was about the time that I realized how dangerous they were.
Back in 2017 and thereafter, were there some shifts in the names that were utilized for some of these groups?
Yes.
When ATK started to become more popular, was that as a result of one of their primary members, Kenyatta or Bullard or Yungeen Ace, becoming more popular with his music career?
Yes.
And 1200 itself, was that a group that you are familiar with, having been growing in size when 187 kind of dissipated in Jacksonville?
I'm not familiar with 187. I think that was before my time as being the police. It's always been 1200 for as long as I've been on.
When you make contact with members from 1200, is it uncommon for you to see markings which indicate 187 or posts which also indicate 187 in them?
Yes, based on my understanding now and what I've learned through my experience in being law enforcement, 187 is more of the older crowd of 1200, and they have rolled into 1200 now. It's not really they don't call themselves 187 anymore.
Did you have a similar experience in your role with investigating, or at least your contacts with 6 Block members, and that being the younger generation of what was formerly known as a PCE?
Yeah, PCE would be also a little bit older crowd. PCE got RICO'd in Jacksonville, and they kind of changed their name after that and became 6 Block.
Based on some of the conferences that you go to, based on your experience, or have you noticed a trend in that if a group gets smaller or changes, a new group develops?
Yes, usually happens after like a mass arrest or something. It's kind of, you take down a good bit of them, that somebody else starts it with the same group and they just kind of change the name.
Does your involvement or your role as a detective with the gang unit include actually documenting gang members?
Yes.
Is that a standard procedure with the Jacksonville Sheriff's Office, at least now?
Yes.
And how do you go about documenting a gang member?
Follows Florida State Statute 874.
what does that process actually look like? Are you writing a report? Are you saving that information?
Yes, we do field investigative reports that it lays out all the information on how they meet the state statute. We submit that report. Once it gets approved, we put it into databases, and it now appears on like NCIC and FCIC databases that they're a gang member in Jacksonville, Florida.
Is that for purposes of you utilizing that information to notify other officers or detectives in Jacksonville?
Yeah, and across the nation.
And how often is that report actually updated?
We have to update them every 5 years. So within the time that they're documented to the 5 years, if they're still meeting state statutes, you redocument them with the new ways on how they're meeting the state statutes still.
So in your role, you have to be familiar with the state statute.
Yes.
And when you say every 5 years, what happens if you have contact with a documented member or an associate within that time frame?
You just document it in a field investigative report, which can be pulled from the system. And then once you get all those compiled and the 5 years is coming around, you write a big master field investigative report that shows all of the contacts and the criteria that they meet in that field investigative report.
And is that just for information for you or other investigating agencies as it relates to potential gang affiliation or association, documenting whenever you've had contact, et cetera?
Yeah, I think
for
it's
the agencies.
Yeah, I think it's more it's a Jacksonville Sheriff's Office based database that houses the reports. So I don't think everybody across the nation can access them. But it appears when you run somebody's name that they're a documented gang member in Jacksonville, Florida, and it'll give a case number, and that allows them to reach out to us if they need the documentation.
It is not all-inclusive or all-encompassing of every gang member, is that correct?
What do you mean by that? I'm sorry.
The documentation that you have, it's not all-encompassing of every member of 1200.
I can only speak for ATK. I'm not. I don't
Well, let's talk about ATK.
Each person that is a member of ATK has their own documentation, and then there's a documentation that actually documents the gang.
But what happens if there is a new member that you've not had contact with?
They wouldn't be considered a member until they're documented, so they would just be an associate, and if I haven't had contact with them, they're simply just an associate or somebody that, like a person of interest that we can be looking into to if they reach the documentation status that we would need to document.
And by document, you are talking about the reports that we've discussed, which is actually compile that information into a report and ensure that other agencies are aware of it.
Yes, ma'am.
That being said, if you made a stop tomorrow and made contact with an individual that met several of the factors to be considered under statute, do they qualify as meeting the statutory criteria, whether you've completed your report or not?
Yes.
In this particular case, did you provide assistance to the Tampa Police Department by way of interviewing some individuals in this case and providing intel regarding the gang rivalries?
Yes.
Were you, at the time that you received information that Charles Jones had been killed, familiar with several music videos that had been published by Charles Jones and/or 6 Block members?
Yes.
Were you also familiar with several music videos that had been posted or published by ATK members?
Yes.
And is that review or familiarity with those music videos a part of the social media review that you previously talked about doing?
Yes.
When you review those videos, what do you actually do when you're watching them?
Everybody does it differently. The way I do it is the first time I usually watch it all the way through with no interruptions. The second time, I usually try to break down the lyrics, see what they're saying, whether it's closed captions or just keep rewinding and listening to it. And then the third time I watch it through, I notate everybody that I can identify in the music video if there's multiple people, and firearms, any type of evidence or stuff like that. And then if I can't identify who they are, I will take a screenshot of the video, and I'll send it to our crime analysis unit, who will then attempt to identify who's in the videos.
And ultimately, do you document that in some way, particularly if gang signs, weapons, or gang-related activity is documented in those videos?
Yes, because that would go towards the documentation on becoming a member. If you're in a music video with a known gang member and you're throwing hand signs and you have a style of dress and you have tattoos visible or necklaces or stuff like that, that's part of being associated to that gang, so that goes towards their documentation.
And at the end of essentially the next 5-year period, would that report that you've documented those things, for example, be utilized in either reestablishing that person as a documented gang member or changing that status?
Yes, but I wouldn't use that same music video or the same big pictures. So it'd have to be new stuff that happened within those 5 years. So they're continuing that lifestyle and they're continuing their association. I'll document that as the 5 years comes along.
And it's a part of your regular practice to watch these music videos every time they come out?
Yes.
Would you consider or define those music videos as popular?
To a certain...
Well, let me re-ask the question. In your review of those music videos, is it uncommon to see tens of millions of views as to each of them?
Yeah, they get lots of views.
Did you work with Detectives Griffin and Drabick in this particular case in discussing the rivalry amongst these gangs, as well as Detective McCullough?
Yes.
And the potential motive behind the homicide of Charles Jones or any of the offenses essentially around the time frame that were committed for it?
Yes.
Did you have an opportunity to specifically review and document a music video titled Who I Smoke?
Yes.
Did you do the same for When I See You?
Yes.
Were those two songs posted or provided by rival groups?
Yes.
Who was Who I Smoke created by or published by?
Who I Smoke is going to be ATK and 1200. It's got the rappers and artists of Yungeen Ace, Fast Money Goon, Wappa with the Choppa, and Spinabins.
And When I See You?
When I See You is a song that was posted by Foolio, also known as Charles Jones, who is a part of a member of 6 Block.
Is it uncommon to see these music videos from rival groups posted back to back with each other?
Yes.
It's uncommon or it's common?
Oh, I'm sorry. I thought you said it was common. It is common. It is a response video.
Is there a specific name that's utilized when you all talk about these types of music videos?
It's often called drill rap.
And what does that mean?
Drill rap is a form of music that simply disses the opposition or talks about crimes that have occurred, whether it's deceased or stuff like that.
How are you able to decipher the language that's actually being utilized in these music videos?
So there's multiple different ways. A lot of these, some of these rappers and artists have become well announced, and they are on platforms such as Apple Music and Spotify. Apple Music will provide the lyrics to the songs along with who the song was written by. And then there's also closed captions on YouTube. And there's also websites out there that will post the lyrics, like I think it's like lyrics.com or something like that, will take the song and actually post the lyrics that they hear.
When you utilize or see those services being offered, do you then still yourself take an opportunity to review the songs to make sure it's accurate?
Yes, I generally will read it on Apple Music and see if I hear the same things that Apple Music has given.
Separate and apart from the transcripts that are provided for these songs, do you also document any kind of significance for the locations at which the videos are taken?
If we can determine where they were taken at, yes.
So for example, in the When I See You music video, was there any significance to the fact that it was filmed or recorded at what appeared to be a cemetery?
Yes, it was reported at a cemetery, and the song is focused on people who are now deceased. So we notate that, but we are unable to notate which cemetery that is at.
When you investigate these types of cases, the information about maybe significance of where the video is published or the posters or visuals that are used in those videos, is that information that you specifically know is relevant just based on your training and experience with these gangs?
Yes.
Are you familiar with the summary exhibits that were created in this particular case for ATK, 6 Block, and 1200?
Yes.
And did you have an opportunity to work with Detective Nieder in at least giving your input or insight in some of the members or associates depicted in those images?
Yeah, I hate to correct you. I worked with Detective Drebeck.
I'm sorry.
That's
Said you.
okay.
You all worked together, though, with other members of the gang unit?
Yes, ma'am. I think Drebeck was the ultimate compiler of the photographs and information, and then Detective McCullough and Griffin both did it for their respective gangs, and I did it for ATK, of saying that's an approved list.
Because that is your assigned group.
Correct.
And can you state whether this summary exhibit is all inclusive of every member of ATK that you have knowledge of?
No, it is not.
Your Honor, can I have 1 moment? Yes. I will pass the witness, Your Honor.
Okay, Mr. Gonzalez?
Afternoon, Detective.
How are you?
So I think you indicated to us that you have been a member of the gang unit for 4 years, and that's inclusive of today, correct?
I'll be coming up on 4 years in a couple months.
And prior to you being in the gang unit, you went through the ranks, you were in a patrol situation, you were in other departments, and then you ended up here sometime close to 4 years ago, correct?
Yes, sir.
And you said you responded to crimes that may or may not have been gang-related crimes based on what people told you or witnesses told you as you responded, correct?
Yes, sir.
And you never actually investigated until you became a member of the gang unit, a gang crime.
Yes, sir.
I think Ms. Isber was asking you early on about the origin or the name ATK.
Yes, sir.
And as I wrote down your response, you indicated that I'd been told. And that's correct, right?
Yes, sir.
And so would it be fair to say that the majority of information you get in this realm are from people on the street?
Yes, sir.
And these are either people that you know or have you come across in other investigations, people that other people tell you about, and when you confront them, whether it be during the course of a crime or whether it be in the course of a field interview or whether it be in the course of someone else giving you their name, your source of information is primarily gathered by and through people on the street, correct?
That would say it's probably half of it. The other half would be like social media and cell phone downloads.
Okay, so social media are people talking on their platforms, depending on what that platform is, about doing this, doing that, so-and-so did this, so-and-so is who, so-and-so is somebody, correct?
Yes, sir.
Okay, and you have no way of confirming what those people are saying other than what comes out of their mouth, correct?
No, I would say that's correct.
And that would essentially compile the bulk of the percentage of what you would call gang intelligence, correct?
Yes, sir.
And that type of intelligence you do not document. You do not write reports on.
Not all of it, no, sir.
Well, any of it. Do you ever write a report that says so-and-so told me so-and-so is a gang member?
It depends on the situation.
If I were to ask you how you know Charles Jones was either the face or a very prominent member of 6 Block, what would you say?
I would say you're correct.
No, you would say people told you that?
No, sir.
You would say...
I would say Charles Jones himself portrays that.
Portrays it in music videos?
Music and on his own personal, on his Instagram.
And that is because he reps 6 Block?
I think he calls himself Mr. Six.
Right? That's where he grew up, right? That's his neighborhood.
To an extent.
Right? That's where his friends are. That's where he congregates. That's where he does a lot of his music. All those correct?
I can't tell you exactly where he makes his videos, but he has made videos there.
Okay. And many of the people he grew up with live there. He lived there, correct?
At the time of his death, he did not live there.
Has Charles Jones ever stated or ever said in a music video that he killed somebody?
I don't think he's ever talked about himself killing anybody.
Has anyone in any rap video you've ever seen said, I killed somebody?
No, I don't think they say those exact words.
Well, they disrespect people that have been killed, correct?
Yes.
Okay. They might even laud or are in the video happy somebody's dead, correct?
Yes.
Okay. But you wouldn't have any means to determine, nor has anyone said in a video that you've seen, I or we killed somebody.
Not using those exact words, no.
Okay. Well, when you say not using those exact words, you're talking about describing how somebody died, right?
Well, I'm saying that I've never listened, me myself have never listened to a music video where somebody has said, I killed John Doe.
Be really stupid, right? I would assume, and there are stupid people out there, but
Yes.
Nonetheless, the videos that you look at will tell you who is disrespecting who.
Yes, sir, in a very cryptic way.
And that would be cryptic way based on maybe the kind of person that person was that was deceased, correct?
Yes, sir.
Or how that person died, correct?
Yes, sir.
And people on the street, everybody knows how a particular person died. No secret, is it?
You just wait for the news.
Wait for the news. Doesn't take long. And in fact, once the news hits, or even before the news hits, people in the street know what happened and how it happened. And they also talk about who they think did it.
Yes.
And for what reason.
Say that.
And also for what reason they did it.
Like the motive behind it?
Yes.
Yes, sir.
And you utilize that information to determine whether or not a person or a group committed a crime unless that person was actually arrested and charged with that crime, correct?
We utilize...
You utilize that information in order to make determinations as to who you think committed a crime, even if there's not enough evidence to support an arrest.
We utilize, I think the second half was right. We utilize that information to guide us in the right direction, and then the evidence that we obtain and the facts of the case is what ultimately leads to probable cause for the arrest.
Well, in probably 75% of the incidents that we've talked about that would comprise the historical nature of this gang war, nobody's ever been arrested for hardly any of it. Isn't that fair?
No.
70%?
I don't know the exact percentages, but there's definitely been a significant amount of arrests in this war.
And listen, I don't want you for 1 minute to think that I'm disrespecting your work or suggesting to you that you guys don't get things done. I don't mean that. What I'm suggesting to you is that for you to think something occurred, for you to have somebody on the street say something happened, For somebody to diss somebody or to talk negatively about their death,
I'm just gonna ask if there's a question that would be asked.
I think he's getting there. What's the next question?
the question would be, that doesn't mean somebody did it, and that doesn't mean you can arrest them for it.
Based on like the social
them-
medias and stuff.
Based on them saying they were happy about it? Correct?
Yes, sir.
Doesn't mean somebody can be arrested.
Yeah, that's right.
Based on them disrespecting that person in general and being happy they're dead, not sufficient for an arrest, correct?
Yes, sir, correct.
Based on them talking about the graphic nature about how that person died, not sufficient for somebody to be arrested, correct?
Yes, sir.
So you can only presume by this bravado or this disrespect that that person or that group of people might have had something to do with that death, correct?
Yes, sir. Like I said, that kind of leads us into the direction. We take that information and couple it with the evidence, and that leads to probable cause for the arrest. It's not just strictly the social media and the disrespect and stuff. There's evidence and other things that go along with it that lead to the arrest.
As it relates, strike that. You utilize the criteria of the gang statute in order to document someone as a gang member, correct?
Yes, sir.
And in the daily course of your work, you look through social media to see if you can find something that is deemed relevant, correct?
Yes, sir.
You look at open cases to determine whether or not there's sufficient evidence to determine that a particular person or persons committed the crime, correct?
Yes, sir.
You determine and you look to see whether those people might be related with one alleged gang or even more than one alleged gang, correct?
Yes, sir.
Because these are what we call hybrid gangs.
The ones we're speaking about today, yes, sir, they're hybrid.
And that means there's no hierarchy in these gangs, correct?
No, sir, there's not.
There's no rules. There's nobody telling someone else what to do, correct?
Correct.
And in fact, they can do their own thing. They can get mad at somebody, whether it be a regular person or a person that exists in another gang, and they can go kill them, correct?
Yes, sir.
Doesn't have to be related to the gang for them to do that, right?
Right.
They could have their own motivation to kill someone outside of any association that they may have with other people that are alleged to be in a gang, correct?
Yes, sir.
Okay? And nobody has to make a collective decision in any one of these groups to kill someone else. You would agree?
Yes, sir, I would agree with you.
And nobody tells somebody else what to do, when to do it, or what they can or can't do, correct?
Yes, sir, I would agree with you.
And they can come and they can go as they please.
Yes.
And they could associate with a different gang if they want to.
Yeah.
And the information that you would get about these things would come either, as you testified to, from social media monitoring or talking to people in the streets.
Yes, sir, generally.
Okay, I'm sorry, Mr. Gonzalez, I hate to interrupt you, but I think one of the defendants needs to use the restroom, so we're just going to take a quick 10-minute recess, okay?
Thank you.
Sure. So, Detective, you are welcome to remain seated, or you can step down, but since you're under cross-examination, you can't talk to anybody, including the state, about anything related to your testimony. Okay?
All right, it's a real quick one to Hell Riders. So to answer your question, yeah, it's Brian Gonzalez. He's talking right now. He represented Zvante Sampson in the Sonny Bell trial. But you're also going to hear Daniel Hernandez. He represented Jalen Bedward. And then Nick Sonardi was Andrew Thompson. So Nick and Scotty, not related, same last name, really weird. But they represented Andrew Thompson. So that's 4 lawyers plus 4 to PI Sam. So that's 5 people that were in the Sonny Bell trial are also in this trial. So if people look familiar, and also the state attorney, not Doherty, oh, what's her name? I always forget her name, which is bad. Ismer, Anna Ismer. She was also in Sunnyvale. So if they look familiar and you guys watch Sunnyvale with us, then that's why. All right, let's continue on.
You reviewing them when they come out, when you become aware of them, etc., correct?
Yes, sir.
And the videos that you talked about, Who I Smoke, When I See You, the third being, I can't remember right this very moment. That would be List of Dead Ops. So most of these videos are old, correct? They're back from early 2021, 2020, thereabouts, give or take, right?
Yeah, give or take a couple, maybe a year or two, around that time.
And there are sometimes large numbers of individuals in these videos, correct?
Yes, sir.
Sometimes there's 4 or 5, sometimes there's 10, sometimes there's 15, 20.
Yes, sir.
Okay. And some of these people you may recognize as people you either have documented or you believe might belong to, be associated with, or documented gang members, correct?
Yes, sir.
And there are also several other people in there that A, you may not know. Is that fair to say?
Yes, sir.
And also that you would have no idea if they are in fact gang members.
I would say that just because they're in the video, they're not members, but it definitely meets the criteria of associates.
So if you appear with a gang member in a rap video, that gets you one step closer, criteria-wise, to being documented as a gang member.
Yes, sir.
Fair to say, pursuant to the statute.
Yes, sir.
And when you look at these rap videos, they're not coded. They're not word coded so that when people talk about them, you don't know what they're saying. Are they?
I don't think I understand that.
It's not coded language. I mean, they're talking. You may understand it. You may not understand it, depending on who you are and how often you listen to their work. But they're not coded with special words, are they?
Not the ones that I've heard, but I would agree with you on that if you live it and you are a fan of it, you understand it more than somebody who doesn't.
And when you do it, and the more you listen to it, you are interpreting those lyrics yourself, correct?
Yes, sir.
You would agree with me that whatever you say under oath is going to be your interpretation of that song or that word or that line.
Yes, sir.
Talking about training and experience, and I'm almost finished. You talked about HIDA, that's North Florida HIDA, correct?
Yes, sir.
That's a general conference. It has a gang component, but when you go to HIDA, you're learning about a lot of different things, whether it be racketeering, whether it be cell towers, whether it be global entry of drugs. It's a generalized course that detectives take that has a gang component within it.
The HIDA classes that I have taken were strictly 8-hour gang classes. Now, they do, HIDA is a drug-based agency, and so they do put on cartel and drug classes and interdiction classes and stuff like that.
So part of it is this is HIDA's gang involvement or gang preparatory course for you.
Yes, sir.
Okay. And you've done that at a beginner's level, correct?
I've taken one or two of the 8-hour HIDA classes.
Okay. And I think you also took a class by the Florida Gang Investigators Association, correct?
Yes, sir.
And I think you also took a class from, and I may be mispronouncing it, ROPIC?
Yeah, something along those lines. It's a combination of letters.
Right, and that also gives you a general understanding of a lot of different subjects, including gangs.
Yes, sir. That one is a robbery gang conference.
Detective, you have never been qualified as a gang expert, have you?
I wouldn't know how to answer. I've testified in gang trials before.
Okay, you've testified in gang trials. You've testified in a lot of trials as it relates to what you did in the investigation, as it relates to how you were involved in an arrest, whether you were involved in a search warrant. What I'm asking you is, has a judge ever qualified you in a trial to testify as an expert in gangs? The answer is no, correct?
I'm not sure that's done at the judge level or what. I would say that an expert is somebody who has more knowledge about something that the general public wouldn't. And I would say I have more knowledge about gangs and ATK than general public.
I would tentatively agree with you with regard to what you believe, your knowledge and experience is, but I would also suggest to you that you never recall having anyone in a trial say Detective Nieder is an expert in gangs and we're going to take his testimony as an expert. You don't recall that happening with a judge being able to say, yes, we're going to treat Detective Nieder as a gang expert.
I think that happened in the last trial. The state deemed me an expert, and I don't remember any objections to it.
Okay, so you believe you were qualified as a gang expert in the trial that was related to this case?
I'm not sure about the qualifications and how that's done at the court level. I do recall that the state said that I was an expert witness for them, and there was no objections to it.
Okay.
Based on my memory.
Understand your answer. Thank you. I don't have anything further.
Yes, sir.
Okay, redirect.
Your Honor, I believe several other defense attorneys have adopted this. Does the court wish to have them?
Yes, I'm sorry. Any additional cross from counsel for Davion Murphy?
Yes, if I may quickly, Your Honor.
Okay.
Good afternoon, Detective. My name is Dick Shinardi. I represent Davion Murphy. Do you recognize Mr. Murphy in the courtroom?
Yes, sir.
Prior to today, have you had any prior contact with Davion Murphy?
Just the date of his arrest.
That was it?
Yes, sir.
All right. Now, you've indicated that you have been a member of the gang unit of the Jacksonville Sheriff's Office since approximately 2021, is that?
22.
22.
Yes, sir. I'll be coming up on 4 years and maybe 4 or 5 months.
All right. In your employment with the Jacksonville Sheriff's Office in their gang unit prior to the arrest that you've referenced of Mr. Davion Murphy, I'm going to keep repeating Davion because there are two Murphys.
Yes, sir.
Had you had any direct contact with Davion Murphy?
No, sir, I have not.
All right. So that was the first contact, correct?
First one ever.
And did I understand you correctly when you indicated that your primary focus as a gang detective was the, which gang was that?
ATK.
ATK.
Yes, sir.
All right. And I'm assuming, and you correct me if I'm wrong, at some points in time, there's an overlap between ATK and possibly 1200 or 6 Block, et cetera?
ATK and 1200 would be like allied together. They post on social media together. They've hung out together. They make music together, but they are two separate gangs in themselves. And 6 Block is a separate gang in itself.
All right. Can you testify specifically what criteria under Florida Statute 874 that qualifies 1200 as a gang?
I do not have 1200. That would be a question for another detective.
So you don't know then individually how it is that 1200 qualifies as a gang as opposed to an association of individuals that live in the same neighborhood, correct?
Yes, sir, that would be correct. Name would come up due to his family ties.
All right. Are you aware or have you checked the prior history of Mr. Davion Murphy?
Like since his arrest or like prior to his arrest? No, sir. Before.
You realize that he was incarcerated until 2023?
That, I learned that earlier. I knew he was incarcerated, but I don't know the extent of time he spent in prison.
All right, thank you, Detective.
Yes, sir.
Okay, does counsel for Mr. Gathright have any, are you done?
Yes, I am
Okay,
now.
very good. You have any questions? Okay.
How are you?
Doing well.
Good, thank you.
Detective Sean Gathright, I think we may have covered this actually this morning, but you didn't know his name until it surfaced in connection with the case we're discussing today, right?
That's correct.
You've never documented him as a gang member, correct?
I have not.
Or a gang associate?
Based on this, he's not documented as associate, no, but based on this case and his connection to Isaiah Chance, he would meet one of the criteria that's outlined in 874.
Okay, and that's all information that you learned
After.
from Tampa PD, basically?
Yes, sir, after the homicide.
Thank you, sir.
Yes, sir.
Okay, and finally, counsel for Isaiah Chance, do you have questions? Okay.
Afternoon, Detective.
Hey, how are you?
You testified that you get a lot of information from social media.
Yes, sir.
Another way, do you do with interviews with gang members?
Yes, sir.
Would you say that they are unwilling to provide you specific information, though?
It depends on the circumstances of the interview. If generally, there's some of them that are really cool, that have outgrown that lifestyle, that will talk to you just man to man or outside of the walls. There's some that are still in the lifestyle, and they'll give you little bits and pieces here and there. And then there's some that face significant charges, and they are willing to help themselves, that give them information.
Okay. But if they're not helping themselves a lot of times, or they're no longer in the gang world anymore, they're giving you more generic information. They're not telling you what.
Yeah,
happened
it's
in
kind of
there.
just basic stuff that everybody will tell you.
Okay. And as far as Isaiah Chance, you documented him based on 5 reasons?
Yes, sir.
Do you remember those?
I do not have it right here in front of me. I need to refresh my memory.
Well, if I run through them very briefly, would you be able to tell me if you remember those?
Yes, sir, I would.
One of those was a 23 necklace he wore on 2 occasions?
Yes, sir.
Okay. Do you remember how you saw that? If you saw it in person? Or?
Yeah, he posted them on his social media, and one of them was in a music video.
Okay. And then 2 and 4 were, one was associated with 1 or more gang members, and one was associated with 1 or more gang members 4 or more times.
Yes, sir.
Do you know how you were able to see those? Did you see those in person?
Yeah, that's also on social media. Just he's posting up with ATK gang members. I don't remember exactly all of them, but I can remember a few of them, like Tayshawn Thomas, Antonio Tilley, like those guys, Raymond Lakes, Raheem West.
Okay.
And then another one was, it was called like a Day in the Life of ATK YouTube vlog that Malquise Worthen posted on YouTube. And in that video, you can see Mr. Chance sitting on the tailgate of a truck with a bunch of ATK gang members.
Okay. So you're getting all that from social media?
Generally, yes, sir.
And then another one was physical evidence that you referred to as an Instagram post?
Yes, sir. So physical evidence is, I treat it as like if I can physically hand it to you and stuff like that, that would be physical evidence. So the post I printed out, and it's in his case file, and it's talking about the ATK.
And the last one was a confidential informant?
Yes, sir.
Now, are you able to talk more about that confidential informant here today? Or is that still someone you are unwilling to release the name of?
I'm not willing to talk about.
Okay. Without asking questions about that, were you able to verify the information this person told you?
Yes, based on the other evidence that I've outlined in the document with all the other criteria.
The ones we just talked about?
Yes, sir.
Okay. Did this person give you any specific information other than just the simple fact that Mr. Chance was an ATK member?
They gave his nickname as well.
Which is?
He has several. Some people call him Double G. They call him Gutta Man or Gutta Zay or just Gutta.
Do you remember what this confidential informant referred to him as?
Gutta Zay.
Okay, that's all I have now.
Okay, thank you. All right, redirect.
You were asked by Mr. Gonzalez about the statements that are made on social media posts and in music videos not being direct statements of any crimes that have been committed. So you didn't hear any statements of, "I killed someone," correct?
Not to my knowledge, I don't remember hearing that.
But there are direct statements or admissions that are frequently posted by gang members. For example, Hakeem Robinson, or Queso. Was Mr. Robinson recently convicted of a crime?
Yes, he was, 2 or 3 days ago.
Is he a member of ATK?
Yes, he is.
Was he in the last several months also convicted of another homicide of a Lil Buck?
Yes.
Is Lil Buck actually Charles McCormick and a member of 6 Block?
I don't know about Lil Buck's document, his status, but he was definitely an associate and artist of 6 Block.
Are you familiar with an admission posted by Hakeem Robinson, aka Queso, in the case in which he was convicted? That was a direct admission. I killed an N-word and then I got my toes done.
Yeah, but it wasn't necessarily, that doesn't like imply. It doesn't say who he killed.
Someone,
Yeah.
does it?
No, it doesn't.
But that would have been a useful piece of information and ultimately was a useful piece of information utilized in the trial where he was ultimately convicted.
Yeah, I believe so. I didn't have to partake in that trial with the evidence, so.
So when you're responding about questions of direct statements of admission, your responses were limited to not seeing gang members say, "I killed so-and-so on X, Y, and Z date."
Correct.
But the other statements that you utilize to essentially develop leads on cases lead you in your investigation to potential items of evidentiary value to help solve those crimes.
Yes, they lead us in the right direction, and then we take that with the evidence that we obtain.
The same thing occurs when music videos are posted back to back, is that correct?
Yes.
Did you have an opportunity in 2023 to respond to the murder of 6 Block member Jake Jett?
Jaquan Pickens, yes, I did.
And that's his legal name is Jaquan Pickens.
Yes.
And were there several social media images or postings that took place immediately thereafter from a rival gang taking credit for that?
Yes.
That cannot serve, at least by itself, as evidence.
By itself, no. Yes, you're
But
correct.
after the social media images that you directly observed, did you, within 5 hours, subsequently respond to the attempted murder of Charles Jones, which occurred?
I think you got the timeline mixed up.
I'm sorry, Lil Kobe. It's an attempted murder for Lil Kobe.
Yeah, so I don't know the exact time of the, in between Jake Jett and Labobi, but it was somewhere around maybe like 10 or 12 hours, I would think.
But you're responding to a homicide scene, just like we previously discussed, in identifying the victim, correct?
For Jake Jett, yes.
And determining what group they're associated with.
Yes, he was a part of the bully gang 6 Block.
And you ultimately determine who is posting on social media, taking credit for those acts.
ATK.
And is there a shooting of a then ATK member within hours?
The shooting would have been of 1200 of Labobi.
So an affiliate or associate to ATK?
Yes, ma'am.
Same scenario when we're talking about the attempted murder of Charles Jones. Was there an attempted murder or a murder of a rival gang member that occurred hours before that?
Yes, ma'am. That would have been the murder of Antonio Tilley.
And did 6 Block members take credit for that on social media?
Yes, by trolling.
And did Charles Jones then become the victim of an attempted murder hours later?
Yes, approximately maybe like 4 or 5 hours later, Charles Jones had an attempt on his life where he was struck in the foot.
So despite not having these direct statements of I killed X, Y, or Z, as you're watching these music videos or watching these social media posts, are the investigations that you're conducting ultimately often confirmed because there is a shooting or another homicide of the individuals who posted those drill rap videos or posts to their rival gangs?
Yes, ma'am. We call it retaliation shootings.
As it related to your discussion regarding gang criteria, in addition to the tattoos, as you previously mentioned, or the type of dress that was depicted, are there necklaces that are depicted by ATK members or worn by ATK members?
Yes, they wear the number 23 as he was a victim of this town center homicide, triple homicide in 2018. They also wear a necklace that has a ace of spade, and it says ATK.
Without your specific knowledge of the gangs, ATK specifically or generally as it relates to 6 Block and 1200 in Jacksonville, would you know the importance of the nicknames that are being said in these music videos or in these postings?
Yes, I know the most of the members and associates' nicknames.
As a result of your work with the Jacksonville Sheriff's Department?
Yeah, just based on my knowledge and experience of doing this line of work.
You were asked about your familiarity with having met several of the defendants in this case in person. Is it common for you to become familiar with members of the gangs that you're investigating by way of seeing them on social media, even if you've never had personal contact with them?
Yes.
And are you able to identify several members of even just ATK without ever having contact with them based on the observations you make on social media?
Yes.
May I have one moment, Your Honor?
Yes.
When we're asking about your familiarity with the defendants specifically, we'll ask in your review of social media, have you had an opportunity to see the defendants either live or actively posting in real time on social media?
Of the ones sitting in here, two of the 4.
Which 2 of the 4 have you actively seen in real time posting or on live?
Rashad Murphy and Isaiah Chance.
Did you have an opportunity to observe Rashad Murphy via Instagram or another means?
Instagram.
And how is it that you were able to observe Mr. Murphy?
He's utilizing the Instagram Ghost 187.
And was that a live video or an active post?
A live video.
Could you see the defendant, Rashad Murphy's face in the live video?
Briefly.
Do you, when you're reviewing social media just day to day, actually record or preserve those videos when you're just doing general intelligence gathering?
No.
If there's evidence of a crime, do you then document that?
Yes.
Okay, so if it's just day to day activity, it's not necessarily something you make a note of?
That would be correct.
And as it relates to Isaiah Chance, you indicated you also saw activity of Mr. Chance. Where was he active?
On his Instagram.
And is that the Gutta Zay Instagram account?
Yes, ma'am.
Did you document interactions between the Gutta Zay account and the Ghost 187 account on Instagram?
They would tag each other and post.
Even to this day, there are active posts with tags, correct? I didn't ask you to check today, but within the duration of this case, as it's been ongoing, there's still active posts.
Somebody's had access to their accounts.
And these are posts as well as the stories that kind of disappear after a certain amount of time. Is that correct?
Yes.
When you saw the post from Mr. Chance's accounts, is he posting images or videos of himself?
Like since his arrest?
No, I apologize. During your investigation of the cases?
Yes, he has. He has posted pictures and images of himself.
And your familiarity as it relates to qualifying Mr. Chance based on his clothing and his music video, is that from Mr. Chance's music video, of Blood on My Prada's video?
Yes.
And is he depicted wearing some type of gang depiction or symbol in that video?
In that video alone, he's wearing the 23 necklace, and he's also with another ATK gang member who is, his name is Xavier Harrison. He goes by the name of Fat Zay.
So in 2 places you would have documented that?
Yes.
No further questions, Your Honor?
Joe, only as it relates to the redirect.
Okay, quickly.
So Ms. Ismer asked you about taking credit. Again, taking credit means somebody is on a video talking about a murder that was occurred or somebody who died. That's taking credit, correct?
Yeah, I would think like taking credit when they talk about it in music videos is just kind of like a disrespect thing. They don't necessarily did it, but they're going to disrespect it by saying they did it.
Well, they're not saying they did it. Does anybody say they did it? Didn't you answer Ms. Ismer by saying by trolling? Isn't that what I heard you say?
Trolling, yes, sir.
Yeah, trolling means that you are attempting to get under the skin of somebody else. You're trolling them.
I would agree with you.
And you would also agree that when the state uses over and over the word taking credit for, you mean they're on Instagram Live, or they're doing a video, or they're communicating, and they're disrespecting the person that died. That's what you mean by taking credit, correct?
Yes, sir.
Okay. And as it relates to Jaquan Pickens, the case that Ms. Isber brought up, that's an unsolved murder, correct?
Correct.
Okay. And when you talk about Jacoby Beals, who was shot the next day, essentially, you believe that was retaliation. You don't have any evidence to show it was retaliation, do you?
It was based on the time frame and the social media posts afterwards that was a retaliation for Jake Jitt.
Trolling, right? Discrediting and dissing.
Yes, sir. That would lead us to believe that it was a retaliation shooting.
And essentially, that would be from unconfirmed hearsay of other people talking on video, and from sources that you can't tell me who they were, can you?
Correct.
And one last thing, when it relates to Mr. Murphy, I know you talked to about Mr. Murphy. When did you see Mr. Murphy on Instagram?
I don't recall the exact time.
Okay, and who else was on there, you said, other than Mr. Chance? Anybody else on that feed? Did you take down other people's handles or other people that were involved in that conversation?
What do you mean by feed? Like as far as tag?
Well, you said you saw them live, right?
Mr. Murphy I've seen live.
Okay, and when you saw him live, can you tell me when that happened?
No, sir, I cannot.
Can you tell me who Mr. Murphy was speaking with?
No, sir.
Can you tell me what was being said?
No, sir.
I don't have anything further.
Okay, very good. All right, may this witness now be excused.
Yes, Your Honor.
Okay, all right, thank you.
I have a quick question. Is that for good or do
I
I
think
wait outside?
is he done?
All
You're
right.
done.
Thank you.
Okay, who's your next witness?
Judge, are you ready for us to call another witness?
I am.
Okay, we can call Craig Griffin, Your Honor. I apologize for the delay.
Okay, and is this still in relation to the defendant Rashad Murphy's second motion in limine, or is this?
Yes.
Okay.
Yes, Your Honor.
Okay, very good. All right, you may proceed.
Detective Griffin, how long have you been with the Jacksonville Sheriff's Office?
Going on 17 years.
And what were your prior assignments before the gang unit with the Sheriff's Office?
Prior assignments, I worked in patrol on the north side of Jacksonville. I was assigned to the narcotics unit. I also worked in internal affairs. I worked in sex offender registration and also assignments inside the jail.
In addition to those assignments, did you play some role in community-based outreach as well?
Yes, ma'am.
And what does that involve?
It involves reaching out to prospective gang members, trying to get those out of that type of life, to give them an opportunity, job, schooling with pastors and local community leaders.
Do you also have the opportunity as in the community outreach to make contact with active gang members or associates?
Yes, ma'am.
And do you have an opportunity in that role to also develop relationships, or at least some semblance of a trusting relationship with those individuals?
Yes, ma'am.
Is that through that outreach itself?
A little bit, yes, ma'am.
What are some of the day-to-day activities that you engage in as a gang detective?
We monitor social media. We monitor reports that we receive from officers that make contact with individuals through patrol. We actually go and do in-field interviews. We do nightly deployments. We do the community outreach as well. We document gang members. We undocument them as well once they reach the 5-year period, if they don't meet the qualifications anymore.
And is that by utilizing the gang statute to ensure that they either meet or do not meet those qualifications?
Yes, ma'am.
Is that the same operating procedure that would have been used by the other gang unit detectives in evaluating at the end of that 5-year period whether they still meet the criteria?
Yes, ma'am.
And that's applied uniformly, whether it be yourself, Detective Nieder, et cetera?
Yes, ma'am.
You all employ the same day-to-day activities as well, maybe different for your specific gang, but same day-to-day outreach, investigations, et cetera?
Yes, ma'am.
So I'm not going to dig too deep into that with you, but I want to ask you whether you also attend the gang conferences
Yes, ma'am.
and do any kind of follow-up work as it relates to staying educated on your particular gang.
Yes, ma'am.
What gang are you assigned with the Jacksonville Sheriff's Office?
Out East 1200.
And how long have you had that assignment?
Almost a little over 2 years now. I was working in conjunction with the prior detective as well.
Explain to me the difference between, or the relationship between, Out East and 1200.
So 1200 is a subset of the overall gang Out East. Out East is the main area. 1200 is a group in which follows up under Out East.
And is that a location or an area of Jacksonville as well?
Yes, ma'am.
Is it typical for members of those gangs to have resided at some time in that area?
Yes, ma'am.
And are you at least starting to see now members of each of these gangs that don't necessarily still live in those areas but are still members?
Yes, ma'am.
Did you have an opportunity in attending the gang conferences to also learn about the mechanisms utilized on a national level with the gang investigations and updated techniques with investigating gang activity?
Yes, ma'am, I have.
Have you shared your knowledge or expertise about Out East, 1200, or Jacksonville gangs locally or statewide or nationally with other gang detectives?
Yes, ma'am.
And have you had an opportunity to review, research, and look at the chart that was created, in this case as a demonstrative, for the group 1200?
Yes, ma'am.
Did the chart accurately reflect at least a portion or some of the individuals affiliated to the group 1200?
Yes, ma'am, it did.
Before you reached a 5-year, or before a 5-year mark was reached, I know you did not have Isaiah Chance assigned to you, but you said every 5 years that determination as to what gang you're affiliated with and whether you meet that criteria is reassessed.
Yes, ma'am.
Had you had an opportunity to come to that time frame with defendant Isaiah Chance in this case?
I have not, no, ma'am.
Was there some information or evidence that at some point Mr. Chance was transitioning from ATK to 1200?
Yes, ma'am, there was talks.
And was that also supported by Mr. Chance's social media posts about switching to 1200 as well?
Correct, yes, ma'am.
In your review of the social media posts that you have, are you able to monitor live videos with gang members associated to those accounts as well?
Yes, ma'am.
And are you always documenting your day-to-day observations, or do you document what you would deem could be useful information in the future?
We document what we deem to be useful in the future.
As a part of the criteria that you mentioned that's statutory, did you have an opportunity to, in looking at the demonstrative aid, confirm each of the individuals depicted met or meets that criteria?
Yes, ma'am.
As it refers to the met that criteria, are some of the individuals depicted no longer living? Were they victims of the back and forth rivalry?
They were victims of gang violence, yes, ma'am.
Did you learn of their relationship to the motive for these deaths as in your role as a detective in the gang unit?
Yes, ma'am.
How about information that you had or information that you knew about the gang rivalries in Jacksonville before you were officially assigned to the unit?
I knew a little bit, having worked in the north side of Jacksonville. You knew certain names that jumped out at you, but once I was assigned to the gang unit, I have gained way more knowledge in reference to the murders.
As it relates to the surviving members of 1200, at least to this point, were there individuals that also rep or previously repped a group 187?
Yes, ma'am.
What is the relationship between 1200 and 187?
So it was like a transformation. 187 would also be considered a subset of Out East. Once 187 was almost like a record label group. Once that kind of went away, they all fell up under 1200.
And so is it unusual for you to see, when you're reviewing, for example, one of the criteria of tattoos, an individual that claims 1,200 with a tattoo that says 187 or vice versa?
Correct.
And in your time investigating these types of cases and even attending the gang conference, were you able to determine what the reference 187 meant or was intended to reference?
Yes, ma'am, I did.
What is that?
So 187 is the California Penal Code for murder or homicide.
Do you also develop this information by way of either confidential or consensual proffers with gang members or former gang members?
That's correct, yes, ma'am.
And does that also occur as a part of your duties in the gang unit?
Yes, ma'am.
In addition to your role in Jacksonville, did you provide information about this specific gang rivalry and your observations from social media to the detectives in your gang unit and the detectives in Tampa?
Yes, ma'am, I did.
Were you specifically able to identify Davion Murphy and Rashad Murphy as members of 1200?
Yes, ma'am.
And have you had an opportunity to review the tattoo images that were collected of defendant Davion Murphy
Yes, ma'am.
from this case?
Yes.
Were there depictions included on those tattoos which you documented or made note of for future documentation which would have related back to either 187 or 1200 activities, including any individuals who were killed in that rivalry?
Correct, yes, ma'am.
Does that include Avery McKnight or Shug?
Yes.
How about Corbin Johnson or Corbin?
Yes, ma'am.
And Joe Rod Adams or Spaz?
Yes, ma'am.
Were those all in some way depicted and included on those tattoos?
Yes, ma'am, they were.
Is there some familial relationship between Rashad Murphy and Davion Murphy that you were able to ascertain?
I believe they're cousins.
And is there some familial relationship, either also a cousin or younger brother in some way, to deceased individual Joe Rod Adams, aka Spaz?
Correct.
Is that cousin or brother or something along those lines?
I believe they're brothers.
And is that information something that you're actually able to confirm, or is that just kind of intel that you have heard?
Just intel we received over the years.
Whose brother is Joe Rod Adams?
Be Davion.
But this is just intel from, outside witnesses of some kind?
That's correct, yes, ma'am.
There has not been at least, or is there required for you when you're creating documentation to obtain birth certificates or solidify familial relationships between the individuals?
No, ma'am, short of having both of them in a room and asking them.
And believing whatever the answer is?
Correct, yes,
Okay.
ma'am.
And so that's part of the intel that you're kind of utilizing in some way over the years as you respond to these calls for service. You learn that there is a familial relationship of some kind between Joe Rod Adams, Davion Murphy, and Rashad Murphy.
Correct, yes, ma'am.
Were you in charge of 1200 when Joe Rod Adams was killed?
No, ma'am.
And were you subsequently made aware of who had been convicted in that death?
Not till afterwards.
So subsequent to the homicide, of course.
Correct.
And was that Robert Howard?
That's correct.
When law enforcement in the Jacksonville area has a question, a concern, an interest in a 1200 gang member, are you the individual for whom they make contact with?
Yes, ma'am.
If there's an outside agency who needs information about 1200 or out east generally, so they're affiliates, I understand that there are several subsets to out east, do they contact you or
Yes,
attempt to
ma'am.
contact you for that information?
That's correct.
Are you the individual with the Jacksonville Sheriff's Department that's considered to hold the specialized knowledge about the out east gangs or 1200 specifically?
Yes, ma'am.
And is that to include the members of the gangs and their associates?
Yes, ma'am.
I'll pass the witness, Your Honor.
Okay, Mr. Gonzalez? On behalf of Rashad Murphy?
Detective, you became assigned or started to become more intimately familiar with 1200 in the early part of 2024, correct?
Roughly, yes, sir.
And so that would have been just a number of months prior to Charles Jones' shooting in June of 24, correct?
Yes, sir.
And before that, you assisted in some of that particular gang activity, right?
Yes, sir.
And utilizing the intelligence or the day-to-day work that the state was asking you about, you monitor reports, meaning you monitor field interrogation reports, correct?
Yes, sir.
You monitor social media for what you can hear and what you can see and what you can develop, correct?
Correct.
And you also talk to people in the street.
That's correct.
And you would agree with me that the majority of the intelligence you get is either from monitoring social media or talking to people in the street, correct?
The FIRs or field investigative reports are pretty important as well.
And when you do this documentation process, each detective utilizes their own means to do that, correct?
Yes, sir.
Granted, there's a statute that broadly tells you what you can document somebody by, correct?
That's correct.
But each detective decides when to document somebody, when they fulfill that that requirement, and when that happens.
Yes.
And you talked about 1200 being a subset of Out East.
Yes, sir.
Who are the prominent members of Out East?
So you got Spinner Benz, Whopper with the Chopper, you have Green Light.
Those are not members of 1200?
Those members of 1200, yes.
Okay, so are you referring to 1200 and Out East being the same?
Yes,
You
they
said
all
one's
fall.
a subset of another.
Correct. But they all fall up under Out East 1200. That's the way it's labeled.
And you said that you have either come in contact or you had information with regard to Rashad Murphy, correct?
Correct.
And this would have happened during your time frame with the gang unit after you became strictly associated with 1200,
Correct.
which would have been in 2024, correct?
Correct. And not until till the murder happened.
And the criteria within which you documented Rashad Murphy came as a result of 2 contacts that you had in
Just lost audio here. Can you guys still hear me? Just make sure that that's on their side.
They're asked, hey, listen, do you know gang members? Fair
Yes.
statement?
Yes, sir.
And you give them a list of people, and they say, yeah, he's a gang member. No, he's not a gang member. He's a gang member. That's what happened in these 2 incidents, correct?
More or less.
Okay? So somebody in a car somewhere that has a misdemeanor amount of marijuana is asked whether or not Rashad Murphy is a gang member, and that meets the criteria for him being a gang member under the statute.
Meets one of the criteria.
Right. And the other criteria would be that he was in the association of an individual on at least 2 occasions by the name of Noah Williams, correct?
Correct.
And Noah Williams is a gang member, correct?
Correct.
And he's been documented as a gang member because other people have said he's a gang member, or he's been in the company of gang members. That's how he became a gang member.
And also his social media.
Okay? His social media doesn't tell you he's a gang member, does it?
It's certain stuff that they put on social media that we kind of use as information as well.
Okay? And you're aware that Noah Williams grew up with Rashad Murphy since they were babies. Did
Yes,
you know
sir.
that in intelligence?
Yes, sir.
Okay? Would that be a significant and reasonable enough circumstance for him to be around Noah Williams at least 2 times when you guys saw them?
Yes, sir.
That is the criteria that made Rashad Murphy a documented gang member, correct?
Yes, sir.
And as it relates to 187, 187 was formed in order to promote rap music, correct?
That's correct.
And at one point in time, those people or those guys that were promoting that rap music or that were part of 187, it ended up dissipating or dissolving, correct?
That's correct.
Okay. And you're saying that some of those members became 1,200.
Correct.
Okay. And they became 1,200 from 187 because somebody told you that they did, right?
That, and along with field interviews, Instagram posts, social media posts.
Okay. You won't have any of those field interviews, would you, that have people's names on them and phone numbers and Twitter handles and Instagram handles?
No,
you
sir.
wouldn't have those for me to look at, would you?
No, sir.
You wouldn't be able to tell me when it occurred, would you?
I can tell you roughly around what year.
Okay. And it would have certainly had to occur after you came on board in 2024, correct?
What do you mean?
The field interviews that documented Mr. Murphy.
For Murphy or for the 187?
No, Murphy.
For Murphy?
We're talking about Mr. Murphy.
For Murphy, not till after I came on, yes.
Okay. And so you don't know what members of 187 that were promoting music and rap music turned into members of 1,200, correct?
Well, we knew two of them for sure.
Okay, who are the for sures?
For, Noah Williams
Yeah.
and Whopper with the Chopper, which would be Reginald Williams.
And that's because they continued making music, right?
Correct.
And the music they made dissed other people
Correct.
and talked badly about people being murdered, correct?
Correct.
And gave intimate details of those murders, correct?
Correct.
Which you knew the details of those murders as well, right? As
Correct.
a law enforcement officer? Did you find out about the intimate details of those murders by people on the street?
What do you mean?
Well, did you find out about intimate details of particular murders by talking to people who said they knew about those murders?
Not necessarily, just through the homicide investigations themselves.
Okay? And so other people, lots of people, thousands of people knew about these murders and how they were committed.
If you're going off based off the music, yes.
Okay? And additionally, you can't eliminate that there weren't thousands of other people talking the same way about those murders on social media as the ones you were monitoring.
What do you mean? I don't quite understand your question.
Can you preclude that, because lots of people knew about these murders, didn't they, when they happened?
I wouldn't say lots of people. What are you saying, just like based off of the amount of people that viewed the YouTube video?
No, I guess I'm just saying when somebody gets murdered out in the street, people know about it real fast, don't
Yes,
they?
yes.
And they actually know how it happened real fast.
I mean, short of somebody being shot in the middle of the street, that's kind of all they know.
Okay? And then people immediately start talking about it, rapping about it, having social media posts about it, and it goes crazy viral, right?
Yes.
And you guys are monitoring just certain ones that are doing that, correct?
Correct.
And there may be 50 other similar videos, similar posts, similar conversations on social media that you're not monitoring that are saying the same thing.
That's correct.
When you talked about 187, and you talked about the statute, the murder statute, isn't it a fact that you are making an assumption, which you have every right to do, don't disagree, I don't disagree with it, you're making an assumption that there can be a connection between 187 in Jacksonville, Florida, and the murder penal statute in California, right?
Yes.
Nobody told you that.
Field interviews.
Okay, so people out in the street, you wouldn't be able to tell me who told you that, right?
No.
Okay, but you're assuming that there's some connection without having an evidentiary foundation that there is, correct?
Correct.
So Detective Griffin, you've gone to HIDA conferences that include components of gang-related work, correct?
Correct.
And they include other types of law enforcement training and education as well.
Correct.
All right. And you've done that since you've been a member of the gang unit.
Yes, sir.
Okay. So that would put you at 4 years or so.
Yes, sir.
In addition to HIDA, was there any other conference that you attended?
What HIDA is just, they offer courses. I believe what you're referring to is FGIA, which is the Florida Gang Conference.
I got it. So HIDA, you've had courses in social media, cell phone investigation, correct?
Correct.
And those can be applied in any area of law enforcement, right?
Yes, sir.
They just make cops better cops, detectives better detectives.
Yes, sir.
Okay. Detective Griffin, you have never been qualified as a gang expert, correct?
No, sir, I haven't.
Nothing further. Thank you.
Okay, Mr. Sonardi, on behalf of Davion Murphy.
Thank you. Good afternoon, Detective. My name is Nick Sonardi. I'm an attorney. I represent Davion Murphy. Do you see Mr. Murphy present in the courtroom?
I do, yes, sir.
Could you identify him, where he's sitting?
He's sitting between the gentleman with the blue jacket and the lady with the glasses on. He has an orange jumpsuit on.
Let the record reflect he has identified Mr. Murphy. So that I'm clear, when was it that you actually became a member of the gang unit of the Jacksonville Sheriff's Office?
February of 21.
So at the time of the homicide involving Mr. Jones, it was, you had been a member approximately 3 years, is that correct?
Correct.
And I believe you've indicated that you were one of the ones during that period of time that assisted in documenting gang members. Is that accurate?
Yes, sir.
And I think we've gone over the method that you utilized in order to identify gang members, and a lot of that was interviews with people in the street, maybe looking at social media. What else?
Yes, sir. Interviews in the street, social media, jail phone calls, jail tablets, meetings just in general with the prospective gang members.
When, if ever, did the name Davion Murphy ever appear on your radar?
Not until this incident.
All right, which would have been in 2024, correct?
Correct.
So prior to between 2021 until 2024, the name Davion Murphy meant absolutely nothing to you, correct?
Correct.
You did not associate him with either Out East, 187, 1200, or any of the other gangs, correct?
It's my understanding he was in prison.
That is correct, until 2023.
Correct.
So the answer to the question is he was never associated with any gangs during that period of time.
Correct.
All right. Have you designated, or are you aware of any designation as we speak today that Mr. Davion Murphy is a member of a gang?
He meets the requirements to be documented as a gang member, but currently, as of today, he is not a documented gang member by myself.
Well, of anyone that you're aware of with the Jacksonville Sheriff's Office that has documented Mr. Davion Murphy as either a gang associate or a gang member?
Not that I'm aware of.
Okay, so as he sits there today, to your knowledge, as a member of the gang unit of the Jacksonville Sheriff's Office, Mr. Davion Murphy is not, nor has he been since the commission of this offense, a member of any gang, correct?
Not with the Jacksonville Sheriff's Office, but with the Florida Department of Corrections might be a little bit different.
All right, you talking about Florida State Prison?
Correct.
All right. And are you aware of any designation by the Florida State Prison that Davion Murphy is a gang associate of any gang?
I believe they have him listed as a STG in there.
You have to help me. What is STG?
Security Threat Group. That's how they document gang members in the DOC.
That's your belief. Have you ever confirmed that?
With Davion, no, but that is how they do it in DOC. That's what it's referred to.
Well, that's what I'm asking you. As to Davion Murphy, have you ever documented whether or not he qualifies? I believe you're using it at STG. Is that correct?
I haven't reviewed DOC's record.
All right, so as we speak, you don't know if he was even documented by Florida State Prison as a gang member?
Correct, sir.
All right. Now, let's see if I can clarify Out East. What was Out East?
What do you mean?
Is that what is Out East?
Out East is a portion of Jacksonville.
Okay.
It's an area town in Jacksonville.
Is that a designation for any kind of gang or assembly of individuals?
Where a lot of known Out East gang members are born and raised. They reside at. A lot of violent crimes have occurred. Robberies, murders, thefts, firearms.
Well, my
drug
question
sales.
is it a designation that is, as is 1200 or 187? Is it the same type of designation, or is it simply a geographic area?
Geographic area up under that.
All right, so it's
Title.
not a gang designation.
I don't think I understand what you're saying. That
Well,
the
I'm
gang
trying to
designation.
determine, you've identified out east as being
Area of town.
an area of town.
Yes.
All right, and my question is, out east also a designation for any type of gang?
Yes.
It is.
Yes.
All right, that was my question. Now, did out east, at some point in time, involved into 1200 or 187?
1200, 187 are subsets of out east.
Well, that's what I'm
So
asking.
They represent out east.
Okay, and is 1200 a part of out east, the geographical area of Jacksonville?
Yes.
All right, and what about, you've identified 187 as allegedly a penal code designation from California for murder, I guess?
Correct. It wouldn't be an area of town.
Okay. Since your time as a member of the gang unit of the Jacksonville Sheriff's Office, are you aware of Davion Murphy being a member of 1200?
No, but currently he does meet the requirements to be documented as a gang member.
All right. Prior to the homicide of Mr. Jones in 2024, were you aware that if Davion Murphy was a member of 1200?
No, sir.
All right. All right. Subsequent to the homicide of Mr. Jones in 2024, are you aware of whether or not Mr. Davion Murphy was a member of 1200?
No, sir.
Now, you indicated part of your criteria or methodology to determine whether or not an individual is a gang member is reviewing social media, correct?
Yes, sir.
And I guess we're talking about Instagram, X, YouTube. What other ones are there?
Facebook.
Facebook.
Twitter.
All right. In your review of that social media, have you ever seen Davion Murphy?
No, sir.
All right. What about the rap videos that you've described or talked about? Have you ever heard or identified Davion Murphy as either one, the individual doing the rap video, or being a part of the rap video?
No, sir.
Now, I believe there was some mention to tattoos of Mr. Murphy, Davion Murphy. I hate to keep repeating Davion, but we have two Murphys.
I got you.
So, were you personally familiar with any tattoos on Davion Murphy?
Not till after the photos.
You saw the photos?
Correct.
Okay. And what are those photos, and they're in evidence, we can show them to you, what are those photos that you believe identified Davion Murphy as a member of 1200?
Correct, one of them that says 1200 block.
1200 block. And that's, I believe, the big tattoo on the back of his neck and his back, correct?
Yes, sir.
Is that what we're referring to?
Yes, sir.
All right. Do you know when that tattoo was applied?
No, sir, I don't.
Do you know whether or not it was applied in prison or not?
No, sir, I don't.
All right. And is it fair to say that a gang member designation expires after 5 years?
That's correct, yes, sir.
All right. And do you know whether or not Mr. Murphy, Davion Murphy, if he did in fact have a gang membership, whether or not it expired after 5 years in light of the fact that he was incarcerated?
I don't know.
Yeah, all right. Thank you. I have any further questions?
Okay, thank you. All right, Mr. Wise, on behalf of, okay, very good. Mr. Petratus, on behalf of Isaiah Chance.
I'm going to go quickly, and then Mr. Wise, with the court's permission, can cover for me. I have to pick up my son, and no one else can do it. And I don't want to stop this from going because I know we have people from out of town.
Yes. How many more witnesses do you have?
Judge, we have two.
All right, very good.
Okay. Just a couple questions. Detective, what was the talk surrounding Mr. Chance moving from ATK to 1200 that you heard?
I believe it was an Instagram post. He was upset about one of his friends that died by way of gang violence and them not getting no retribution for it.
Now, so did you got that from an Instagram post, or you were told that by somebody else?
I was told that by somebody else.
Did you ever see the Instagram post?
No, sir.
Who told you that?
It was another detective within the unit.
Okay. So would it have been Detective Nader?
It possibly could have been.
Did you hear anything from anyone on the street about this supposed move?
No, sir.
Okay. And so all you know is from Detective Nader?
Correct.
Okay. That's all I have.
Okay, very good. All right, Mr. Wise?
Hello. I know we covered this earlier, but you didn't know Sean Gathright until the traffic stop that we talked about earlier.
That's correct.
You've never documented him as a gang member, correct?
No, sir.
And you never documented him as a gang associate either?
No, sir.
Thank you, sir.
Okay, rebuttal, excuse me, redirect?
Detective, whether you have documented Sean Gathright or Davian Murphy or Rashad Murphy, whether you did it or did not, is that what's necessary to determine whether the defendants each meet the criteria for documenting them under Florida statutes, or meet the criteria for being a gang member or gang associate under the statutes?
No, ma'am.
Is the documentation that you keep being asked about, whether they're documented gang members or documented associates, the reports that are utilized by your agency or across jurisdictions to discuss or share information about gang members?
No, ma'am.
When you are talking about certified gang members or gang members that are listed by your agency, that is whatever report you all are utilizing and uploading.
That's correct. Yes, ma'am.
Does that have any correlation other than having used the statute to make those lists to the fact that in looking at the statute, the defendants still meet the criteria on that list?
Correct.
When you were asked specifically about Rashad Murphy, you indicated you had intel on the street, but also there were music videos, correct?
Correct.
Which depicted Mr. Murphy possessing firearms, correct?
Correct.
With that association member that he says is a brother, or that you were asked about being a close relative to him, Noah Williams?
Correct.
And in those videos, with a reference to F. Foolio attached to all of them, Mr. Murphy is depicted, is that correct?
That's correct.
Mr. Murphy?
Rashad Murphy is depicted, is that correct?
Yes, ma'am.
And Rashad Murphy is possessing firearms along with other gang members in those videos, correct?
Yes, ma'am.
You were able to identify specifically documented gang members in those videos and reviewing them.
Yes, ma'am.
Even though you were not assigned to 1200, when you actually got the 1200 assignment, basically, you had already been in the gang unit?
Yes, ma'am.
And you had to essentially learn the history of 1200 and catch up.
Yes, ma'am.
Because these music videos that you were referencing with Rashad Murphy, some of them date back to 2020. Isn't that correct?
That's correct.
And in reference to those videos as well, are there several individuals, to include Mr. Rashad Murphy, utilizing gang signs as well?
Yes, ma'am.
How about clothing indicative of their membership?
That's correct.
And clothing directly related oftentimes to Charles Jones, or the victim, Foolio.
Yes, ma'am.
When the videos are reviewed by you or preserved by you, you educate yourself on the history of the gang despite only having been assigned to 1200 for half a year or so.
That's correct.
And did you have some knowledge at least of the inner workings of Out East and 1200 when you actually were transferred to that group?
Yes, ma'am.
When you discussed Mr. Davion Murphy, you don't recall which gang he was affiliated with in the Department of Corrections custody?
No, ma'am.
So that would have been another member of your agency that would have reviewed that information.
Correct, when it comes to DOC paperwork.
And you also were asked about whether you were aware whether Davion Murphy was a member of 1200 at the time of the homicide. When you obtain information, even if it is after the offenses that you arrived to investigate, are you still checking to see if at the time the crime was committed, each of the defendants meet the statutory criteria required to be considered a gang member or a gang associate?
Yes, ma'am.
I have no other questions, Your Honor.
Okay, may this witness be excused?
Yes, Your Honor.
Okay, you are free to go.
Thank you.
All right, who's the next witness?
Detective Trey McCullough.
Very good, you may proceed.
Please state your full name for the record and spell your last name for the court reporter.
It's Detective Trey McCullough, and it's MCCULLOUGH.
How are you employed?
I am employed at the Jacksonville Sheriff's Office.
How long have you been with the Jacksonville Sheriff's Office?
Roughly 10 and a half years.
Prior to becoming an officer with the Jacksonville Sheriff's Office, do you have any prior law enforcement experience?
I do.
What is that?
I started my career out in Bradford County, which is in Stark, Florida. I did a year and a half there. And then from there, I went to a different agency, Baker County Sheriff's Office. And I did 3.5 there. So roughly total of about 15, including JSO.
And before coming to Jacksonville Sheriff's Office, what sort of assignments did you have at those other 2 law enforcement agencies?
Well, I started out in patrol, and then from there I went to like an investigation slash like major crimes unit, narcotics unit.
And you, oh, did I interrupt you?
No, that's it.
Okay. You said you're a detective with the Jacksonville Sheriff's Office, is that correct?
That's correct.
What unit are you currently assigned to?
I'm currently assigned to the gang investigations unit.
How long have you been in the gang investigation unit?
Coming up on 4.5 years.
4.5 years. Prior to coming to the gang unit, were you familiar in your position as a Jacksonville Sheriff's deputy with gang activity in Jacksonville before coming to the gang unit?
I was, yes.
And prior to coming to the gang unit, how long had you been familiar with the gang activity, specifically the rival gang war between ATK, 1200, and 6 Block, and some of the other groups that they were subsets of?
I started my career at JSO in, it was 2016, so shortly after that, whenever I got released to patrol.
As a patrol officer, would there be more than a few occasions where you would become aware of those 2 groups and some sort of incident that occurred?
Yes.
And when you went specifically to the gang unit, did you have any specialized training in order to become a detective in that unit?
I had previously worked in the narcotics division at the Jacksonville Sheriff's Office. I did like a citywide task force type deal, and then obviously the gang unit.
And as a member of the gang unit, do you receive training that is specifically geared towards gang activity?
I do.
What sort of training did you receive?
So the very first training I received once I became, or once I was officially in the gang investigations unit, was it was a 16-hour course. It was I believe it was labeled the beginner course, and then from there I did the intermediate training, which was like a year and a half, 2 years later, and that was a week-long course, like a 40-hour course. And then in between that, there's been numerous classes that I've attended, taken, like maybe they're like a one-day course here in Jacksonville, or depending on if it's a local training or something that we can go to, and not travel out of state or out of city.
And when you reference the beginner and intermediate courses and training that you have done, are those courses specifically focused on gang activity?
That's correct, yes.
Is there any sort of certification from going to those 2 courses?
You receive a certification with your name and the total number of hours of the course and the actual name of the course.
And you said that you had been in the gang unit for 4 years, is that correct?
Coming up on 4.5 years.
Coming up on 4.5. And as a member, as a detective in the gang unit, what are your daily activities that you do on a daily basis?
Just to monitor the gang activity in Duval County, which includes like assisting other units such as homicide, our RVCU unit, which is they investigate all shootings that don't result into a murder. We assist other units if they have questions about the gang activity and the current trends or beefs that who's going on and who's going back and forth, whatnot.
How many members are in your unit, the gang unit in Jacksonville Sheriff's Office?
There are currently 12 detectives and 2 supervisors.
And as part of the makeup of that specific unit, are there members within your unit that are assigned to specific gangs?
Yes,
Are you assigned to a specific gang or subset?
I am.
Who are you assigned to? What gang?
I'm currently assigned 6 Block, along with Bully Gang.
And I want to ask you about that. You said 6 Block along with Bully Gang. Are they a related, or is one a subset of the other?
Bully Gang is a subset of 6 Block.
And can you explain what you mean by that it's a subset of 6 Block?
So essentially, 6 Block was a documented criminal gang prior to me coming to the gang unit. As the older, or I should say the younger guys were coming up, they kind of created this thing. It was, Bully Gang, but it was the same group of individuals that were associated with 6 Block, just a younger version. Similar to how PCE was, the older version of 6 Block, and then 6 Block formed and so forth.
And is that kind of evolution in the gang in Jacksonville, is that something kind of unique to Jacksonville in particular, where you have older members involved in a specific gang, and then younger generations or newer members then become that are a subset of that group?
Yes, ma'am, I would say that's accurate.
And that is based on your knowledge and training in this specific area in Jacksonville, is that correct?
That's correct, with all the historical data and the same group of individuals, just maybe a different term or different name.
And you said specifically, you mentioned PCE, that was a much older group, and as a result of that, 6 Block became a subset of that, is that correct?
6 Block essentially formed after PCE was dismantled in a RICO.
Was it a RICO, is that correct?
That's correct.
And when 6 Block took over, was there a member that was a predominant member who was known for 6 Block?
Yes.
And who was that?
Charles Jones.
And was Charles Jones a documented member of 6 Block?
Yes, he was.
Was he the most predominant or well-known member of 6 Block?
I would say that's an accurate statement.
And when we go back to PCE, there would have been documentation. I know that you said you were just there for 4 years. When there is a gang that is evolving or becoming active in Jacksonville, is there a requirement that be documented in a field incident report?
That's correct.
And that would have occurred prior to you being taken over, is that correct?
That's correct.
Both for PCE and for 6 Block?
That's correct.
But as the current detective in 6 Block, would part of your job and duties of becoming the gang detective specifically covering 6 Block, would you go over and take a look at those certifications and that document and that history?
Yes.
And would members of the other members of the gang unit who are responsible for the other gangs, would they be responsible as well for taking a look at that prior documentation?
Looking at the prior documentation for 6 Block or their assigned?
For their assigned gang?
Yes.
I apologize. So going back to some of the daily responsibilities, now that you are the current person tasked with 6 Block, do you now document gang members and undocument them if necessary?
I do.
Counsel, can you all approach the bench real quick, the
Yes.
attorneys?
May I proceed?
Yes, you can proceed.
Detective McCullough, I was asking you about your daily duties as a gang unit detective specifically assigned to 6 Block, and I believe I was asking you about your documentation. That is something you currently do, is that correct?
That's correct.
So you are responsible for that documentation.
That's correct.
How is a gang member undocumented?
Depending on their activity, after 5 years, we revisit their, what kind of investigate what they're currently doing, and if they have no like specific gang ties or any activity or still, claiming or, repping the gang that they were associated or familiar with, then, there's a report written that basically, kind of eliminates them.
And that is required based by the Florida gang statute, is that correct? 874, that documentation be kept, is that correct?
That's correct.
And you said that you also monitor social media, is that correct?
That's correct.
And are you familiar with the term drill rap videos?
I am.
And what does that mean to you in respect to the Jacksonville gang, rival gang war that's going on?
The drill rap in Jacksonville really took off quite a few years ago, and it's essentially music made by up-and-coming artists that's extremely vulgar, and they, diss or talk bad about, the opposing rival gang. If someone gets, shot or they're injured or murdered, they get on social media, they talk about it, they make specific details about their murder just to kind of throw a shot, if you say, or if you want to call it that, just basically throw shade at the other side, kind of diss the deceased of the, their rival gang.
Why do you monitor and track those drill rap videos?
Because from my training and experience, that usually draws a response, from.
Retaliation?
Correct.
And I want to also ask you about your training and experience specifically with the drill rap videos. In these drill rap videos, are there nicknames that are utilized by the singers, the rappers who are making these drill rap videos?
Yes.
And based on your knowledge and training in the gang unit, do you recognize the nicknames that are being utilized in these drill rap videos?
I do.
And based on your knowledge and training as a gang detective, do you receive briefings and alerts when members, these gang members, 6 Block, as well as the rival gang members, when there is a shooting that occurs?
Yes.
And as a gang member detective, do you sometimes respond to those locations to assist in the investigation?
I do.
And does that include homicide cases?
Yes.
Shootings that occur at high schools?
Yes.
Shootings where people survive their injuries?
Yes.
And based on your specialized knowledge and training, the timing of those music videos, can that have a significance to an investigation?
Yes, absolutely.
And that is all based on your specific knowledge and training in the gang unit, in this gang unit in Jacksonville, is that correct?
That's correct from the history that they have shown in the past, yes.
And I know that we have shown you this chart for 6 Block, is that correct?
Yes.
You did not make this chart, is that correct?
I did not.
That was a chart that was put together by other gang detectives in your unit, is that correct?
Yes.
I believe Detectives Drebeck and Detective Nieder.
Yes.
But you yourself, since you were assigned to 6 Block, did you look at the people that are listed, the members and associates that have been put on this chart?
I have.
And could you confirm that these are members and associates of 6 Block?
Yes.
And you know that based on your time and experience as a gang detective, is that correct?
That's correct, along with some of them I have, had interactions with, so.
So I want to specifically ask Charles Jones, he's on here, what was his nickname?
His Instagram handle was Julio Foolio, but people in Duval County just referred to him as Foolio or Six or Lil Six.
And you said that you have, not only have you had interviews with people on the street, but you yourself, during your work in this specific unit, you have had contact with members, is that correct?
Yes.
And that's live and in person?
That's correct.
And can you give us an example of some of the members of 6 Block that you have encountered and have met and have seen out in person when you are working in the field?
From that list or just in general?
In general.
It's kind of a long list, but obviously Charles Jones, Felix Poussey, Loreno Span, Therese Poe, Gary Davis, Alex Bass, Keon Newkirk. There's numerous. I don't
Numerous. You've been in the gang unit for a very long time, is that correct?
That's correct. 4.5 years, yeah.
And you said that just on the list, there are other documented members of Sixth Block and associates that are not on this list, is that correct?
That's correct.
This chart in particular was put together based on some relevance to this case. Are you familiar with Adrian Gaynor Bibby?
I am.
And is he a documented member of Sixth Block?
Yes.
And how are you familiar with Bibby?
He was murdered in Hilltop back in 2019, I believe.
And when you say Hilltop, what area of Jacksonville are you referring to?
It's on the northwest side of Jacksonville, Duval County. It's an apartment complex, Hilltop Village Apartments. It's right there on West 45th Street.
And what gang is associated with Hilltop, that area?
6 block.
6 block. So Charles Jones and Adrian Gaynor, that's kind of their area, is that correct?
That's correct.
And did you know the relationship between Charles Jones and Adrian Gaynor?
Other than they were super close, very close friends.
And are you familiar with a rap video, Who I Smoke?
I am.
And in that rap video, and that is put on by the rival gang, 1200 and ATK, is that correct?
That's correct.
There are several refrains in that, or several lines in there, Who I Smoke, and then there is a specific name or a nickname that is given after Who I Smoke, is that correct?
That's correct.
Is one of those nicknames that is mentioned by ATK and 1200 in that song, Bibby?
Yes.
Were there other nicknames that were mentioned in that song after that sentence, Who I Smoke?
There were.
And are some of those other members that were specifically mentioned, those nicknames of gang members belonging to 6 block or the subset bully gang, are they actually dead and deceased from that song?
Yes, every name mentioned in that song, Who I Smoke, is deceased.
And were nicknames utilized specifically in that video?
That's correct.
You're also familiar with a drill rap video that was created by Charles Jones that was called When I See You, is that correct?
That's correct.
And were there specific individuals that Charles Jones referenced in that drill rap video that referred to people who were killed in the rival gangs?
That's correct.
Who was that?
I don't remember their actual, I want to say Jacoby Groover, he was 4, that's what he went by, and then 2 times, which was Kenyatta Buller's brother, and then 23, which was, I can't think of his legal name, but it was.
You know the nicknames, correct?
Correct, yeah.
And as a gang member in Jacksonville, part of that unit, even though you're just assigned to 6 block, do you also have familiarity and share information with the other gang detectives who are responsible for the rival gang?
That's correct. We share information. I'm extremely familiar with, the gang that I'm, specifically assigned to, as well as the other ones. I don't know, like, pertinent details to the other rival gangs as like I do at 6 block.
But you're familiar enough with the nicknames, is that correct?
Correct.
And you said Kenyatta Bullard. Is that the person known as Yungeen Ace?
That's correct.
He was shot several times in that same shooting but survived, is that correct?
That's correct.
As a detective specifically assigned to 6 block, are you familiar with the criteria that some gangs have hand signs or hand signals?
Yes.
Is there a hand sign or a signal that is particular to the gang 6 block?
There is.
And what is it?
There are several, actually. There's one for 6 block, one for bully gang, and then there's another hand sign that they flashed that we have determined to be as a hand sign associated to 6 block.
And I'm going to show you just what's been marked for identification 6 block. I want to take you, some of these photographs are from social media. Is it common for members of the gangs in Jacksonville to post photographs, videos to social media, to various social medias?
Yes.
And in those photographs, can you recognize the hand signs that are specific to 6 block and specific to bully gang, as you have just described? And I know that some of them have more than one.
Yes.
And looking at that chart, are the photographs that are specifically utilized in this chart, do some of the photographs contain members that are flashing those hand signs?
Yes.
And can you kind of just describe, and I know it's sometimes hard to describe, what are some of the hand signs that are typical for 6 Block?
So you want me to demonstrate them?
Yes, ma'am.
So,
Yes, sir.
so this would be the 6 Block hand sign, and then this would be the Bully Gang hand sign, and then they'll, flash the K for Kendra.
And they will post themselves doing this, is that correct?
That's correct.
And that can be sometimes part of the documentation of the certification, correct?
That's correct.
And you know that because you have specialized training for these specific groups, this gang and its subsets.
That's correct.
And the chart you just showed him, is that marked as an exhibit?
Judge, we're going to argue it later, but I just had him look at it marked for identification.
Okay.
And just for the record, it was a chart that was entitled 6 Block Members and Associates. Is that correct, sir?
Yes.
Now, not only do you assist other gang detectives in your unit, do you also assist other law enforcement agencies if there is any sort of intel or information that is needed regarding your specific gang 6 Block?
Yes.
And that would include Tampa Police Department for this investigation, is that correct?
That's correct.
And along with the hand signs that you are familiar, that are unique to 6 Block and Bully Gang, are you also familiar with dress style and/or any specific jewelry that might be unique to those groups,
Yes,
to that gang?
I am, yes.
And can you describe what sort of dress style or jewelry that may be specifically worn by members of that gang?
So oftentimes when a gang member is murdered or, deceased, they will, print out shirts with their face, or it's like a group picture, like they'll do shirts, they'll do lanyards, they'll do little wristbands, and then obviously the jewelry and pendants and stuff like that with a picture of them, on them, hanging from the jewelry.
Worn in memory of their deceased member, is that correct, or a friend?
That's correct.
And you said the certification for 6 Block as a gang, that was done prior to you, is that correct?
That's correct.
And that would be kept in a field incident report, which would document how that gang qualified for the criteria per the statute, is that correct?
That's correct.
And there is a field incident report for 6 Block in this particular case, is that correct?
That's correct.
And are there any tattoos that are common to 6 Block that you are aware of?
Yes, there are several tattoos.
And what are those?
There's anything from 8 ball, which is you referencing a deceased member. There's a 35, the number 35, which is referencing a deceased member. There's the name Bibby. There's a Kendra one. There's quite a few.
And we've talked about the drill rap videos and sometimes the timing of that. Is that why you monitor their social media?
Yes.
What other information do you get off social media? We've also saw photographs with gang signs, but can you tell us why it is so important to be monitoring this on a daily basis?
To monitor it on a daily basis, it assists me with, and I'm sure the other detectives as well, to keep up with the current trends. The new, they might start flashing a new hand sign and we've never seen it. Then we start investigating that, like why do they keep doing this or why do they keep doing that? So social media is a tool that we just utilize for, the criminal gangs in Jacksonville.
And we've already talked about the intel that you receive when there is a shooting where there is a member of a gang who has been shot, and the timing of viewing social media. Is there, when that is done, do you specifically, does that also kind of tip you off to start looking at social media when something, an event like that happens?
Yes, as soon as a violent crime happens involving a gang member, most of the time we're monitoring social media.
Even if the homicide occurs at 4 a.m. in the morning, is that correct?
That's correct.
And can the timing and posting of certain pictures be relevant when it is occurring immediately after a shooting, before law enforcement officers have even responded or identified a victim?
I think that's an accurate statement, given that, like, some people might not even know who the victim is, just as you described.
But somebody with your training and your experience, you would know where to look, what accounts, and what otherwise might not have significance. Is that correct?
That's correct.
All right, Your Honor, may I have one moment?
Yes.
Your Honor, we pass the witness.
Okay, Mr. Gonzalez?
Afternoon, Detective.
Good afternoon.
Detective, in talking about your training and experience, just briefly, I know you talked about having done a beginner's course for 16 hours and then the intermediate course for 40 hours, and that would have been in 2022, correct?
The 16-hour course would have been in 2022. There was the intermediate was 23, a year of 23, I believe.
Okay. And when you talked about a certification, correct me if I'm wrong, what you're talking about is a certificate of completion.
That's correct.
Okay, we're not talking about somebody as a result of you having that class certifying you as something.
That's correct. Yes.
Okay. And you talked about the evolution of gangs. And I think you told Ms. Doherty that you believe that the evolution of gangs is unique to Duval County?
Yes, I do.
Okay. And that's based on what?
Well, the reason I believe it's unique, you have your traditional gangs throughout this entire country, such as your Bloods, your Crips, your GDs, your Latin Kings, so forth. Here in Duval County, they adopt a lot of the same styles that we have seen, but they're more of like a neighborhood hybrid gang. Like you're not going to hear of 6 Block in, let's just say California, in my opinion, because it's not a national, it's more of a strictly neighborhood specific group in Duval County.
And essentially, I understand they're the Crips and the Bloods, and they have their nationwide appeal. But you're aware in Hillsborough County, there are hybrid gangs that are associated with neighborhoods all over the city, right?
You asked if I'm familiar with Hillsborough County gangs? And I don't know anything about Hillsborough County gangs.
Then how would you tell me it's unique to Duval?
It's unique in a sense that it's different than your traditional gangs, such as your Bloods and your Crips. I don't know how the gang activity works down here.
I understand. So what you're saying is it's not a Bloods, Crips, Latin King situation. It's a hybrid situation, and those are unique to each other.
Yes, usually in those traditional gangs, the national gangs, you have some type of hierarchy, structure, order. What we have seen, and again, I don't know, I can't speak for Hillsborough County. What we have seen in Duval County, there is no structure, per se, or hierarchy.
Understood. And what I must have misunderstood you. You don't mean it's unique to Duval. You're just because you don't know how gangs are structured in other communities, in other cities, in other counties, in other states.
Sure. And maybe I didn't explain that well, and I apologize.
No, that's okay.
We have the national gangs in Duval County. It's just the ones that we primarily investigate that with all the violent crime is usually stems from these neighborhood gangs.
And you talked about in listening to these rap videos and individuals' names being mentioned in them, whether it be their street names, whether it be their real names. There's a large cross-section of the community that would also know these people's names, correct? They don't have to be stated in this video in order for people to know that's their name or that's their street name. Agreed?
I guess it would depend on the audience who's reviewing it.
And it's a large audience that is reviewing it, sometimes millions and millions of people, correct?
I mean, that's fair to say, yeah.
Okay. And all of those people who see those videos being produced over and over again, they're going to get to know those names, and they're going to know those names. People on the street are going to know those names. They're going to tell other people who those names are, correct?
I can't speak for them, but I would assume.
The intelligence that you get is just that. It's intelligence, correct? Meaning, in talking to people on the street, in monitoring social media accounts, you would agree that a large percentage of it turns out to be hearsay in most circumstances. It's somebody saying something about somebody else, or somebody hearing something that somebody else did and telling somebody else, and that person telling you.
I mean, here, you're referring to like intelligence from the documentation and stuff, or I'm confused, I'm sorry.
Intelligence in whatever information you get in furtherance of the activities that you do on a daily basis.
No, I would disagree. As far as the documentation and intelligence that we gather and we document, like as Ms. Doherty was saying on the FRs, that is information that we have verified.
And maybe I misled you. I didn't mean as it relates to the documentation of a particular person as a gang member. I mean the information you gain in general as it relates to gang activity comes more often than not in a hearsay capacity. Somebody that you're not going to be able to write down a name, you don't know when it happened, you don't know who told who about it. It gets to you and you bank it.
I wouldn't say bank it, no. I mean, we oftentimes hear like very crazy, wild, outlandish stuff, on the internet when something happens, but no, like we don't bank it.
And the internet's alive when these things happen. I mean, it's plastered all over social media. It's getting millions of views. You are seeing it on different platforms, different people posting it, different people talking about it, and therefore what you are looking at is a particular person or a particular group talking about it. You would agree with me?
Whatever the individual or the actual investigation it is that I'm investigating, I'm trying to determine facts and, that can assist and, whatever the lead detective is on that specific investigation and kind of, like cipher through the stuff that's not relevant or that, just some random person on social media saying that they heard this or this.
Okay. And in talking about Bibby Gaynor's death, for example, are you aware that there are members of the gang unit that believe that Bibby's death was a crime of opportunity and not a crime of retaliation and not a crime of revenge? Have you heard that?
I have not heard that, no.
Okay. And when Bibby died, there was a significant volume of music produced about it, whether it be people dissing him or people praising him, correct?
That's correct.
And that went over a large social media space.
Yes, it is.
Not limited to simply ATK and 6 Block. It wasn't the social media coverage, the dissing, the praising, the memorials, the talking about, wasn't just limited to these two gangs, allegedly, correct?
I mean, as far as social media of the individuals that were involved, and yes, it was directed back towards ATK.
But not limited to.
No, I mean anyone can have can go on social media and say what they want. I don't know if I'm answering your question correctly.
Okay. I don't have anything further. Thank you.
Okay, Mr. Sonardi.
I do have one more thing. Detective, Have you ever been qualified by a judge as a gang expert?
I have never, I have had a state attorney back in Duval County list me as an expert witness, but I've never been qualified or by a judge saying that I'm an expert witness.
Yeah, never testified as such. You've testified a lot in a lot of different cases, a lot of investigation with what you did, with what you learned, but you would agree with me that a judge has never qualified you to a jury to say, this person who's talking is an expert in gangs.
That's correct.
Thank you.
You know we don't do that anymore, Mr. Gonzalez. We used to. Okay. Mr. Sonardi.
Yeah, very briefly, Judge, if I may, from here. Good afternoon, Detective. My name is Dick Sonardi. I represent Mr. Davion Murphy, sitting here to my left. Prior to June of 2024, did you ever have any contact directly with Davion Murphy?
No, I did not.
Was it after the homicide involving Mr. Jones that his name became aware to you?
Yes.
Did you have any involvement whatsoever in attempting to qualify Mr. Davion Murphy as a gang associate or a gang member?
No, I did not.
And as he sits here today, do you in fact know whether or not he is a gang member or a gang associate?
I do not know that.
Thank you. I have no further questions.
Okay. Mr. Wise, on behalf of Mr. Gathright and Mr. Chance.
Good afternoon, sir.
Good afternoon.
As to Sean Gathright, you didn't know him or even know of his name prior to the investigation that we've been discussing here today, correct?
That's correct.
And you've never documented him as a gang member?
I have not.
Or gang associate?
I have not.
Do you know anything about whether he would qualify as a gang member or associate?
I do not.
Okay. Isaiah Chance, you've never had any contact with him either, is that correct?
I have not.
Never documented him as a gang member or associate?
No.
Thank you, sir.
Okay, very good. Redirect?
Yes, just briefly. Detective, you have been listed by the state in cases where you have testified as an expert in gang activity in Jacksonville. Is that correct?
That's correct.
Approximately how many times in Duval County had you been listed as an expert witness?
I couldn't tell you. I don't know. There's been numerous, I would say.
That you know that you were listed?
That I was listed, yes.
And in those cases where you were listed, did you come to court and testify in this area of gang activity?
There were a few times, yes.
And specifically, I think that you were asked about Adrian Gaynor, Bibby, and all of the internet activity that came forward. Is that correct?
That's correct.
Was there an arrest actually made for the death, the murder of Adrian Gaynor, known as Bibby?
There was.
Who was arrested and what was his gang affiliation?
His name was Hakeem Robinson, went by Queso, and he was a member of ATK.
And has he recently pled guilty to that murder of killing the person who was a member of 6th Block, Adrian Bibby?
He did.
And he was a member, you said, of ATK?
Yes.
I have nothing further, Judge.
Okay, very good. May this witness be excused?
Yes.
Okay, very good. Thank you. Free to go.
Thank you.
All right, who's your final witness for this evening?
Christopher Drabeck, Your Honor.
Okay. Okay, Detective, you remain under oath. From your previous testimony, state you may proceed.
Detective, how are you employed?
Jacksonville Sheriff's Office
And how long have you been with the Jacksonville Sheriff's Office?
since May of 2017.
And again, I guess I didn't get you to state your name for the record. Can you do that for me?
Yes, ma'am. My name is Christopher Drabeck.
And how, you said that you've been with the Jacksonville Sheriff's Office since 2017, is that correct?
Correct.
And what unit are you currently assigned to?
I am assigned to the Gang Investigations Unit.
How long have you been with the Gang Investigations Unit at the Jacksonville Sheriff's Office?
Since May of 2024.
And what specific gang are you assigned to as a member of that unit?
21st Street, Rack Chase and Family, Yo-Yo Entertainment.
And none of those gangs are involved in this particular case, is that correct?
Correct.
But as a member of the gang unit, you would assist other agencies with any sort of information or intel that was necessary for a Jacksonville gang unit, is that correct?
Yes.
And as a member of that unit, although you're assigned to another gang, you do have familiarity with 6 Block, ATK, and 1200, is that correct?
Yes, ma'am.
And you share information with the detectives that are responsible and assigned to those particular gangs, is that correct?
Yes.
And based on the investigation that occurred in Tampa, were you assigned as a person responsible to assist Tampa Police Department with the investigation, the gang component involving 6 Block, ATK, and 1200?
Yes.
What are your duties as a gang unit detective, your daily duties and responsibilities? What do you do?
I'm required to monitor members, associates, persons of interest relative to the gangs and groups that I'm assigned. I also assist other major case investigative units with intelligence sharing as it pertains to their investigations and as that relates to the gangs and groups that I monitor.
And as part of your duties and responsibilities, do you ever respond to investigations or shootings involving your particular gangs?
Yes.
What about other gangs involved in Jacksonville, specifically ATK, 1200, or 6 Block?
Yes.
Is it how many members are in the gang unit?
I believe there's 12.
And do you work as a unit and assist each other with investigations, even if it may be a gang not particular to your specific assigned gang?
Yes.
What sort of training did you receive in order to be a gang unit detective?
There's no preliminary required training leading up to the assignment of the gang investigations unit. However, the sheriff's office does fund for us to attend conferences, more specifically the FGIA, which stands for the Florida Gang Investigators Association, which is an annual training seminar that puts on basic, intermediate, and expert level training as it relates to gang investigations in the state of Florida.
And which ones did you go to?
I've so far completed the beginner.
And as part of your duties, and you said you monitor daily activities of gang members, how do you do that? How do you go about conducting your monitoring?
Jail calls, jail tablet calls, social media, device downloads, interviews, field investigative reports, and other various investigations.
There were some gang charts that were put together for this specific case, gang charts involving ATK, 1200, and 6 Block. Are you familiar with those?
Yes, ma'am.
Did you and Detective Nieder put those together with assistance of the other gang detectives in your unit?
Yes.
And as part of your duties as a gang detective, do you familiarize yourselves with the various different nicknames that the members of the gangs go by?
Yes.
Are you also monitoring and taking a look at social media of various members of different gang groups?
Yes.
And what about drill rap videos?
Yes.
What is the significance of drill rap videos to the rival gang war between ATK and 1200 versus 6 Block?
Can you ask that again?
Yes. Is there, what role does the drill rap videos play in the gang war between allied groups ATK and 1200 against 6 Block?
We see it as an opportunity for the gangs and groups and the members that are within them to essentially disrespect the people that they're referencing in their music.
And with regards to the gangs in Jacksonville and general gang knowledge, do these different groups, do they have unique, whether it be tattoos or jewelry or style of dress, do the different various gangs in Jacksonville, do they have different modes of, different modes of dress that may be particular to a specific gang?
Yes.
And is that something that you learn as part of your training and experiencing, monitoring these different gangs in Jacksonville?
Yes.
And the same question as to tattoos. Are there tattoos that are specific to a particular group and subset of a gang?
There can be, yes.
And what about hand signs and hand signals?
Yes.
Your Honor, may I have one moment?
Yes.
Your Honor, at this time, we pass the witness.
Okay, Mr. Gonzalez?
Afternoon, Detective.
Good afternoon.
So quickly, you became a member of the gang squad in 2024, correct?
Yes.
And that would have been approximately a month before the Charles Jones murder.
Yes.
And you didn't have any specific involvement in that particular murder. You have your own things that you handle.
Correct.
And when you talk to us about the drill rap videos, these are rap videos that get millions and millions of views across the country, across the world, correct?
Yes, sir.
And they are songs that are produced, not always, but many times by artists that are signed to record labels that produce music in studios and sell their work commercially, correct?
Yep.
And those videos, I think you described them as being disrespect.
They can be.
For the most part, is a drill rap video, a video where one group or one person disrespects another group or another person.
They can be, yes.
And we have used, strike that. And as I understand it, unless something's happened in the meantime, you have not testified as an expert in any legal proceeding, correct? And let me
Was that a
rephrase
no?
it.
I'm thinking.
Oh.
Yeah, let me rephrase it. I know you have testified in your cases. I know you have testified in cases that are gang-related or that you were part of in some form or respect. What I would like to know is, have you ever testified as an expert?
Aside from this case, no.
Aside from the state listing you as an expert in this case?
Yes.
Thank you.
Thank you. Mr. Sonardi?
Detective Nick Sonardi, I represent Mr. Davion Murphy. You recognize him?
I do.
How do you recognize Mr. Murphy?
I've met him personally.
Was that during an interview?
Yes.
Prior to that interview, had you had any prior contact with Davion Murphy?
No.
And as I understand it, as Mr. Gonzalez has indicated, you actually became a member of the gang unit a month or so prior to the homicide of Mr. Jones, correct?
Correct.
And did you have any involvement whatsoever either with the prosecuting authorities in Jacksonville or the prosecuting authorities in Hillsborough County designating Davion Murphy as an associate of a gang out of Jacksonville?
I have not, no.
Do you have any direct knowledge that Davion Murphy is in fact a member of any gang out of Duval County?
Not independently from the groups I'm assigned, no.
Thank you. I have no further questions.
Thank you, Mr. Sonardi. All right, Mr. Wise, on behalf of Mr. Gathright, Mr. Chance.
Good afternoon, Detective.
Good afternoon.
I think we covered this earlier today, but Sean Gathright, you didn't know him until you began work in this investigation in connection with Tampa PD.
Correct.
How about Isaiah Chance? Is it the same situation for him?
No.
Okay, and you learned of him from searching the internet at some point, is that right?
Separate investigations pertaining to my other cases.
Okay, prior to your work on the case we're talking about here?
Yes.
Okay. Well, let me talk about Mr. Gathright first. You ever documented him as a member of a gang
No.
or an associate?
Nope.
Okay. Do you have any information to suggest he's a member of a gang?
Not from any of my investigations, no.
How about Isaiah Chance? Have you ever documented him as a gang
I have not documented him.
or a gang associate?
I have not documented him as a gang associate.
Do you have any information to suggest he's either one?
I would, yes.
What would that be?
It pertains to ongoing investigations that are major case.
So it sounds like something that's unrelated to this case?
It is.
It sounds like something you're not prepared to discuss?
Correct.
Okay. That's all I have.
Laura, can I ask one more question?
Sure.
Detective, what is your understanding, if you have one, about what you'll be testifying to in this trial as an expert?
I would suggest it's predominantly, as it relates to an expert, my groups and gangs aren't involved in this investigation. So in my opinion, I believe the best way to describe it, my role in this investigation was facilitating investigative portions that occurred in Jacksonville and assisting Detective Ramos with various things.
Would it require expert testimony to discuss what you did in assistance to Detective Ramos?
I don't know.
Answer is no.
Just asking.
I know, I'm just cutting to the chase. The answer is no. He's a fact witness. Okay, redirect.
Just briefly, Your Honor. Detective, I know the defense counsel asked you if you personally documented Isaiah Chance as a gang member, is that correct?
Yes,
That's not part of your responsibility because you are assigned to another gang, is that correct?
that's true.
And so there may be gang documentation, but that would have been done by somebody else in your unit, is that correct?
That's true.
And as far as the documentation for Davey and Murphy, any documentation that existed prior to you becoming a gang detective, you would not have done that documentation, obviously, is that correct?
Correct.
And since you are not assigned to that particular gang to 1200, you would not be aware of that documentation, is that correct?
Correct.
That doesn't mean that that doesn't exist, is that correct?
Yes, ma'am.
Or that neither one of those are not gang members?
Correct.
I have nothing further, Judge.
Okay. May this witness be excused?
Yes.
Okay, you are free to go.
Thank you.
Okay, that's it for the witnesses today, correct?
Yes, Your Honor.
Okay. All right, so we're going to reconvene Tuesday. I'd like to start at 9 a.m., okay? Again, I asked you all to meet tomorrow since we don't have court, at least penalty phase counsel, to go over all of the penalty phase motions to see if there's any agreement as to any of them. Also, then, when we reconvene on Tuesday, I would like to, I know that we have penalty phase scheduled that day, but I would like to hear argument on the motions to suppress first, just because I've reviewed all the case law, and I would prefer to hear those arguments when the case law is fresh in my mind, so I'd like to start off with that. And then the later morning or afternoon will be devoted to penalty phase motions. So, okay? Also, we discussed the Richardson-Hayes cases out of Jacksonville, and I did note that those cases were tried together but before two separate juries. Do either of you know why there were two separate juries? Did they have a Bruton problem?
Judge, I want to go back and look, but I do believe there was reference to statements, and I don't want to make a representation that it was specifically Bruton without further taking a look at it. But I did notice there was mention of statements.
Okay, so I did review the cases, and it wasn't clear to me why there were two separate juries. So if you all could find out definitively, that would be helpful.
And by the way, Judge, I did misspeak yesterday because I believe I said they were severed, and I didn't mean to say they were severed.
Right.
They were tried with the two juries. I did try to look at some of the pleadings, and I'll get with Ms. Doherty, maybe we can collaborate on that and give the...
Yeah, I'm just curious why there were two separate...
You can also call the prosecutor on the case.
Yeah, that'd be good. I just would like to know, because the reported opinions are not clear as to why there were, from my reading, as far as why there were two separate juries. Okay, thank you all. We'll
Judge,
see.
I also want to tell the court for the record, Mr. Hernandez apparently will not be available tomorrow, so I suspect he will get with the state on Monday with regard to
Yes.
full penalty phase motions.
Yes, he needs to meet, confer before Tuesday. Okay, very good. Thank you all.
Judge, if I may, there were two Ks, so we decided, I discussed it with the state, to make the second 2K that was identified by Mr. Grega. No. But one of
Right.
2K1 and 2K2.
That's fine.
2L, excuse me.
No, she's going to make a tail, Judge.
That's fine. And did you give the clerk your Defense Exhibit 1, the zip drive or the flash drive?
Yes.
Okay, all right. Okay, is that it?
Yes, Your Honor.
Okay, very good. See you all Tuesday morning, 9 a.m.
All right, and that is that. So with that, we will wrap up our pretrial coverage for today. This being our pretrial prep 2. So we're going to do Monday and Tuesday. So we'll have 2 more because we definitely have enough. We have a lot more pretrial hearings to hear and to go through. And when we are done with those, I think we're going to have time to cover Alicia Andrews' testimony. So I think we're going to be able to get Alicia Andrews in there too. So really appreciate you guys spending your day with us. I hope that the names are starting to become familiar to you. I know there's a lot of moving parts, a lot of players involved with this upcoming trial. And I think just the more that you're with us, the more you hear people's names, it will help. Once we go to trial. Definitely encourage you, if you are interested, to look at our playlist. I will go ahead and I'll just drop that here real quick. If you're looking to find out more, we did a history of the history between ATK and KTA a couple days ago, and then yesterday we focused on just Charles Jones and his history. So if you're interested in that and really getting really caught up on everything, I would say check that out as well. So with that, I would say thank you to our mods. Thank you to Aaron. Appreciate chat being courteous and respectful of each other. I know we have difference of opinions, and we do ask that you keep it, respect everybody in the court. Don't post any disparaging remarks against them, because you never know who's watching. You never know who's watching and who's going to be in chat with us and who's going to be watching. And that's just the way we do it here. We respect your opinion, and we just ask that you respect our ask that you don't pick on somebody in court based on the way they look or how they talk, that kind of stuff. So you can express your opinion, just keep it respectful. All right, with that, I don't have Super Bowl. Oh, Super Bowl's out there, so I don't have Super Bowl to show you. So anyway, guys, have a great weekend. We will see you Monday, 9 a.m. Eastern for day 3 of our pretrial prep. So have a great one. Take care of yourselves. Do something, positive for yourself. Go look up at the stars. Go walk on the beach. Go walk in the grass. Or if you don't have that to you, go watch something that gets you away from this. Play some music. Put some music on. Music always helps. Dance. Go and dance. I know some of you will be doing that. I'm going to go play some guitar. All right, guys. Have a great one. See ya. Bye.